I sent you to life in confinement without parole.
That's f***ing horse shit. You do whatever the f*** you want.
Why are they shutting my mic off?
On the fence.
You got to create the community that you want to live in.
I have created a Patreon page for those of you who want to support my channel. All patrons will receive access to the new private Bond Court Discord server. All video content will remain on my YouTube channel for free. Supporting me on Patreon is not required, but it is greatly appreciated. Thank you to everyone for watching my channel, liking my videos, and leaving comments. Bond Court is now in session.
Good morning, this is Dalia Romero, Spanish interpreter on the line, already sworn in today.
Good morning. Defendant is approaching the podium now.
Thank you, Your Honor.
I'm sorry, we don't know who this is. Who's Spanish?
It's Eduardo Pastrana Pacheco.
Is that felony DV?
Felony.
Thank you.
2020 CF 304AO. All right, defendant is wearing a headset.
He can hear the interpreter, Your Honor. Good morning.
Good morning. And your name, sir?
Eduardo Pastrana.
Eduardo Pastrano.
All right, sir, you're here today because you're arrested on a warrant for violation of probation on your grand theft, third-degree grand theft motor vehicle charges. There is no bond on that. I will appoint a public defender to represent you on the violation. Oh, you already have a private attorney. Like that. Someone's already entered a notice of appearance, so you do have an attorney already. Okay?
Thank you very much.
Thank you. And again, that was 2020 CF 304AO. And I think that's it for the Spanish cases, right? That's it. Thank you, ma'am. Have a good day.
Thank you, Your Honor. You too. Thank you.
Bye-bye. Your name, sir?
Ralph Atkins.
I'm Mr. Atkins. Hold on. Here today because you were arrested on a charge of petty theft. You reset him. Oh, this guy was in the hospital and got reset for. I have reviewed the charging affidavit. I do find that there's sufficient probable cause. Bond set in the amount of $500. I'll appoint a public defender to represent you. This one end up.
Your Honor, I ask that there be no return.
Yeah, okay. Yeah. Okay. You're here today, Mr. Atkins, because you were arrested on a charge of petty theft. I have reviewed the charging affidavit, and I do find that there's sufficient probable cause. I'll set bond the amount of $500, and we'll appoint a public defender to represent you. Okay? Thank you.
Any action on his out on bond?
Yeah. What's that?
Any action on the out on bond?
Oh, I don't have that.
Yep. I mean, this is all a reset. It's 2022 CF 4454 AO, a petty theft, 2 prior conviction.
When did that occur?
He was arrested May 24th.
And then this one's on May 28th.
I don't have that.
Yes, he was arrested May 20th.
Yeah. Yeah. Yeah.
Oh, I apologize. He was originally arrested April 3rd and then rearrested May 24th. I apologize.
But this one does, for sure does pre-exist. Yeah, okay.
He doesn't have an attorney on that one either, Your Honor. I don't know why.
Okay, so the bondsman already came off. Endorsed that bond. So he's not being held. Or he already is being held on that. Do you have that?
Yes.
So I'll take no action on that then. All right, I'll appoint a public defender to represent you, sir.
And I will waive the appearance, Your Honor.
All right. I think we reset him today to maybe do a plea. Is this
Yes,
one?
Your Honor.
All right. I'm going to roll it till tomorrow and see.
Yes, Your Honor.
All right. We'll try one more time. And if not, tomorrow, then I'll just go ahead and we'll move on. It's a possible plea, so we'll just roll it for 24. It's mental health today, but we'll see if we can get him in to plea him tomorrow. But I won't roll it till Saturday because people will be talking about me like I'm talking about other. You know, it's okay for me to talk, but I don't want to be talked about. All right, your name, sir?
Marco Harris.
Mr. Harris, you're here today because you were arrested based on a probable cause warrant for a number of charges. First of all, attempted second-degree murder, aggravated assault with a firearm, domestic violence, shooting at, within, or into a building, possession of firearm in commission of a felony, and battery domestic violence. Now, do you, okay, so it didn't happen at a place. What's her name? So Miss Smith, Keisha Smith, you don't live with her?
No, sir.
You have an address that's separate from her?
Yes, sir.
All right, and you have no reason to have any contact with her, is that right?
Yes, sir.
Okay. All right, as to the attempted second-degree murder, there is no bond on that.
Your Honor, I believe he's entitled to a bond.
State, want to be heard? As to amount.
I would ask for at least 50,000, Your Honor.
All right, I'll set that at $50,000. Aggravated assault with a firearm, I'll set that at $5,000. Shooting at or within, $1,000. Possession of firearm by convicted felon, $1,000. And battery domestic violence, $500. Appoint a public defender to represent you. If you do bond out, you're not to have any contact with Makisha Smith. No contact whatsoever, or any contact with the other witnesses in the case. It happened at a Waffle House, so. All right, thank you, sir.
Your Honor, can we also do the no firearms, no weapon?
Yeah, that's right. No guns, no weapons, no alcohol, no drugs. Okay, no guns, no weapons, no alcohol, no drugs. Yes, sir. Thank you. All righty. Out of practice on my fourth day. Billy Jerome? Mr. Jerome, case. I did have a question about this one. They charge it as aggravated battery, and it looks like it's bites.
Yes, because the bite, and he bit hard enough to break the skin.
There's teeth, deadly weapons, or is that likely to cause
The scarring.
bodily harm?
The bodily harm.
No, it's here.
All right, I'll set bond an amount of $1,000 on that. No, Yeah, and I'll point a public defender, you're gonna waive his appearance.
Yes, Your Honor.
All right, and then we'll, no contact with Barry Zephyr, Zephir. And, no contact with Marie Jerome, who's the witness in the case. And no return to 6601 Sea Harbor Drive. One time he can go with law enforcement. And again, appoint public defender to represent him. No guns, no weapons, no drugs, no alcohol. Unfortunately, I can't tell him that he can't have his teeth because that's his weapon. But you know, I don't know how many teeth he has. He may not have a lot. All right, your name, sir?
Jose Solano?
Verano. I have Jose Antonio Solano Soto.
Sure.
All right. So I have it run all together into one. All right, sir, you're here today because you've been charged with, you're arrested on charge of aggravated assault with deadly weapon, domestic violence. I have read the charging affidavit, and I do find that there is sufficient probable cause. Anyone here? No. Do you have another place to go other than 17883 East Colonial Drive?
Yes, sir.
Where's that?
669,
Whose place?
Shenango Lane.
Whose place is that?
That's, my boss.
Okay, all right. And you don't have any reason to have any contact with your wife, is that right?
Yeah.
Okay. Well, I'll set bond amount $1,000. No return to 17883 East Colonial Drive, number 20. You can't go back there except one time. You get someone from the law enforcement to go with you. You can pick up your personal items, your clothes, or anything that you need, just personal stuff, but no contact at all with your wife, which is Useli, Yusely,
Yes, sir.
Solano, and no guns, no drugs, no weapons, no alcohol.
Yes, sir.
And I will appoint a public defender. Your name, ma'am?
Maria B. Ventura.
All right. You're here today because you're arrested on a charge of aggravated battery with a deadly weapon, domestic violence. I have read the charging affidavit, and I do find that there is sufficient probable cause. Do you have anywhere else to go other than I assume you were living at 10228 Trillium's Court?
That is correct. I own that home.
Do you have anywhere else to go other than that right now?
No, not right now.
All right. Because I assume that Jose is still there.
Yes, he's still there.
You're gonna have to go somewhere else. He's not here to say that he wants contact with you, so I'm gonna have to order that you have no contact and that you not return to that address, so you're gonna have to figure that out. All right?
I mean, I don't have the address, but I know someone I could.
Friend or a relative or
Yes,
something.
she's a
All right.
friend.
Okay, I will set bond amount of $1,000 and order that you not return to 10228 Trillium's Court. You can go there one time with law enforcement to pick up any personal items, anything that you need, okay? But you have to go with law enforcement. And you're not to have any contact with Jose, your husband, Jose Ventura, and that means no phone, no text, nothing, no contact at all, okay? Don't possess any guns or weapons, and don't use or possess any drugs or alcohol. And I'll appoint a public defender to represent you. Brian Blanton. You are Brian Blanton? Sir. All right, Mr. Blanton, you're here today because you're arrested on a charge of battery, domestic violence. I have reviewed the charging affidavit, and I do find that there is sufficient probable cause. And were you living at the, oh no, this is not a home address. Were you living with Stacy Edwards?
No.
No, okay. And this happened, I guess, allegedly at was that outside of a party or something, right? Okay. So you have no reason to have any contact with her then?
Excuse me, sir?
You don't have any reason to have any contact with her?
No.
All right, where do you live?
Then I live with my old girl.
All right, and she's not there and won't be there, Stacy?
No.
Okay. All right, I'll set bond in the amount of $500. Order that you not have any contact with Stacy Edwards. No contact whatsoever. Not to possess any guns or weapons, no drugs do not possess or use any drugs or alcohol. And I will appoint a public defender to represent you. Ms. Garcia's case, I have reviewed the charging affidavit. I do find sufficient probable cause.
There's a victim, Your Honor.
Oh, is there?
The next defendant.
Oh, okay, okay.
I will set bond in the amount of $500. She's not to return to 2917 Antique Oaks Circle, number 24. She's not to have any contact with John Stanfield, Stanfield. No contact whatsoever. Not to possess any or use any drugs or alcohol, or not to possess any guns or weapons. And I'll appoint a public defender. Your name, sir?
Michael Jean Baptiste.
Jean Baptiste, you're here today because you're arrested on a charge of domestic violence battery. I have reviewed the charging affidavit. I do find that there's sufficient probable cause. All right, ma'am, raise your right hand, please. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Your name?
Shania Celine.
All right, and you're the alleged victim in this case, is that right?
Yes.
All right, what did you want to tell me? Do you want to have contact with Mr. Jean-Pierre, or no?
Yes, I would.
I'm Baptiste, excuse me. You do?
Yes.
You have no fear of him?
No, not at all.
So if he comes home, you don't think that he's going to do this again?
Never.
Okay. So what I can do is I'll order that he not have hostile contact with you. All right, so he can come home. I'll give him a bond and let him come home and stay with you. Do you guys live together?
We don't.
Okay, all right, well, that's even better. So you don't live, where do you live?
I live in 1050 Pine Street.
Okay, and you have your own place?
I stay with my uncle, sir.
What's that?
Stay with my uncle, sir.
Okay, all right, so you have your own place separate from her?
Yes, sir.
That's actually better. Okay, I will set bond in the amount of $500. I will allow you to have contact, but it cannot be hostile contact with her, okay? So that means you can't raise your voice, can't send her a mean text, can't throw something against the wall when she's in the room with you. You can't show any anger to her, you understand that?
Yes, sir.
Okay. And then since you have separate residence, you have to maintain separate residence. So although you are separate now, you can't move in together. I'd rather you not do that. No guns, no weapons, don't use or possess any drugs or alcohol, and I'll appoint a public defender to represent you.
Thank you.
Okay? All right, ma'am, you understand what no hostile contact means. If he is hostile to you in any way, you can make a phone call, and he's back here. Okay?
Yes.
All right. Good
Your Honor,
luck.
I'm sorry. I was just making sure. I didn't know if he could afford the bond. Since he qualifies, could he be released on free trial?
Yeah, would you rather have that? Want PTR?
Yes.
All right, so I'll release you with PTR conditions. Slipped my mind, I had it right there. Your name, sir? Mr. Longo, you're here today because you're arrested on charge of domestic violence battery. I have reviewed the charging affidavit, and I do find that there's sufficient probable cause. Now, were you living at 16478 Angel Fish Road?
Yes.
And does Kimberly live there as well? All right. Do you have another place to go other than that right now?
No.
All right, you're going to have to find a place because I'm not going to allow you to go back there if with her being there.
Okay.
Okay? Now, that could change if she speaks to the prosecutors and the domestic violence judge decides to modify that. My order today will be that you not return there, okay? All right, I'll set bond amount of $500. No return to 16478 Angelfish Road. Now, you can go back there one time to pick up any clothes or personal items you need, but you have to call either the sheriff or the police, whatever jurisdiction is there, to come with you. In other words, they'll send someone out. They'll be there. That's for your protection as well as hers. That way, nothing happens, right? You pick up your stuff, and then that's it. No reason to go back after that, okay? Not to possess any guns or weapons. You're not to use or possess any alcohol or drugs, okay? And again, no contact at all with Kimberly Longo. That means you can't send her a text, can't leave a message on her phone, nothing like that, okay? All right, and I'll appoint a public defender to represent you. Oh, you want PTR?
Yes, Your Honor.
All right, I'll release your PTR. So the pretrial release conditions, you will have to keep in contact. There's some things you have to do, but there won't be a bond required. Your name, ma'am?
Crystal Nieves.
All right, Ms. Nieves, you're here today because you're arrested on charge of battery, domestic violence. I have reviewed the charging affidavit, and I do find that there's sufficient probable cause. Raise your right hand, please, sir. You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, your name?
Israel Ortiz.
All right, and you are the alleged victim in this case? Is that right?
Right.
Okay. And tell me what you want to tell me. Are you in fear of her, or do you want to have contact with her, or you want to have no contact with her?
I am not in fear of her. I would like to have contact with her.
Okay. Were you guys living together at that Curry Ford Road address?
Right.
All right, so you would have no problem with her coming back home?
No problem with that.
All right, I understand if I do that, I will say no hostile contact. That means she can't raise her voice, she can't speak to you in a mean way, she can't throw some stuff around, she can't be hostile to you in any way. You understand that?
Yes.
Would that be okay?
That's fine.
All right, so Ms. Nieves, you understand that?
Yes.
I will allow you to go back home and be with Mr. Ortiz, but you can't be hostile in any way. And that includes sending him a text. If he's not home at 5 o'clock, say, "Where are you?" and you start cursing at him. That's hostile. No hostile contact whatsoever, okay?
Mm-hmm.
All right, she's not eligible for PTR?
One moment, yeah.
All right, I will set bond amount of $500. I'll allow you to return back to your home, and you can have contact, but no hostile contact with Mr. Ortiz. You're not to possess any drugs or alcohol, and not use any drugs or alcohol, obviously, and no guns or weapons, okay? And I'll appoint a public defender to represent you. Good luck. Thank you, sir. Your name, sir?
Norberto Pilat.
All right, Mr. Palat, you're here today because you're arrested on a charge of battery, domestic violence. I have reviewed the charging affidavit, and I do find that there is sufficient probable cause for the charge. Were you living at the 4215 South Cimarron Boulevard address?
Yes.
And does Francesca live there?
No, Your Honor.
She does not. Okay. Okay. Oh, I remember this one. Yeah, she was coming there to bother you, and then you walked out and allegedly got yourself arrested. Yeah. Okay. All right. So there'd be no. Obviously, you didn't want to have contact with her, I assume. So what I'll do is I'll set bond. You are eligible for pretrial release. I can either set a bond of $500, which you'd have to post, or I can release you with pretrial release conditions. So there are conditions, but you don't have to post a bond. Which one would you prefer?
Would I be able to hear the conditions first?
What's that?
Can I hear the conditions?
Well, you have to call into them. They may drug test you, but you have to call in every once in a while. That's required.
You would like pretrial release.
All right, I'll release you with pretrial release conditions. You can go back to your own address. You'll have no contact with Francesca, and that's Francheska, Mejias, Meijias, or excuse me, Mejias. Now I know that the hard part of that means she may try to make contact with you, right? Do not engage. If she comes, and I think they trespassed her off that apartment complex. If she comes, you can call the police and they'll let them deal with it, okay? I'll appoint a public defender to represent you. You're not supposed to, you're not to possess any drugs or alcohol or use any drugs or alcohol, and do not possess any guns or weapons. Okay? All right, good luck. Your name, sir?
John Joe Pugh.
All right, Mr. Pugh, you're here today because you're arrested on a charge of battery domestic violence. I have reviewed the charging affidavit, and I do find that there's sufficient probable cause. Good morning, ma'am. Raise your right hand, please. You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God.
Yes, sir.
And your name is?
Andrea Pugh.
And you are the alleged victim in the case, is that right?
Yes, sir.
And you are Mr. Pugh's daughter, is that correct?
Sir.
Okay. Are you here to tell me that you don't want to have contact with him, or that you want him to be able to come home? Okay, all right. And what I can do is, if I let him come home, I'll order that he not have any hostile contact with you, okay? So nothing of this kind of stuff. He can't raise his voice to you, can't in any way be hostile. Would that be all right?
Yes, sir.
Okay,
Yes,
all right.
sir.
All right, Mr. Pugh, you do qualify for pretrial release, which would mean you could be released without a bond. Now, you will have to phone in and keep in contact with your pretrial release officer. Do you want to do that, or do you want me to just put a $500 bond on it?
I'm Social Security. I'm physical.
If you do PTR, it doesn't cost you anything to get released.
Yeah.
All right. I think you. All right. I'll release with PTR conditions. I'm going to allow you to go home. You just have to have. You're not to have any hostile contact with Miss Pugh, with your daughter. Okay. No hostile contact. You can't raise your voice, even if there's something you think she's doing wrong. You got to let it go. Okay. No hostile contact. Don't slam in doors. No yelling. No throwing stuff. Okay. All right. No. You're not to use or possess any drugs or alcohol. And you're not to possess any guns or weapons. Okay. And I will appoint a public defender to represent you. All right. Thank you, ma'am.
Thank you.
Your name, sir?
Justin Rodriguez.
All right, Mr. Rodriguez, you're here today because you're arrested on a charge of domestic violence battery. I have reviewed the charging affidavit, and I do find that there is sufficient probable cause. Now, are you living at the Eastmar Commons address?
Yes, sir.
And let's see, is Ariel? She lives there as well.
Yeah.
All right. Do you have another place to go on the short term?
Yeah, I can go to my brother's or my mom.
Okay, perfect. It's because she's not here. What I'll have to order that you not return there. All right. Now you do qualify for pretrial release, so we can either set you a $500 bond, or I can release you on pretrial conditions, which there are some conditions to it, but you don't have to post a bond.
No, I'll pay the bond.
All right. You just want to do $500 bond? I'll pose a $500 bond. No return to 10239 Eastmar Commons Boulevard, number 2035. So you can't go back to that apartment other than one time. You can go back with the law enforcement escorts. You either call the sheriff or the police, and they'll go with you. You can get your clothes or anything that you need, personal items. You can't take televisions or furniture, but you can take whatever you need with you that one time. You're not to have any contact with Ariel Minthy, and that's Ariel Minthy, two different names. Ong is the last name, O-N-G. And if DCF is involved, because I know that there are children, you need to follow the agreement or whatever plan is put in place by DCF as a condition, okay? No drugs, no alcohol, and not to be used or possessed, no weapons or guns to be possessed, okay? Now, on your affidavit of insolvency, you put that you make $70,000 a year. Is that correct?
Yeah.
Okay, you do not qualify for a public defender, so I can't appoint one for you. So you'll have to hire an attorney on that, okay? All righty. Thank you, sir.
Thank you for your time.
Janessa Camacho. All right, that's out of county.
She bonded, yeah.
You did? Oh, yeah, because there were, oh, wow, 25,000. All right, so she's bonded. And Engelbert Cuevas. Good morning. Mr. Cuevas, you're here today for some warrants, or a warrant out of Dade County on an aggravated battery charge, and the bond on that is $15,000. That's Volusia, or is it? It says Dade on here. Oh, we're holding for Dade. Yeah, the warrant is out of Volusia County for aggravated battery is $15,000, and it looks like you also have a hold for Dade County as well. So if you don't bond out on the Volusia, we'll notice Volusia, and then I guess it'll be a race to the jail to see whether Dade County gets you or Volusia gets you.
Okay.
Okay.
Thank you, Your Honor.
Mm-hmm. Good luck. Just see the two vans from Dade County and Volusia trying to get here first because they really want to. Your name, ma'am?
Elizabeth Carlton.
All right, Ms. Carlton, you're here today because you're arrested on a charge of resisting an officer without violence. I have read the charging affidavit, and I do that I find there's sufficient probable cause. Bond set in the amount of $500. And does she have VOP, or we don't have that today?
She has a VOP.
Has that already been dealt with?
No, she should be subpoenaed on that today.
Oh, there it is. Skipped it. That's on the one thing, and I'll appoint a public defender on that. And then you also hear on a violation of your probation for the burglary of conveyance charge that you had, and there is no bond on that. And I'll appoint a public defender on the violation as well. So you got a public defender on both of those. Okay, thank you. Rodney Polite. All right. All right, you are Mr. Polite?
Yes, sir.
Okay, Mr. Polite, you're here today because you were arrested on a charge for violating your probation, and that would be the probation that you're placed on for the possession with intent and the possession of cannabis. And there is no bond on that. I will appoint a public defender to represent you. I'm gonna try. Is it Torquanzia? Is that right?
It's Torquanzia.
Torquanzia.
That was good.
And last name Speed.
Yes, sir.
So, and is it Quinet's?
Cune.
Oh, see, that was fancy, and I didn't go fancy. I would have got it. Okay. All right, Ms. Speed, you're here today because you're picked up on a violation of probation warrant, and that is from your grand theft charge.
Yes.
And there is no bond on that. I will appoint a public defender to represent you. Okay. 19 cases. I can get behind that. Oh, okay. All right, 33-day motions. First one is 2022 CF 4891AO, Jesse Carnley.
Granted, notice of non-filing.
'22 CF 4822AO, Michael Thomas.
Granted, notice of non-filing.
'22 MM 2895AO.
Denied, information was filed.
2022 CF 4912 AO.
Denied, information was filed.
Twenty CF 4898 AO, Brian Jackson.
Granted, notice of non-filing.
2022 CF 4881 AO.
Granted, notice of non-filing.
2022 CF 4945 AO.
And information has not been filed at this date. Can I just confirm that the date on the order is June 4th?
It can be. Yes, it does say 6-4.
Thank you, Your Honor. And information hasn't been filed at this time.
So I'm gonna roll it off, or what do you guys usually do on that? Because it's not granted, because it's not 6-4 yet, right?
Your Honor, just an issue we've been having. So per the statute, we're allowed to file our 33-day motions on the 30th day, which is why we changed the language that says to be granted if an information is not filed on that day. So
But what happens is, I mean, is that gonna, is classification's gonna look in Odyssey to see if an information's filed on 6-4? I mean, what's gonna trigger that?
That I don't know. That's
If I sign it today, what's the likelihood on 6-4 that someone's gonna look at it downstairs and go, oh yeah, there's not an information, and then it's gonna go?
I think that's the issue we've been dealing with.
Yeah, and I guess the other question is, it's the weekend. The weekend judges don't do they? I mean, do you guys, I don't remember doing them.
No.
They must. They don't?
No, they don't.
No, they don't. Okay.
I guess, can we just roll it till tomorrow? I don't know.
I'm fine with that. I'm here tomorrow.
Okay.
To see if there's anything, if not.
All right, we'll just hold on to that one until tomorrow. I already signed it. Okay. 2022 CF 2511 AO, Jarquavius Mack.
Granted, case was no billed.
Your Honor, I have one other issue.
Okay.
The Nikita Gibson from yesterday,
Yes.
I had the wrong case number, so I redid the order with the correct case numbers.
All right, the same thing, it's just the case numbers that are
Yes, Your
supposed to
Honor.
be applied to? Okay.
Yes. May I approach?
You weren't here, but did you tell her what happened?
No, not yet.
Yeah, it's,
I'm pretty sure.
I think Ms. Gibson, we first called on Tuesday, right, is that right? Tuesday or Wednesday? What's day? Yeah, it went Tuesday, because yesterday was Wednesday, that's when we dealt with it.
So all I'm doing is change, because I put the wrong case numbers here. I had all
Okay.
2022.
Okay.
So it's the same order to take these off.
Okay.
Fixing the case numbers.
Okay.
That sucks, baby.
I was rushing yesterday, I put the wrong number.
All righty.
The state has nothing further. May I be excused?
Yes, you may. What time do we want to? There were so few this morning, I got through about, not quite half of the afternoons as well, so. Come back at,
Can we come back at 11? Is that enough time for corrections?
All right, good afternoon, everyone. We are on the docket for first appearances. I'm Judge Tom Young, Circuit Judge of the Ninth Circuits, and I sit here in Osceola County. Can I have appearance for the state, please?
Cynthia Carrasco for the state.
And for defense?
It's Alexander Rosa.
Rosa, you said?
That's right.
All right, thank you, Mr. Rosa. And who for pretrial release?
Patricia Jenkins for pretrial release.
All right, good afternoon, Officer Jenkins.
Good afternoon, sir.
All right, I'm told that the first individual on the docket, Matthew Torres, 2022 CF 1588, requires the assistance of a sign language interpreter. Mr. Rosa, do you know if Mr. Torres is able to read lips?
He cannot, I think he can read English, you said?
No, lips, I was asking.
He can't read lips, but he can write.
He can read and understand English?
I think so. That's what I've been told.
All right. We can't, he does have a bond. And the bond is $5,000 on count 1 and $500 each on counts 2 and 3 for a total of $6,000. The arrest affidavit has him arrested as burglary of an occupied dwelling, criminal mischief of greater than $200 and less than $1,000, and trespass to an occupied structure or conveyance. I'll be glad to reset this for tomorrow if he doesn't post bond. That should give folks an opportunity to obtain sign language
Sure, Judge.
interpreter.
Let's reset it for tomorrow and try and get an interpreter.
Yeah, but if you want to show him the bond amounts, that would at least do as much as we're able to do today.
So are we finding PC?
Well, I'm intending to reset it without a finding.
Oh.
And I would take any arguments and address the merits tomorrow. But at least he can be advised of the bond amount.
We're advising him now, Judge.
Okay, thank you. That's the best we're able to do under the circumstances there. All right. So let me get the Spanish interpreter for our next cases.
Hello, Cisco Unity connection message.
Good afternoon, Your Honor. This is Laura Bretaña, Spanish interpreter, previously sworn.
Good afternoon. I am calling for assistance with first appearances at the Osceola County Jail. I need to make some general announcements, and I would like your assistance with those first. Are you able to hear me, Madam Interpreter?
Yes, Your Honor.
Excellent. All right. Folks at the jail, we are here today for first appearances.
A las personas que se encuentran en la cárcel, nos encontramos aquí para la vista de primera instancia.
We will not be discussing the specific facts or merits of your cases.
No atenderemos los hechos particulares ni los méritos de sus casos.
What we will be discussing is whether there is probable cause for the arrest.
Lo que discutiremos es si existen indicios de criminalidad para su arresto.
And if there is probable cause, whether you should have a bond, and if so, the amount and conditions of bond.
Y si existiesen indicios de criminalidad, entonces atenderemos el hecho de si se les concede fianza, de ser así, la cantidad de la misma y las condiciones de su puesta en libertad.
Unless you are represented by a private attorney, I will provisionally appoint the Office of the Public Defender to represent you for today's purposes.
A menos de que ya ustedes tengan representación legal privada, se designará el abogado de oficio provisionalmente para que les represente durante la audiencia del día de hoy.
If you wish to have court-appointed counsel, I will need for you to complete the required financial affidavit.
Si ustedes deseen que el abogado de oficio permanezca representándoles, tendrán que completar el affidavit necesario para designarle el mismo.
If you qualify for court-appointed counsel, after completing that affidavit, the court will unconditionally appoint counsel at that time.
Y si luego de completar el affidavit se determina que cumplen con los requisitos para que se le designe el abogado de oficio, entonces el mismo les será designado por el resto del caso.
All right, thank you. And our first case, Madam Clerk, will be Karen Maldonado Rodriguez, 2022 CF 1586.
Karen Maldonado Rodríguez, 22 CF 1586.
All right, good afternoon, ma'am.
Buenas tardes, señora. Good afternoon.
Ma'am, you were arrested for the charge of aggravated battery causing great bodily harm or disability.
Señora, usted fue puesta bajo arresto ante la acusación de agresión física agravada causando grave daño corporal o incapacidad.
All right, Mr. Rosa, do you have any argument to present on this case?
Licenciado Rosa, ¿tiene algún argumento que presentar en este caso?
Yes, Judge. The injuries in question here are there wasn't an actual injury caused that caused great bodily harm or disability, so I'd argue there was no probable cause.
Sí, su señoría, yo quiero argumentar que no existen indicios de criminalidad, ya que las lesiones recibidas no hubieron lesiones que causaran grave daño corporal o incapacidad.
Ms. Carrasco, does the state wish to respond?
Licenciada, ¿la Fiscalía desea responder?
Your Honor, state rejects the argument. State would argue that the injuries that were observed at the police officer in this incident are bodily harm. If we go to where the officer mentioned, I'm sorry, Your Honor, I'm trying to look for the exact.
Doesn't it have to be great bodily harm as opposed to bodily harm?
Su señoría, la Fiscalía argumentará que en este caso las lesiones, según fueron observadas por el agente de la policía, causaron daño corporal. Permítame, por favor, llegar a la parte donde se menciona. Él le preguntó a la fiscal, ¿no tiene que ser grave daño corporal?
No, Your Honor, in that case, the state would ask for a reset.
No, su señoría, en ese caso, la Fiscalía solicita que se aplace la audiencia.
I'm not going to reset. There is probable cause for a battery arrest. I don't believe there is probable cause for aggravated battery.
No la voy a aplazar. Yo considero que existen indicios de criminalidad para un arresto por agresión física, pero no creo que existan indicios de criminalidad para un arresto por agresión física agravada.
These are wouldn't call them unusual, but these are a special set of circumstances, let's say.
Bueno, yo no les llamaría a estas circunstancias inusuales, pero sí que son particulares.
So, Ms. Maldonado Rodriguez is entitled or qualified for pretrial release with a bond.
La señora Maldonado Rodríguez cumple con los requisitos para libertad provisional con fianza.
So I'm going to establish bond at $500 with pretrial release conditions.
Se concede fianza en la cantidad de $500 con las condiciones del programa de libertad provisional.
Conditions of the bond are going to be no contact with the alleged victim,
Como condición de la fianza, se le prohíbe todo tipo de contacto con la presunta víctima.
must maintain separate residence from the alleged victim.
Se le prohíbe la convivencia con la presunta víctima.
I will allow Ms. Maldonado Rodriguez to return to 3619 Vega Creek Drive at St. Cloud.
Le permitiré a la señora Maldonado Rodríguez regresar al 3619 del Vega Creek Drive en St. Cloud.
She may not possess any weapons or firearms while the case is pending.
Se le prohíbe la tenencia de todo tipo de armas y armas de fuego mientras el caso esté abierto.
And I don't recall seeing that the alleged victim and Ms. Maldonado Rodriguez share children in common. Mr. Rosa, do you have any knowledge in that regard?
No recuerdo haber visto que la señora Maldonado y la presunta víctima tengan hijos en común. Licenciado Rosa, ¿sabe algo más usted al respecto?
I do not, Your Honor.
No, su señoría.
Can you ask?
I'm gonna have someone else ask. I don't speak Spanish.
All right.
Le preguntó, bueno, le voy a pedir a alguien más que lo haga porque yo no hablo español.
No, Your Honor, there is no relationship.
All right, thank you.
No, su señoría, no tienen hijos en común.
All right, Ms. Carrasco, is there anything further I need to address?
Nothing.
¿Algo más que tenga que atender?
Nothing further, Your Honor, from the state.
Nada más de parte de la Fiscalía, su señoría.
Mr. Rosa, anything I need to address from the defense perspective?
Nothing from defense, Your Honor.
Thank you.
Señor licenciado Rosa, ¿algo más que tenga que atender de parte de la defensa? No, su señoría.
Our next case is Carlos Valentin Lopez, 2022 MM1249. Good afternoon, sir.
Buenas tardes, señor.
Sir, you were arrested for battery, misdemeanor battery.
Señor, usted fue puesto bajo arresto por la falta de agresión física.
There is probable cause.
Existen indicios de criminalidad.
Your case is related to Ms. Maldonado Rodriguez's case.
Su caso está relacionado al caso de la señora Rodríguez Maldonado.
You are also eligible for pretrial release conditions with a bond.
Usted también cumple con los requisitos de participar en el programa de libertad provisional con fianza.
I'm going to set your bond also at $500 with pretrial release conditions.
Se le concede fianza también por la cantidad de $500 con el supervisión del programa de libertad provisional.
You may not have contact with the alleged victim, Ms. Maldonado Rodriguez.
Se le prohíbe todo tipo de contacto con la presunta víctima, la señora Maldonado Rodríguez.
You must maintain a separate residence.
Se le prohíbe la convivencia.
I will allow you to return one time with a law enforcement officer to obtain your personal belongings.
Le permitiré regresar en una ocasión acompañado de las autoridades para que recoja sus pertenencias.
You must make arrangements with law enforcement before going to the residence to obtain your property.
Usted tiene que hacer los arreglos con las autoridades antes de ir a la propiedad a recoger sus pertenencias.
You may not possess any weapons or firearms while you are on release while this case is pending.
Mientras usted se encuentre en libertad, mientras el caso esté pendiente, se le prohíbe la tenencia de todo tipo de armas.
Ms. Carrasco, is there anything further we need to address?
Nothing from the state, Your Honor.
Licenciada, ¿algo más que tengamos que atender? Nada más de parte de la Fiscalía.
Mr. Rosa, anything further? Thank you.
Licenciado Rosa, nada más de parte de la defensa.
Thank you, sir.
Gracias, señor.
Madam Interpreter, can you ask if anyone else at the jail needs your assistance?
Yes. ¿Alguna de las personas que permanece en la cárcel necesitan los servicios del intérprete al español?
No hands, Judge.
All right, thank you. Thank you, Madam Interpreter.
Thank you, Your Honor.
All right, that brings us to our out-of-county warrants, and the first case is Aaron Cruz. And this is Pinellas County case number 2021 CF 6205. Mr. Cruz, you were arrested on a warrant out of Pinellas County for failure to appear. And no bond has been set by the judge in Pinellas County. You'll be transported over to Pinellas County, and you'll address the court there. If there are any issues in the meantime, the public defender has been provisionally appointed to assist you in addressing any issues that come up here while you're here. Okay? Thanks, sir. All right, Kelly Dorfman. This is Orange County case number 2021 MM57. Good afternoon, ma'am. You were arrested on a warrant out of Orange County for failure to appear.
Yes, I just got the warning about it. I
Yeah.
was just informed about the warrant a day or two ago, so I hadn't had a chance to really react to it.
Right. Well, you apparently failed to appear. They did set a bond for you in the amount of $500. Okey-doke. And if you don't post the bond, they will transfer you or transport you to Orange County, and you can see a judge there.
Is there any way for an ROR, since I was not really warned about this, I never knew about this warrant until just a day or two ago.
The judge in Orange set the bond at $500. So, all right.
Okay.
Thank you. All right, then that brings us to our other warrant cases. We had several today. Anthony Ray Ball, case number 2021 CF 2878. Afternoon, Mr. Ball. The state issued a warrant for your arrest signed by Judge Turner, alleging that you violated conditions 7 and 9 of the order of probation. There is no bond in your case. What is the next court date, Madam Clerk?
June 7th, 8:55 a.m.
So next Tuesday, at what time? 8:55?
8:55 a.m.
Next Tuesday at 8:55, you will see a judge for a status. Okay? Thank you, sir. Kwasi Banks, this is case number 2021 CF 2915. Afternoon, Mr. Banks. So the state issued a warrant signed by Judge Carson for Judge Nix Walker, alleging you violated conditions 1, 2, 3, and 9 of the order of probation. There is no bond set in your case. And when is the next court date for Mr. Banks?
June 7th, 8:55.
All right, so next Tuesday at 8:55 a.m., sir, will be your next court date. Thank you. Sharif Edward Bradley, 2022 CT 524. Good afternoon, Mr. Bradley. You were arrested on a warrant for failure to appear before Judge Epperson for arraignment. Judge Epperson did set a bond for you in the amount of $500.
Yeah, and I turned myself in yesterday. I went to the somewhere on Earlo Street to turn myself in. I wasn't sure. I'm from Syracuse, New York. I had went back to Syracuse. Then I came back basically to turn myself in. My wife was out here doing work. So I turned myself in, though. I didn't know I had the warrant because I didn't, on the ticket, the address that they have for me is, the PO number is wrong, but I didn't check it, so.
Well, Judge Epperson did set this bond for you, and you've got a public defender provisionally appointed to represent you now, so if you need to address that bond with Judge Epperson, they can assist you in doing that, okay?
Yes, sir.
All right, thanks, sir. All right, Nelson Camacho Jr., 2022 CT 1345.
Judge, he's pretty hard of hearing, just so you're aware.
Okay. Good afternoon, Mr. Camacho. Judge Sanders Morency issued an arrest warrant for you for failure to appear at arraignment, and she set your bond at $5,000.
Yes, Your Honor, I went to court yesterday. I didn't know exactly the time. My last name is spelled with C-A, not C-O, so whenever I call the courtroom, they have a hard time finding my name. But I did arrive at the courtroom at 9:30. I know it was late. I didn't know that you actually see the judge at 8:30 in the morning. But I went to my job, which is like maybe 2 miles away from the courthouse, to return the keys so they could open up the store. And then I went to the courtroom to find out how much is the ticket and to see the judge. My intention was to go to court. I did work in court. I did find the court officer to find out why the courtroom door was closed. And when they approached me, they said they were initiating a warrant while I was sitting down with the officer from the courtroom. And they tried to ask for a second hearing, but I guess it didn't happen.
Yeah, the order was issued at 10:43. Your hearing would have been much earlier than that. So I've appointed the public defender to assist you today, and they can assist you in getting in front of Judge Sanders Morency to address the bond situation. Okay?
Judge, if I may, is there any way we can get his bond lowered to $2,000? The bond amount right now, he indicated to me he would be unable to pay, but if we could get it down lower to $2,000, he'd be able to pay the bond.
Here's the thing. I don't like it when other judges deal with my bonds, because I set my bonds based on the circumstances in front of me. And so out of respect for my colleagues, I'm not going to mess with their bonds because I presume they do the same thing. So I would prefer that you all go to Judge Sanders Morency. She is reasonable, and I'm sure will address it.
Thank you, Your Honor.
Thank you. All right.
Just one more question. Do we have a next court date for?
I'm not sure, since it was a failure to appear. Do we have a court date?
If he's able to bond out, his next court date would be June 20th. If he's still in jail, it would be June 9th.
So next Thursday would be.
Next Thursday is jail arraignment, but if he bonds out, then it would be June 20th.
All right.
I'm ready, Your Honor.
All right, thank you, sir. Mark Shane Douglas, 2021 CT 2520. Good afternoon, Mr. Douglas. So you were arrested on a warrant for failure to appear at pretrial before Judge Epperson. He set your bond at the amount of $5,000. Does Mr. Douglas have a next court date, Madam Clerk?
Not until August 2nd for the PT.
All right. So the public defender has been provisionally appointed to represent you, sir. If you can't afford the bond set, they can assist you in getting before Judge Epperson before your next court date.
Okay, sir.
Thank you. Okay, Mordlin Dulcine, 2022 CF 1527.
Good afternoon, Your Honor.
Good
Excuse me, Your Honor,
afternoon,
I'd like
sir.
to request a waiving of the reading of the charges for this one.
All right. Not Madam, Ms. Carrasco, although I guess you would be a madam as well. I normally say Madam Clerk. Ms. Carrasco, count one as drafted is worded as an attempt. Wouldn't that make that particular charge a second-degree felony?
Your Honor, based on the information that was relayed to me,
I am talking only about count one.
I'm sorry, Anna, could you please repeat the question?
Yeah, my question was, as written on the face of the warrant, it's referenced as an attempt. Would not that make that a second-degree felony? There seemed to be a disconnect between the charge referenced on the face of the warrant and the affidavit. What I'm trying to get at is Mr. Dulcine entitled to bond on count one.
Your Honor, based on the warrant affidavit, the state is moving to hold the defendant no bond.
Well, and I believe that count two, that's appropriate, but count one, I think he may be entitled to a bond. That's why I was asking the question.
Your Honor, if you give me a moment, and a moment to confer with the ASA assigned to this case, could we recall on this case?
Yeah, we'll recall this case at the end of the docket, Mr.
Thank you.
Dulcine. Okay, thank you. All right, so that brings us to Constance Jean Gayart, 2017 CF 278. Good afternoon, ma'am. You were arrested, ma'am, on a violation of probation warrant signed by Judge Karsten, alleging that you violated conditions 2 and 7 of the order of probation. There is no bond set by the warrant. When is Ms. Garrett's next court date, Madam Clerk?
June 15th at 9 a.m.
All right, so June 15th at 9 a.m. will be your next court date in front of Judge Karsten, ma'am.
I have animals at home that need to be fed.
So who can help you take care of those?
I don't know, nobody's wanting to help anymore.
All right.
I can try to call my aunt, but I don't have any time on my phone.
All right. Mr. Rosa, I'm going to ask you to either help Ms. Garrett contact her relatives or notify law enforcement, someone who can make sure the animals are not neglected or suffering.
Yes, Your Honor.
Because there is no bond, and we need to make sure that the animals are taken care of. Thank you for bringing that to my attention, ma'am.
I just want to make sure that I'm a groomer. I wanted to make sure that they're well taken care of.
Right. We all want to make sure that nothing untoward comes to the four-legged family members, okay?
Thank you.
Thank you. All right, Kevin Hinault, 2022 MM 894. Good afternoon, sir. So you were arrested on a warrant for petty theft less than $750. There is probable cause. And your bond, sir, has been set at $250. And so I'm going to stay the bond in that amount. I'm not going to order pretrial release on top of the bond. Okay. Thank you, sir. Arthur James Herring, 2021 CF 2873. Ms. Carrasco, can you tell me whether there has been a finding of incompetence or is it in status mode?
Or, Your Honor, just to confirm, 22 CF,
21 CF?
2873?
Correct. One moment, Mr. Herring. I'm looking here myself. I don't believe there has been a finding. All right, so Mr. Herring, you were arrested for failure to appear at a competency status hearing. The court had previously removed the reporting requirement to pretrial release, but then in March revoked pretrial release altogether. So you currently have 0 bond. Does Mr. Herring have a next court date, Madam Clerk?
June 7th at 9:30 a.m.
All right, so your next court date, sir, will be next Tuesday at 9:30.
Okay.
Thank you. Brennan Miller Littleton, Cody Brennan Miller Littleton. This is case number 2023-447. Good afternoon, sir. Sir, you were arrested on a violation of probation warrant that alleges you violated condition 5 of the order of probation by committing new law offenses. And there is no bond set in your case. What is the next court date for Mr. Littleton?
June 7th, 8:55 a.m.
All right, so next Tuesday at 8:55 a.m., sir, is your next court date. Thank you. Edwin Lopez, 2022 CF 1449. All right, good afternoon, Mr. Lopez. Sir, you were arrested for various failure to report or register charges, failure to register an address change, failure to report after vacating a permanent residence, failure to report change in employment information, failure to register every 6 months, 2 counts of that. The bonds, sir, are set at $2,500 on count 1, $500 each for counts 2 and 3, $150 on counts 4 and 5. There is probable cause as established by the warrant. I'm not going to add any pretrial release conditions other than that you report as required or register as required by law if you post bond. Of course, failure to do so would be a new law offense. Okay. Thank you, sir. Chikwe Mahoke,
Cheko Koji, how you doing, sir?
say the last name again?
Koji.
Mikoji. I was practicing
I
before
saw your
court.
face. I saw.
I was practicing before court and I thought I had it right, but I then drew a blank, so I apologize.
Not a problem.
All right, Mr. Mukwoji, you were arrested, sir, on a violation of probation warrant from Judge Nix Walker's division. The warrant alleges you violated Condition 5 by committing new law offenses, and it alleges that you violated Conditions 10 and the special condition requiring community service. There is no bond in your case, and Madam Clerk, when is Mr. Mukwoji's next?
June 7th, 8:55 a.m.
All right, so next Tuesday at 8:55 will be your next court date. All right, we have two cases for Kyle Scott Felix Ricker, 2021. Yes.
Mr. I'm going to butcher his name. He would like to address the court as well. So if you entertain that for a moment.
All right, what would you like to ask, sir?
Well, basically, I know. Yes, sir. I did. The charge that I had caught was from August 2000. When I originally started the probation, and I run a company. So it was a disgruntled customer that I was going to have this settled on Tuesday, but I was picked up on Monday. My question is, if you looked at my arrest report, you will see that my arrest report, I was actually working on a job, and tomorrow's Friday. I have 8 employees that I need to take care of their payroll, and I have equipment, et cetera, that's on the job site that is vacant at the moment. And not only that, my debit card that my girlfriend, fiance has is not working, so she doesn't have access to pay anyone or take care of any of the bills with this, the first of the month. I have 8 employees that get paid bi-weekly that are expecting their paychecks on Friday. My question and my plea to you is that if I can receive a bond at any amount, because obviously I make enough, if I can then appear at this judge on the 7th.
Well, one of the charges is that you were engaging as a contractor without being registered or certified.
Right, and I was expecting to show the results to that and solve that on Tuesday. So I was believing in my hopes that charge would be dismissed.
Well, that's not set for hearing on Tuesday.
Oh, no, it was set for last Tuesday. I was supposed to meet with my public defender on Tuesday, but got picked up on Monday. So I was supposed to resolve that on Tuesday.
Well, they can address that with you, sir. It's really not in your interest to speak on the record because anything you say can be used against you. But as I said earlier, I'm not going to disturb another judge's determination with regard to bond because there are several alleged violations. So Tuesday at 8:55, your attorneys will be able to address these allegations, okay? All right, Mr. Ricker, 2021 CF 3061 and 2446.
Judge, you refused to come.
Okay, we'll reset Mr. Ricker for tomorrow. That brings us to Civilis Woodson, 2022 MM 1203. Morning, or good afternoon, Mr. Woodson.
How you doing, sir?
Sir, you were arrested on a warrant for misdemeanor battery, I believe. Yes, misdemeanor domestic violence battery. There is probable cause as established in the affidavit on which the warrant was issued. Ms. Jenkins or Officer Jenkins, what are the other legal constraints?
I'm looking for it now. He have a case that is still pending in Orange County. We kept trying to find it. His next court date for that is in June. Coming up, June, I can give it to you in a minute.
Is he out on bond there or what?
He was out on bond in 12/2/2021, but it was revoked. The bond was revoked back on 12/21. So he has another hearing coming up 6/20/22.
All right, so that's correct. Thank you, Officer Jenkins, for reminding me of that. Yes?
Defendant has indicated to me he believes the case is dismissed. He wanted me to let you know that,
I have
so.
no cases in Orange
He
County.
has no cases in Orange County right now.
None.
Well, the documents I have, let me find that.
It's Osceola County.
Tell me the case number again.
Case number 20 CF 912.
Your Honor, if I may.
Yes.
That case is set for trial on June 20th, 2022.
Pre-trial on the 8th, though.
He had pretrial on June 9th.
Right, correct. June 8th at 9 a.m. And that will be before a senior judge covering for Judge Nix Walker. A habitual felony offender notice has been filed in that case. Mr. Woodson is out on bond in that case. There were some pretrial release conditions that were modified. In that case. A new bond had been set in November of 2021. Release conditions were modified May 5th of 2022. All right, so the bond in that case will be revoked, forfeited, and escheated. Mr. Woodson will be held zero bond in that case.
Would that case be 20 CF 912?
Correct. It doesn't.
Judge, if you could, I'm sorry, I couldn't quite hear you. Why is he on a zero bond?
Because he has, there is probable cause that he committed a new crime while he was out on bond.
Gotcha.
And in this case today, the simple battery case, I'm going to set bond in the amount of $1,000 with pretrial release conditions. No, he doesn't qualify for pretrial release on this case. So $1,000 bond, no contact with the alleged victim, no return to the location, must maintain a separate residence, may not possess any weapons or firearms or ammunition. Okay. All right, thank you, Mr. Woodson. All right, our next case is David Curse, 2022 MM 1141. All right, Mr. Curse, good afternoon, sir.
Good afternoon, sir.
Sir, you were arrested on a warrant alleging battery, dating violence, and violation of a pretrial release condition. I noted the unique circumstances of the pretrial release condition. You were invited to violate that, which doesn't speak well for the alleged victim, but the responsibility to abide by the court order requiring no contact is, of course, on you. And the judge who signed the warrant found probable cause, and I agree with that. The issue is, what are the conditions of release that I should set? Based on the circumstances, I'm going to set bond at, Ms. Carrasco, do you want to be heard on conditions of bond? It's rather unusual circumstances.
1 second, Your Honor.
I shouldn't say rather unusual, but they're noteworthy in any event.
Your Honor, one of the conditions will be no contact with the alleged victim.
Right, but is there any objection to a low bond amount based on the circumstances?
Stay objects to a high bond, Your Honor.
To a high bond?
To a high bond.
Yeah, okay. So you're agreeing to a low bond?
Yes, Your Honor.
Yeah, that was my question, because I thought a low bond was appropriate, but I wanted the state's position. All right, so Mr. Curse, I'm going to set bond on count 1 at $500. I'm going to set bond on count 2 as ROR, so you'll be released on your own recognizance as to count 2. So a total bond of $500. Conditions of bond, sir: no contact with the alleged victim, no return to the location where this incident occurred, which was the alleged victim's residence, and you've got to comply with the no contact order in case number 22 CF 1238, even if you're invited to violate that. Okay?
Thank you, Your Honor.
Okay, thanks, sir. Thank you. All right, let's recall Mr. Dulcine's case, Mordlin Dulcine. I see we have some other prosecutors in the room to address the question the court had earlier. This is 22 CF 1527. All right. Mr. Kozera, appreciate you coming up. So the second count, and the defense waived the reading of the charges earlier. Second count is punishable by life. So the court would set no bond and refer this to the division judge for an Arthur hearing if a bond motion is filed. But count one, as it appears on the face of the warrant, seems to be a second-degree felony. Do you agree?
Yes, Your Honor. As it appears on the warrant, it does. It appears to be, looking at the warrant affidavit, there appears to have been an error, and it looks like there were supposed to be 3 counts. The first of which is omitted from the warrant affidavit in the section where they ask for probable cause for these.
Correct, and that would be a punishable by life.
That would be a life felony.
Right.
Or capital.
Right.
So, Your Honor, if the court is inclined to hold him no bond on count 2, as it stands, then I don't see any problems. We may ask that the warrant be amended at a later time, but that's nothing that needs to be addressed right now.
Right, but I did want to set a bond if he was entitled to a bond on count 1. I want to set one for that count.
On count 1, he would be entitled to a bond. That's correct.
All right. So on count 1, I'm going to set bond at $50,000, and on count 2, I'm going to leave that at 0 bond, and the division judge can address that in a bond hearing.
Perfect. Thank you, Your Honor.
Okay. And there is probable cause as set forth in the arrest affidavit.
And Your Honor, not that it really matters, given that there's no bond on count 2, but we would certainly ask for no weapons, no firearms, and no contact with any co-defendants or anything.
Correct, yeah. Much of this is an intellectual exercise under the circumstances, but yes, no contact with alleged victims or witnesses, no possession of any weapons or firearms. I don't believe this happened at a residence. But I'll order no return to the location of the alleged offense.
Thank you, Your Honor.
Thank you. All right, thank you, sir. All right, that brings us to Nancy Cologne, 2022 MM 1243. All right, Ms. Cologne. Ma'am, you were arrested for misdemeanor battery. All right, there is probable cause. I'm going to set your bond at $500 with pretrial release conditions. The conditions are that you may not have any contact with the alleged victim. You must not return to the location of the offense. If you have any personal belongings there, you can return with law enforcement one time to obtain your personal belongings. You have to make arrangements with law enforcement in advance to do that. You must maintain a separate residence, as I said, and you may not possess any weapons or firearms while the case is pending. And you're on release. Okay?
Thank you.
Thank you. John Ingram, 2022 CF 1582. Good afternoon, Mr. Ingram. So you're arrested on 4 charges, possession of marijuana greater than 20 grams, drugs or possession of a controlled substance, possession with intent to sell or deliver cocaine, and drug paraphernalia, possession or use of drug paraphernalia. I find probable cause with regard to counts 1, 2, and 4. I don't find probable cause with regard to the intent to sell. Based on the totality of the affidavit. There certainly was some indication that maybe you had in the past or would in the future, but the other circumstances, I don't believe supported that. So your bond's going to be $2,500 on counts 1 and 2 and $500 on count 4. I'm going to ROR you on count 3, so that's a total of $5,500 bond. So that's reduced from $13,000. Your conditions of release are going to be to comply with pretrial release conditions. And I'm going to order random urinalyses. All right, you may not use or possess any drugs or narcotics without a valid prescription. All right?
Yes, sir.
Thank you, sir.
Random.
Random urinalysis, PTR conditions and random urinalyses, and no possession of drugs or narcotics without a valid.
So you want that on monthly, Your Honor?
I'm sorry?
You want that monthly urine analysis?
Do I want it on Monday?
Monthly.
Monthly.
Yes,
I'll leave that to your discretion.
Okay.
Thank you. All right, Deshaun Jones, 2022 CF 1584. Good afternoon, sir. Sir, you're arrested for petty theft, two or more convictions previously, and also trespass after warning. You're also out on bond in Orange County, case number 22 CF 900. There is probable cause for the current arrest. The bonds are $1,000 on count 1, $500 on count 2. Going to order that you not return to the location of the alleged offense, and you may not have contact with any victim or witness. With regard to Orange County case number 22 CF 900, your bond in that case will be, or your release in that case will be revoked. If you're on bond, it will be forfeited and escheated, and there will be zero bond in that case. Okay, thank you, sir. Gregory Limley, 22 MM 1244. All right, good afternoon, Mr. Limley. Can anyone shed light on the group home where this alleged incident occurred? Is Mr. Limley there voluntarily, or is he court ordered to be there?
He's voluntary, Judge.
What kind of group home is it?
Your Honor, he said it indicated it is for individuals that draw Social Security SSI checks.
All right.
Disability, Your Honor.
All right. There are some unfortunate circumstances in this case. So you were arrested, Mr. Limley, for battery, misdemeanor battery. There is probable cause based on the arrest affidavit. You do qualify for direct pretrial release. However, based on the circumstances, I think leaving your bond in place is appropriate. So your bond is going to be $500. I'm going to order that you have no contact with Sharon Lavalente, and you may not return to the group home. I will allow you to return one time with law enforcement to get your personal belongings. If Ms. Lavalente doesn't work there, doesn't live there, couldn't really tell from the affidavit whether they both live there or whether the alleged victim works there. I have no problem with Mr. Limley continuing to live there if there's a way to have no contact with the alleged victim. So why don't I do this? I'm going to order that there be pretrial release conditions in addition to the bond amount, so that we can verify the no contact compliance. I hesitate to make Mr. Limley homeless. On the other hand, the facts are what they are. All right, so you may not have contact with Ms. Lavalente or any other witnesses. You may not reside there unless there is a way to have no contact with Ms. Lavalente. You may not possess any weapons or firearms. And you may not use any drugs or narcotics without a valid prescription. Okay? All right, and you have to take all prescription medications as prescribed. Okay? Thank you, sir. Matthew Lormeus, 2022 MM1245. We have a witness here for this case. Good afternoon, sir.
Good afternoon, Your Honor.
Sir, you were arrested for misdemeanor battery. I do find probable cause based on the affidavit. Do we have a witness here for this case? Come on up, ma'am. And are you Anna Raymond? Yes, sir. All right, raise your right hand to be sworn, please. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Yes. All right. So you're a soft talker, so I need you to speak up so I can hear you, but also they need to be able to hear you at the jail. That's a microphone on the lectern, so if you will get close and speak up, tell me what you would like me to consider with regard to conditions of release.
I would like to have contact with him. We do share a child as well as bills, a car, a residence. I don't feel he's a threat. I'm not afraid of him. And yeah, I would like to have contact with him.
All right. Is there a history of violence between the two of you?
No, there was one case before this, but it was a misunderstanding. So that was dropped, and I'm pursuing to drop these charges as well.
All right. If you were in danger, would you hesitate to call 911?
No, sir.
Why did you choose to call 911 this time when he had driven away?
I didn't, Your Honor. The neighbors did.
So do you reside with one of Mr. Lomais's relatives?
Yes.
I'm sorry, someone coughed when you were answering.
It's okay. Yes, sir, we did.
All right. And who is that you live with?
His sister, Mathlene Ruiz.
And is the sister willing to allow the two of you to reside there?
I believe so, yes.
And how old is the child that you share with Mr. Lomais?
He just turned 9 months old yesterday.
All right. I'll note that according to the arrest affidavit, he hadn't been born yet. There's a typo in the year. So 9 months old. Was the child in harm's way when this incident occurred?
No.
Where was the child?
He was in the car. We were arguing outside of the car.
And so when Mr. Lomais drove away, he took the child with him?
Yes.
Have you ever seen him be abusive toward the baby?
No, sir.
All right, Ms. Carrasco, do you have any questions for?
Yes, Your Honor, briefly, just to confirm, Ms. Raymond, are you in fear of the defendant?
No.
Will you be able to call 911 should this happen again?
Yes.
Do you work?
Not currently.
Does the defendant have any prior injunctions that are active at this time?
No.
Nothing further, Your Honor.
Mr. Rosa, do you have any questions for Ms. Raymond?
No, I'm good, Your Honor.
All right, Ms. Raymond, does Mr. Lomais work?
Yes.
What kind of work does he do?
He is a cook.
Okay, where does he cook?
At Outback Steakhouse.
And what is the address where you all would live if I granted release and allowed you to live together?
1426 Riverboat Drive, Kissimmee, Florida 34744.
Okay. What was the reason for the altercation in the case?
It was just, we were having a bad day. We were arguing. I don't even remember what it was. We were just having a really bad day. We've both been really stressed out and overwhelmed.
Is that because of too much responsibility and not enough money?
Partially.
All right. Mr. Lomais, if I allow you to have contact with Ms. Raymond, are you going to be able to make sure that the contact is non-hostile in nature?
Yes, sir.
So if you're losing your temper, that means you need to walk away without putting your hands on Ms. Raymond or on anyone else, you understand?
Yes, sir.
How many hours a week do you work at Outback?
I did recently start, so it does range. Sometimes I stay late, sometimes I leave early.
Okay. How many years of school do you have, sir?
I didn't hear what you said, sorry.
How many years of school do you have?
I graduated.
Okay. All right. I think a low bond is appropriate based on the circumstances. I'm going to set your bond, sir, at $250 with pretrial release conditions. They'll explain to you what that means at the jail before you're released, pretrial release conditions. I have to set a low bond in order to give you those conditions. You may have contact with Ms. Raymond, you may reside with Ms. Raymond and the child, but you may not have hostile contact. Your contact must always be non-hostile. If there is any cause to believe that you have been hostile in any way, that would be a ground to revoke your bond, so keep that in mind. You may not possess any weapons or firearms, so that means if anyone in the home where you're living has weapons or firearms, those weapons or firearms have to go away, all right? All right, anything else, Ms. Carrasco?
No, Your Honor.
All right, thank you, sir. Thank you, Ms. Raymond. All right, we have two cases for Mark Perman, 2022 MM 1246 and Orange County case 2020 CF 5185. All right, sir. You were arrested for two charges. You were arrested in case number 22 MM 1246 for resisting an arrest without violence. That may or may not be true. I can't tell from the affidavit, so I'm finding no probable cause on that charge. And so you'll be released ROR as to that case. However, you do have the warrant out of Orange County, and there is no bond on that case. So you're going to be held on that case and transferred or transported to Orange County. You'll see a judge there.
So there's no way I can get my bond?
No, that's an Orange County case, and the judge set zero bond on that one. And that was for a failure to appear, and that's why you don't have a bond there. It would appear you knew you had a failure to appear warrant because of the circumstances in the case that I found no probable cause. The warrant doesn't say the officer told you to stop. That's why I found no probable cause. If they told you to stop, then there would be probable cause.
Yes, sir.
All right? All right, thank you, sir. 22 MM 1247, Rancis Prophet. Good afternoon, sir. So you were arrested on the charges of resisting an arrest without violence and trespass into a structure or conveyance. So these are interesting set of circumstances in the arrest affidavit. Ms. Carrasco, there is not probable cause based on the narrative, in my opinion anyway. Hold on.
Your Honor, the defendant was trespassed and asked to leave, and he refused to leave even though he was trespassed the first time.
Well, he walked out to the vestibule, and then he sat up, then he sat down and said he wouldn't leave, but then he got up and tried to leave, and they wouldn't let him. So did they want him to leave or not want him to leave? And he was actively resisting by pulling away, but that was after they had not allowed him to leave, although they had told him to leave. There's obviously a problem here, but
Your Honor, may I please have a 24-hour reset in this case?
all right. I will grant the request for 24 hours to allow the state to attempt to amend the affidavit. There is no probable cause as it is written now.
Thank you, Your Honor.
Justin Saunders, 2022 CF 1587. afternoon, sir.
Good afternoon.
Sir, you were arrested on the charges of aggravated assault with a deadly weapon and resisting an officer without violence. There is very narrow probable cause here. There is probable cause, but it's not overwhelming probable cause. Probable cause is a very low standard. Ms. Carrasco, do you wish to be heard on conditions of release?
Excuse me, Your Honor.
Yes, sir.
I believe when I was reading the report, the weapon that they found on him was a different color than the one that was reported, so I think it's like the challenge probable cause that way. It was found in the house, not on this person.
Well, correct, after he had gone home. But like I said, it's thin, but I do think there is some probable cause there. But that's why I'm inquiring about conditions of release. Officer Jenkins, does Mr. Saunders have history?
From 2004 to 2008, driving while license suspended, habitual offender. 2017, knowingly driving while license suspended. In 2022, February, failure to appear on case 21 CT 3572. In May 2022, failure to appear on case 21 CT 3572.
All right.
That's all we have, sir.
So his history is driving related.
Yes, sir.
All right. Ms. Carrasco, do you have anything that?
No, Your Honor.
Mr. Saunders, you qualify for bond with pretrial release conditions. And these are interesting circumstances, shall we say. I'm going to set your bond on count one at $1,000. I'm going to leave count two at $500 for a total bond of $1,500. Okay, $1,500 total bond. You may not have contact with the alleged victim. You may not possess any weapons or firearms, so I'm going to require that the green Luger, was that seized by law enforcement?
I don't think it was, Your Honor.
Yeah, it says it was collected and entered into evidence. All right, so we don't have to worry about that. But you may not possess any weapons or firearms while you're on release in this case.
Judge, so bond was $1,000 and 500.
Correct.
Was that with PTR?
With PTR conditions. And no contact with the alleged victim or witnesses, and no possession of weapons or firearms. Okay. Thank you.
Thank you, Your Honor.
All right, Terrell Taylor, 2022 MM 1248.
Your Honor, he asked to be excused, so I'd ask him to be waived today.
He has to be excused, so what?
I'd like to waive him today.
Okay, so we will waive Mr. Taylor, and his bond will be stayed at $500. There was probable cause. He may not have any contact with the alleged victim. He may not return to the Burger King where the incident occurred. All right. Seems like there's another case pending with him, but that's not before me today. All right, 2022 MM1250. Let's see, that's Misty White. All right, Ms. White. Ma'am, you are arrested in this case on misdemeanor battery. There is probable cause. I'm going to set your bond in this case at $500. Going to require that you maintain a separate residence. Going to allow you to return to the residence if that is still occupied by you or Mr. White. I'll allow you to go one time with law enforcement to get your personal belongings. Ma'am, is your mother taking care of your small son?
Technically, it's the father's mother, because this is from a different side. But yes, she has custody of him right now.
Okay, and who is watching your teenage daughter?
My brothers.
All right, and your teenage daughter is coming up on 18 years old in September, correct?
Correct.
All right. The reason I'm asking you those questions, ma'am, is because the probable cause in this case requires that I find an on-view violation of your probation in the case 2019 CF 4223, and you are a violent felony offender of special concern, so the court has no authority to give you a bond in that case. Okay. So I'm not sure whose division that's in, but that will be set for a status hearing at some point. Okay?
Judge, to recap, did you find PC on
Yes.
the probation, on the case that she's on probation?
Well, I found probable cause for the new arrest, which gives rise to on-view violation
So you
or
did find-
violation of condition 5. Yeah.
And just to make sure, the bond was 500. Was there no contact order or?
Well, I said maintain separate residence. Yes, no contact.
No return and return once?
One-time return. If that residence is still a residence, it was a motel room. Yep. Okay, thank you, Ms. White.
Judge, do we have a next court date or status hearing date?
On demand.
Yeah, it's on demand because it was an on-view.
Gotcha, okay.
Okay, thank you. And then we have Michael Joshua Ballou recalled from yesterday. Is he here?
He refused, Judge.
All right, so he's refused 2 days in a row, so I'm going to deem that a waiver. There is probable cause. His bond will be stayed at $500, and he is ordered not to return to the location of the alleged offense and to have no contact with his I know it's his mother, but I think it's his sister also, who are the alleged victims. Yeah. So no return and no contact. Okay, anything else, Mr. Rosa?
I think that's it, Judge.
All right, thank you, sir.
Have a good one.
You as well. Ms. Carrasco, anything else?
Nothing further, Your Honor, from the
All right,
state. Thank you.
thank you. Thank you, Officer Jenkins.
I have created a Patreon page for those of you who want to support my channel. All patrons will receive access to the new private bond court Discord server. All video content will remain on my YouTube channel for free. Supporting me on Patreon is not required, but it is greatly appreciated. Thank you to everyone for watching my channel, liking my videos, and leaving comments. Bond court is now in session.
Have been previously sworn.
Alrighty. The defendant will be brought and put in the headset in just a second. They're bringing him out.
Certainly, Your Honor.
And case number is 2021 CT 5583 AO. Bonell Cruz Gordiz. Gordils. Gordils. He is wearing the headset.
Your Honor, the interpreter can confirm there's connection.
All right, your name, sir?
Your Honor, the interpreter did not catch that audio.
You need to lean into the microphone. Lean into the microphone.
Onel Cruz Gordils.
Your Honor, the interpreter is facing some audio issues at this time. Would it be okay if I asked you to call back and one of my colleagues will pick up the call?
All right, we'll do it. Thanks. One of those days.
Good morning, Your Honor. This is Rafael Barrera, State Certified Court Interpreter. I have been previously sworn.
All right, good morning. The defendant is wearing the headset.
Thank you, Your Honor. If you allow me just a moment to connect and confirm.
Sure.
Your
Honor, the interpreter is able to connect and confirm the defendant can hear.
All right, your name, sir?
Onel Cruz.
Onel Cruz.
Sir, you're here today because you were arrested on a warrant for failing to appear on a charge of driving while license suspended. Bond is set in the amount of $1,000. And I will appoint a public defender to represent you. And what about the rest of this stuff on here? The grand theft, attaching his tag, and then another driving while suspended?
Yeah, he was already seen on those cases.
Yes, all right. All right, thank you, sir. And that's 2021 CT 5583 AO.
Thank you very much, Your Honor. May the interpreter be excused.
That's it, right? Yes, thank you.
Thank you, Your Honor. Have a good morning.
Right, bye-bye. I'll go into WebEx now.
Oh, we're not doing questions.
Welcome to an Econo meeting. You are entering the meeting now.
Are your name, sir?
Keon Jawan Bell.
Which one is
Oh, it's not.
Raymond.
Your last name is Bell?
Yes, sir.
Okay. Does anyone have that?
It's an arraignment?
That was already here this morning.
Oh, here we go. All righty. Okay, Mr. Bell, you're here for arraignment on, you're driving under the influence charge on the violation of probation. We'll enter a denial of that and set that for a violation of probation hearing, and the public defender looks like was already in your case before, but if not, we'll appoint the public defender for the VOP. All righty?
Division 63, VOP status, June 17th at 9 o'clock, courtroom 10B.
All right, we'll enter a denial on that violation of probation, set that for a violation of probation status. Public defender is previously appointed.
Division 84, VOP status, June 20th at 8:30, courtroom 4B.
Enter denial of the violation. Oh, is it? No, it's not. It's not a VOP. We'll set that for pretrial, and when a public defender's already been appointed.
She has two cases. Is it the same division for both cases?
What division is the reckless in? Okay, so in 2022 CT 2557 AO, the reckless driving, we'll set that for pretrial. 2022 CT 2559 AO, set that for a pretrial, and we'll transfer that to Division 85, so they're both together. All right.
Division 85, pretrial conference, June 27th at 9 o'clock, courtroom 4A.
Parsons Adelbert. Your name, sir?
Albert Parsons.
All right, sir. It looks like we got it backwards. You're here for arraignment on your battery domestic violence.
Yes, sir.
Assume there's not an offer on the case at this point.
No, Your Honor.
All right, we'll set that for pretrial. You do have a public defender, and they'll keep in contact with your attorney.
Division 50, pretrial conference, June 20th at 9 o'clock, courtroom 7C.
Have with Jarvis Harden. All right, we'll enter plea of not guilty, set that for pretrial.
Division 83, pretrial conference, June 20th at 8:30, courtroom 6C.
All right, your name, ma'am? Thomas Killen, you're here for arraignment on your petty theft of $100 or more.
I believe she has two cases.
I only have one. Do you have a second case?
Okay, I was thinking of a different case.
Okay.
Your Honor, the offer from the state is an adjudication of guilt, credit time served, no return to 11930 Narcousie Road. There is also a cost of investigation in the amount of $100 to Orlando Police Department. Ms. Kilman would like to accept and enter a plea of no contest, Your Honor.
All right, Ms. Killen, is that correct? You want to enter a plea of no contest to the charge of petty theft of $100 or more? Are you under the influence of any drugs or alcohol today? Have you suffered from or been treated for any mental illness in the past? All right, the plea form there, you understood the rights on that. Do you have any questions about the rights? Understand this is punishable by up to a year in the county jail, up to $1,000 fine, and that the entry of your plea would result in deportation if you're not a citizen. All right, I do find sufficient factual basis to accept your plea. I'll judge you guilty of the charge. You'll be sentenced to 40 days in the Orange County Jail. You do have 40 days credit for the time that you've previously served. On post-court costs, a $50 cost of prosecution to the state, and a $100 cost of investigation to OPD. Finally, I'm going to order that you not return to the 11930 Narcousie Road for a period of 1 year. If you do return there and the court's made aware of that, you are subject to a contempt citation. The court costs and the cost of prosecution and investigation I'll give you 24 months to make that, get that paid, okay? All right, you'll be released as to this case. Enter plea of not guilty, set that for pretrial.
Division 62 pretrial conference, July 28th at 8:30, courtroom 12C.
Nope. Your name, ma'am? Come forward. Come on up. Yeah. That was the one before you. What's your name?
Dominique McNutt.
Ms. McNutt, you're here today for arraignment on your trespass charge.
And, Your Honor, the offer from the state was an adjudication of guilt, credit time served, no return to 1446 North Pine Hill Road, and Ms. McNutt would like to accept and enter a plea of no contest.
All right, Ms. McNutt, is that right? You want to enter a plea of no contest to this trespass charge?
Oh, yes, sir.
All righty. Are you under the influence of any drugs or alcohol?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
Yes, sir, I have.
Take any medication for that?
Not at this time.
You do understand what's happening here today, though?
Oh, yes, sir.
And you know what this charge is? You know the trespass? Okay. You understood the rights in the form here. Do you have any questions about the form that you signed?
No, sir.
You understand that this is punishable up to a year in the county jail, up to $1,000 fine, and at the entry of your plea could result in deportation if you're not a citizen. All right. All right, if you find sufficient factual basis, I will adjudge you guilty. Sentenced to 34 days in the Orange County Jail. You do have 34 days credit for the time you've served. I'm going to impose court costs and a $50 cost of prosecution. That's a total of $273, and I'll give you 24 months to pay that. Okay, 24 months to get it paid. Finally, I'm going to order that you not return to 1146 North Pine Hills Road for a period of 1 year. If you do go back there, the court's made aware that you are subject to a contempt citation, which could result in up to a 180-day jail sentence. Okay? All righty, you'll be released as to this case.
Can I have just a second?
Sure. Did she have something else?
Yes. She can step back and we can take him. I'm just gonna look at one thing for her. If she could just step right here for a second. Mm-hmm. And we can continue. I just wanna make sure.
All right, your name, sir?
Sir?
Your name?
Mr. McWhite.
Mr. McWhite, you're here for arraignment on your criminal mischief charge. Looks like, I guess it originally was a felony and now it's a misdemeanor.
Yes.
Oh, the offer from the state is an adjudication of guilt, credit time served. There's a cost of investigation in the amount of $136 $136.04 to the Orlando Police Department. Mr. McWhite would like to accept and enter a plea of no contest. Also, Your Honor, I think the state needs to reserve on restitution. Is that it?
Yes.
Okay.
All right, Mr. McWhite, your attorney says you want to resolve this case by entering a plea of no contest. Is that right?
Yes, sir.
Are you under the influence of any drugs or alcohol?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
No, sir.
All right, the plea form that you signed there, do you understand all the rights in that?
Yes, sir.
And do you have any questions about those rights?
No, sir.
All right, you understand that this is punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your plea would result in deportation if you're not a citizen. Understand?
Understand? Yes, I
Yeah.
do.
All right, go ahead and sign that. All right, I do find a sufficient factual basis to accept your plea. I will adjudge you guilty of the charge of criminal mischief. You're sentenced to 40 days in the Orange County Jail. You do have 40 days credit for the time that you've previously served. I'll impose court costs, a $50 cost of prosecution to the state, a cost of investigation of $136 for OPD. And finally, I'll order restitution and reserve for a period of 60 days for the state. Now, I'll give you 24 months to pay the court costs and the cost of prosecution, okay? Because it's 273 plus 136, and then if they have restitution, but you got 2 years to pay that off, okay? All right, you'll be released as to this case. Jose Ortiz Concepcion? All right, sir, you're here today because you're here for arraignment on your violation of probation. Is there any, there's no offer in there.
Your Honor, may I please have permission to speak freely?
Sure.
All right, on this same violation, it's running concurrent with another case, and I already went to court over it. I told the judge that on my initial appearance, so pretty much I've been violated twice with the same violation. I've already went to court for it. I have another court date set for it on the 28th.
What's the other charge that you already have?
It was a grand theft. This case is running concurrent with that one, and
So you were on probation on grand theft and on a battery?
Yes, sir.
Okay.
And this battery is running concurrent with that grand theft, and I already went to court for that violation, which the judge acknowledged and reset the court date because she didn't want me to get a warrant for the violation on this charge, which ended up happening anyway. And I've already been in jail for a week, and then he tried to put on there for the victim's impact course, and I sent my public defender the certificate of completion for that yesterday as well as the proof, which is on public records for the documentation that I've already gone to court for this VOP. So technically, it's like double jeopardy. I've been hit twice with the same violation.
No, it's different cases, not double jeopardy.
Okay, so
And if I could have just a moment, Your Honor.
Yeah, I'm taking a look at it real quick too. This is my case. Case in which I put no bond on, but I did. All right, so that other case is pending still, you said?
Yes,
Your other violation?
Yes, sir. I have court for that on the 28th. I'm just trying to understand how am I being hit with the same violation. I understand.
Because you got one on the grand theft and you got one on the battery. And so by you doing the same thing, it's a violation here, it's a violation there. That's how you got two violations.
But all right, so what I'm trying to understand, if this case is concurrent with that one, wouldn't it pertain, like, kind of be just one?
No.
Okay.
I will say, to your credit, it's clear that they were confused. It's a couple of things. First of all, the violation that was brought to me on the battery charge was from the state of Florida Department of Corrections, not from county probation and parole. And originally they had my name, then it got crossed out and they put Barber on it, and then they crossed that out and put my name back on it. So I think that there is some sort of confusion. What's his release status on the other VOP? Do we know? Are you out on bond on the other one, or are you being held?
I've already went to court. I got another court date for the 28th of this.
I understand that, but so you went to court from jail?
Yeah, I went, I came from Marion County, and then I bonded out, and then I went to court, seen the judge, Elaine Barber, and then from there, she saw the second violation, and she didn't want me to get double hit, so she acknowledged it, and then she reset the court date for the 28th.
Oh, that's on the grand theft, Your Honor.
Right, well, that's my question. Was he was out on bond on that? And when did they pick you up on this?
I got picked up, I didn't get picked up on that VOP. I actually had to go to court for another court date, and when I went there, I brought it to her attention just so I wouldn't get like double violated, and then she acknowledged it and gave me another court date for it. On the 20th, if I'm not mistaken. 28th, sir.
So you got picked up at the courthouse?
No, sir. I came from Marion County. I was originally in Marion County.
So you were in Marion County jail?
Yes, sir. And then I did 31
So
days.
you got arrested on a new charge there?
No, I didn't get arrested on any new charge, sir. I just, it was just kind of like hearsay, and I ended up.
I'm not talking about the validity, okay, but they don't just say, okay, come on into the jail if you want to have a picnic.
Yeah,
So there must have been a reason they took you to jail in Marion County.
yeah, they took me to jail because I was currently at the Phoenix House program, and there was some hearsay there that caused me to go to jail.
All right.
And then from there, when I was in jail, then I was to see Elaine Barber, which was my initial judge. I sat there for 31 days, got transported here, bonded out, went to court a week later. She acknowledged a new violation for the failed drug test, which is the same one that's concurrent with this one, and then reset it for the 28th.
On that case?
Yes, sir.
Then how did you get picked up on this case?
Great question. I'm still trying to figure that out.
Hey, dude, you have to know how you ended up in jail. Where were you and where did they arrest you?
Oh, on this case?
Yes.
I was literally just at home, and they said they had a warrant for the
Okay.
violation. I'm sorry, sir. I didn't understand your question.
All right. When is your court date on the other one?
On the 28th, sir.
What is Division 84's EOP date?
June 20th at 8:30.
All right, I'll release some ROR on this, and set it for that June 20th date. Don't burn me. If you don't show up, you're not getting out of jail, okay?
I appreciate you, sir. Thank you for your time.
If you end up in jail on Judge Barber's case, make sure you let the public defender know so that they'll know that that's where you are and that's why you're not at court, okay?
All right. Thank you, sir. Have a wonderful day.
All righty. So there's. I don't see them. They're not on there, are they? Oh. Okay. I guess that's how it shows up. On mine, it'll show up there. All right, your name, ma'am?
Andrea Sharber.
Ms. Sharber, you're here today for arraignment on your resisting without violence charge.
Yes, sir.
The offer from the state, Your Honor, is an adjudication of guilt, credit time served, and court costs. Ms. Sharber would like to accept and enter a plea of no contest.
All right, so Ms. Sharber, is that correct? You would like to enter a plea of no contest to the charge of resisting?
Yes, sir.
All right, are you under the influence of any drugs or alcohol today?
Naproxen, but I'm not.
Okay. All right, and have you suffered from or been treated for any mental illness in the past?
No, sir.
All right, you read over a plea form, understood the rights. Now, do you have any questions about the rights that are on this form?
I don't have any questions.
All right, you understand this is punishable by up to a maximum of a year in the county jail, up to $1,000 fine, and that the entry of your plea could result in deportation if you're not a citizen. Those are all things that could, that's not going to happen,
All right.
but that's the maximum. All right. I do find sufficient factual basis. I'll accept your plea of no contest to the charge of resisting an officer without violence. Be sentenced to 28 days in the Orange County Jail. You do have 28 days credit for the time you previously served. I will impose court costs and a $50 cost of prosecution. Now, that's a total of $273.
All right.
And I'll give you 2 years, so 24 months to pay that. Okay?
Great.
All right, you'll be released as to this case.
Good afternoon.
Okay, take care. Gina Aravallo.
Good morning, Your Honor. McKenna Mundy here on behalf of Gina Aravallo.
All right, good morning. Good afternoon, I think. Well, it's right at the cusp of it, so.
Right at the
It's about to change. Okay, Ms. Aravallo. Or ma'am, you're here today because you were arrested on a charge of ag stalking after an injunction. I have read the charging affidavit, and I do find sufficient probable cause. Counsel want to be heard?
Your Honor, our office has filed an unopposed motion to set bond and release conditions, as well as filed a proposed order that has been signed by our office, as well as the state attorney assigned to this case, who I believe is Christopher Smith. Yes, Christopher Smith. I don't know if you can see it in the file. I'm happy to go over the conditions that are set forth in that motion.
I don't see that, so why don't you go ahead and do that? It hasn't made the queue yet in Odyssey. What were the conditions?
That bond be set at $5,000 is the first one. Next is defendant have no direct or indirect contact with the alleged victim, including specifically no telephone, computer, or third-party contact.
Okay.
Defendant is not to come within 1,000 feet of the victim's home or any of his business locations. Defendant may not possess any firearms. Defendant shall submit to GPS monitoring. Within 20 days of her release, defendant shall undergo a psychological or psychiatric evaluation and provide it under seal to the court and the state. These conditions are to be monitored by pretrial release, and defendant shall report to pretrial release services within 24 hours of her release. If she is released in the county other than Orange County, Florida, she shall report the day of her release if she is released in Orange County, Florida.
Excuse me, may I address the court?
Okay, so are those the complete conditions?
Yes, Your Honor.
Just one question.
Okay.
First of all, that's my lawyer?
Yes,
Okay,
that's your
I'm
lawyer.
sorry,
I'm one of the attorneys at the office, yes.
You work with who, I'm sorry?
Yes,
She's
with the attorney that was hired. That she's an attorney in their office.
With Mr. Aaron Delgado? Okay.
Yes.
Thank you.
All right.
I want to address the court now about the conditions.
Yeah.
It's just a quick question. I requested or I invoked habeas corpus 5 days ago, and I just want to know what was the decision on that. Because the thing is, I will agree with the conditions, if that's what you want, Your Honor, but it's a little complicated. The injunction that we are talking about, it was
Ms.
Yeah, you
Ravello, I caution you against speaking about any of the facts in your case. I don't know the status of the habeas corpus that you filed, but if the judge is on board with the conditions we've set out, you'll get out today, and we can discuss that further.
Yeah, you have to understand everything that's being said in here is being recorded. So you start talking about an injunction and whether you were served or whether you weren't served or what you did or didn't do. Let me just explain that the state's sitting right over there and she has her pen poised right above her pad, ready to write down what you say. So they'll go and pull that record, and then when you're going to hear it again is if you go to trial, they're going to just play that, anything you admit to. So I think your attorney has suggested that you not listen or that you not speak about your case. I think that's good advice.
It's just a quick question.
Okay.
The injunction, the day before or the day that I was arrested, I requested the judge to rule on a motion to vacate. And I had a hearing on that motion to vacate on Tuesday, and all what I want to know is if that injunction was vacated, because it was basically entered. I agreed to enter on that injunction.
Well, if you file the motion, if you file the motion to vacate it and then you got arrested on a violation of that, it's unlikely that that would have been granted. So at this point, that's something that your attorney can sort out with you. What I'll do, because it's an agreed upon disposition for bond in this case, I will set bond amount of $5,000. It's going to have stringent conditions. If you violate any of these conditions, you're going to be back in jail and it'll be no bond. That's a guarantee, okay? So the conditions are as follows. You're not to contact, let's see, the alleged victim in the case, who is, what's his name?
Stan Newton.
You have that state, I'm looking at that. You see, it might not be, it might be Marcy Law that didn't put it in there. I think they just refer to it as a victim. All right, you're not to contact the alleged victim in the case, who currently has a standing injunction. There is a injunction that's against you in that. No contact with him in any way, through telephone, text, the computer, third party, nothing. You can't ask someone to send them. You can't, you can't wink at them, all right? Nothing, no contact, all right? You're not to go within 1,000 feet of his home or his place of business or wherever he is. Can't be within 1,000 feet of him. You must submit to a psychological evaluation and have a report prepared and tendered to the court to your attorney within 20 days. All right, so you need to undergo the psychological evaluation. I think your attorney probably can help you get that set up. You will be released with a $5,000 bond and PTR conditions. Now, there are some, go ahead.
Your Honor, so that's gonna be bond and PTR, because she doesn't qualify for pretrial release.
I understand. So that's what their agreement is. I'll say it, and then you guys have to sort that out. The attorneys, if you have a problem, you can let the attorney know. The most important thing is that you have to keep in contact with them.
Yes, definitely, I will not.
Yeah, right, okay. Now, and you have to report in to PTR within the same day of your release. So if you bond out today, needs to be today, or within 24 hours if it's somewhere else. I don't think she's going to get transferred anywhere, is she, that you know of? Counsel?
I'm sorry, there's a little bit.
That's all right.
Can you-
There's no holds or anything on her, so I expect that she will be, if she bonds out, she'll bond out from here, so we shouldn't be concerned. So,
I'm
re-
sorry, Your Honor.
yes, and then finally, you have to agree or submit to GPS monitoring, meaning that they'll get either a leg monitor or a type of monitor on you too, so that they can be certain as to where you are, okay? So those are the conditions, yep.
I don't believe we have GPS in Orange County, Your Honor.
We don't give it on a regular basis, but are there companies that still do it? I know that we stopped making it a condition unless it's agreed upon.
Your Honor, another question. My brother, where I'm going to be staying after this, he lives like 500 feet from one of
Nope.
Dan's offices.
Can't be within 1,000 feet of his
Any of the
home.
offices?
What's
I mean,
that?
he has like 10 offices.
Yes, yeah,
Anywhere.
within 1,000 feet of the alleged victim's place of business or his places of business and his home.
For how long? Until this case is decided, right?
Until this case is over, that's right.
Perfect, Your Honor, thank you.
Okay.
And yeah, Your Honor, to my understanding, there is no GPS monitoring in Orange County, and she won't get out in 24 hours because this is going to kick back if you add PTR to her conditions, because per our admin order, aggravated stalking doesn't qualify at all per the chief judge, so she's not going to get out. It's just going to kick back to the court.
Your Honor, based on that, I would just ask that you strike the PTR condition and then just increase the bond based on.
Well, I mean, if,
I
all right, I'll strike PTR if they say that that's not going to work, and we'll indicate that if available, submit to GPS monitoring. I'm going to leave the bond at
He also
5,000.
lives in Miami, and he has no offices there or doesn't live there, so I don't know if that.
If you want to go to Miami, that's okay.
No, I live there.
That's preferred, because then you're not,
Yes,
you won't
definitely.
be within 1,000 feet of him. Okay? So, all right, I will strike the PTR condition since that might gum the works up. Everything else is within there, and you will submit to GPS monitoring if it's available, okay? They may have it in Dade County, so if she's gonna go down there, but all the other conditions will be there.
Thank you, Your Honor.
Yes?
Oh, that's.
I was just saying thank you.
Okay, all righty, okay, yeah, we missed the beginning. All right, so, if available, so that means that, right, exactly, that's not gonna be a problem for them. Yep,
Make sure I got the
Mhm.
psychological evaluation to be completed within 24 hours
20 days.
Thank you so much.
20 days.
and results to be submitted to.
The court to be sealed and to her attorney, so that way they can get it to the state. I think that's a better process. That it? All right. Okay, thank you, counsel.
Thank you very much. Have a great day, Your Honor.
You too.
You are the only participant.
Your name, sir?
Seth Meenick, Your Honor.
Hi, Mr. Meenick, you're here today because you failed to appear on a petty theft charge.
And Your Honor, the offer from the state is an adjudication of guilt, credit time served, no return to 8574 South Orange Blossom Trail. Mr. Minnick would like to accept and enter a plea of no contest.
Okay. Is that right, Mr. Bennett? You want to enter a plea of no contest to the charge?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol?
No, Your Honor.
Have you suffered from or been treated for any mental illness in the past?
No, Your Honor.
That plea form, you understood the rights. Do you have any questions about the rights on it?
No, Your Honor.
You understand this is punishable by up to 60 days in jail, up to a $500 fine, and at the entry of your plea, would result in deportation if you're not a citizen.
Yes, Your Honor.
All right. I do find sufficient factual basis to accept your plea. I will judge you guilty of the charge of petty theft, be sentenced to time served,
He has 14 days.
14 days with 14 days credit. Will impose court costs and a $50 cost of prosecutions, a total of $273. And I'll give you 24 months, 2 years to pay that. Okay?
Yes, thank you, Your Honor.
All right, you'll be released as to this case.
You have a nice day.
You too. Your name?
Rakian Dongwa Abdurrahman.
All right, ma'am, you're here today because you were arrested on a charge of indecent conduct.
No? Yes, sir.
And, Your Honor, the offer from the state was a withhold of adjudication, credit time served, and court costs. Would you like to accept and enter a plea of no contest?
All right, ma'am, is that what you want to do, is enter a plea of no contest?
Yes, sir.
Are you under the influence of any drugs or alcohol?
No, sir.
Have you suffered from or been treated for any mental illness?
Schizophrenia?
Hey, do you understand what's happening here today?
Yes, I do.
All right, go ahead and sign that. Now, you understood the rights on that form. Do you have any questions about the rights on the form?
You didn't get a chance to read them.
We went over them, Your Honor.
All right, so you understand all that. Do you have any questions about the rights you're giving up? Okay. You understand that's punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your plea would result in deportation if you're not a citizen.
Yes, sir.
All right, I do find sufficient factual basis to accept your plea. I'll withhold adjudication. You were sentenced to the time you served.
2 days.
2 days with 2 days credit. Impose court costs and a $50 cost of prosecution. That's a total of $273. I'll give you 24 months to pay that off.
I will pay it.
Okay?
Yes, sir.
All righty, you're all set. You'll be released as to this case.
Your Honor, can I have the case number, please?
Yes, she has a name on here now. It's Rukia, Rukia. Yep, there you go. And for the record, that was 2022 MO 670AO.
Thank you.
All righty. Did you have a date? Did they have a date of birth for her? Can we get a date of birth for the last lady? Oh, yeah.
That's the date of birth that we still have. Okay.
I guess it's possible. 22. Your name, sir?
Michael Acevedo.
Mr. Acevedo, you're here today because you're arrested on a charge of possession of drug paraphernalia. I've reviewed the charging affidavit, and there is sufficient probable cause.
Your Honor,
Yes?
with regard to case number 22 MM 3688, possession of drug paraphernalia, state announces a no information.
All right. That means they're not going to proceed on the case, so this case will be dropped. You will be released as to this case. Your name, sir?
Wansley August.
Mr. August, you're here today because you were arrested on charge of battery. I have reviewed the charging affidavit, and I do find that there's sufficient probable cause. I will set bond the amount of $500. If you do bond out, you're not to have any contact with Wiley, W-I-L-Y, Geffrard, G-E-F-F-R-A-R-D. No drugs, no weapons, no guns, no alcohol. Okay, I'll appoint a public defender to represent you on that.
Your Honor, I'd also ask for a no return.
All right, and you're not to return to,
1355 West Gore Street.
and go back there, okay? Now, let's see, you were out on bond. in 2022 CF 5365AO. Just a week ago. I'll take no action on that one. And appoint a public defender to represent him in the new case. Mary Jameson. (2022 MM 3686AO). Ms. Jameson?
Yes.
You're here because you're arrested on a charge of trespass after warning. I have reviewed the charging affidavit and I do find sufficient probable cause. And bond will be set in the amount of $500.
Your Honor, the offer from the state is an adjudication of guilt, credit time served, no return to 3005 West Colonial Drive. And Ms. Jameson would like to accept and enter a plea of no contest.
All right, Ms. Jameson, is that right? You want to enter a plea of no contest to the trespass? Yes?
Yes.
All right. Are you under the influence of any drugs or alcohol today?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
Yes, sir.
All right, do you understand what's going on here today?
Yes, I do, sir.
And you understand what the charge is about?
Yes.
Okay. Now, the plea form you signed, you understood the rights on there. Do you have any questions about those rights?
No, thank you.
Okay. Go ahead and sign that now. All right, you understand that this is punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your plea may result in deportation if you're not a citizen.
Yes, sir.
You understand all that?
Yes, sir.
Okay, I do find sufficient factual basis to accept your plea. I'll judge you guilty of that offense, and I will sentence you the time you served.
2 days.
That's 2 days with 2 days credit. Impose court costs, a $50 cost of prosecution to the state, a total of $273. And I'll give you 24 months to pay that off. Finally, you're not to return to 3005 or 3005 West Colonial Drive for a period of 1 year. If you do return back there and the court's made aware of that, then you are subject to a contempt citation. You'll be released as to this case. Okay. This one was skipped. David Frederick. He did bonded, he bonded. All right, Mr. Kohlberger was arrested on a petty theft. I do find that there's sufficient probable cause, set bond in the amount of $500 and appoint a public defender. What was it, 250? All right, leave it at 250.
I'd ask for no return, Your Honor.
And no return to the place.
Family Dollar.
Family Dollar Store. Not to go to any Family Dollar stores. All right, your name, sir? Your name? Mr. Perez, you're here today because you were arrested on charge of resisting without violence. I have read the charging affidavit and I do find that there's sufficient probable cause to step on the amount of $500.
Your Honor, the offer from the state was an adjudication of guilt, credit time served, and court costs. Mr. Perez would like to accept and enter a plea of no contest.
Is that correct, Mr. Perez? You want to just enter a plea of no contest?
Yes, sir.
All right, are you under the influence of any drugs or alcohol today?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
Excuse me?
Have you suffered from or been treated for any mental illness in the past?
Yes, sir.
All right, do you understand what's going on here today?
Yes, sir.
And are you on any medication for that?
No medication.
All right, but you do understand the charges that are against you today?
Sir.
Okay, now, there's a plea form that you signed. Did you understand the rights on that and then sign it?
Yes, sir.
Do you have any questions about anything on that form?
No, sir.
Okay, go ahead and sign it now. All right, you do understand that this is punishable by up to a year in the county jail, up to a $1,000 fine, and that the entry of your plea would result in deportation if you're not a citizen.
Yes, sir.
All right, I do find sufficient factual basis. I will judge you guilty, sentenced to time served,
2 days.
2 days with 2 days credit, and I'll impose court costs and a $50 cost of prosecution for the state. That's a total of $273, and I'll have you pay that at any point in time within the next 24 months. All right?
Yes, sir.
Okay, thank you.
Thank you.
You said no action on his out on bond?
What's that?
Did you say no action?
Yeah, no action on the other bond. And that's 2022 MM 3690 AO. Let me try to remember to do that for you. Your name, sir?
Yashua Ben Yah.
All right, Mr. Ya, you are here in case number 2022 MM 3693 AO. You were arrested on charge of trespass on a structure or conveyance. I have reviewed the charging affidavit, and I do find that there is sufficient probable cause. Oh, go ahead.
Your Honor, the offer from the state is an adjudication of guilt, credit time served, no return to 6942 West Sand Lake Road. And court costs, Mr. Yah would like to accept and enter a plea of no contest.
Is that right, Mr. Ya? You want to enter a plea of no
Yes.
contest and resolve the case?
Yes, Your Honor.
Okay, go ahead and sign that. All right, are you under the influence of any drugs or alcohol today?
No, sir.
Have you suffered from or been treated for any mental illness in the past? Any mental illness treatment?
Oh, I don't need to. 'cause he's-
Been in a mental institution, but I wouldn't say,
Okay. You understand what's going on here today, though, what these charges are about?
yes, sir.
Okay. The plea form that you've signed here, you understood the rights. Do you have any question about anything on here?
No, sir.
Okay, you understand that this is punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your plea could result in deportation if you're not a citizen. You understand all that?
Yes, sir.
All right, I do find sufficient factual basis to accept your plea. I will judge you guilty of the charge. I'll impose court costs and a $50 cost of prosecution. That's a total of $273, and I'll give you 24 months, 2 years to pay that, okay? Finally, you're not to return to 6942 West Sand Lake Road for a period of 1 year. If you do go back there and the court's made aware of it, you are subject to a contempt citation, okay?
Okay,
All right, you'll be released as to this case.
thank you.
Yes, adjudication. All right, take care.
You too, sir.
What happened with Margaret Buckley?
Can we,
All right,
Your Honor, can we reset for tomorrow? There is an offer.
all right, we'll roll till tomorrow. John Heinz?
Yes, sir.
All right, Mr. Heinz, you're here today because you were arrested on charge of soliciting without a permit. I have reviewed the charging affidavit. I do find that there's sufficient probable cause.
And the offer from the state is a withhold of adjudication, credit time served, and court costs. Mr. Heiss would like to accept and enter a plea of no contest. Your Honor.
All right, Mr. Heinz, you're going to want to enter a plea of no contest, is that right?
Yes, sir.
Are you under the influence of any drugs or alcohol today?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
No, sir.
All right, that plea form that you're going to sign, you read that, understood the rights. Do you have any questions about it?
No, sir.
You understand that this is punishable by up to a maximum of 60 days in jail, up to a $500 fine, and that the entry of your plea could result in deportation if you're not a citizen.
Yes, sir.
All right, go ahead and sign that. All right, I do find a sufficient factual basis to accept your plea. I'll withhold adjudication. Sentence to time served.
2 days.
2 days with 2 days credit. I will impose court costs and a $50 cost of prosecution. Is a total of $273. And then I'll give you 24 months or 2 years to pay that off, okay?
Thanks, sir.
All righty, you're all set. You'll be released as to this case.
Thank you.
Oh, that's right. It's actually, sir, it's 223 and 10. That's right. Yeah, that's fine.
He'll get that.
It's a bonus for him. All right. Jeffrey Rivera?
Yes, sir.
Hi, Mr. Rivera, you're here today because you were arrested on a charge of soliciting without a permit. I have reviewed the charging affidavit, and I do find that there's sufficient probable cause.
Your Honor, the offer from the state was a withhold, credit time served, and court costs. Mr. Riviera would like to accept and enter a plea of no contest.
All right, Mr. Rivera, is that right? You want to enter a plea of no contest?
Yes.
All right. Go ahead and sign that. Are you under the influence of any drugs or alcohol today? Have you suffered from or been treated for any mental illness in the past?
No, sir.
All right. Now, you understand the rights on that form. Do you have any questions about anything on the plea form?
No, sir.
You understand this is punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your plea would result in deportation if you're not a citizen.
Yes, sir.
All right. I do find sufficient factual basis to accept your plea. I'll withhold adjudication, be sentenced to, time served. With 2 days with 2 days credit. I will impose, court costs of $223, a filing reimbursement of $10. So it's a total of $233, and I'll give you, 24 months to pay that off. Okay, and you'll be released as to this case.
Thank you.
Alrighty.
Got it. I just wanted to make sure.
Gregory Switkowski. Your name, sir?
Greg Swatkowski, sir.
Hi, Mr. Swatkowski, you're here in 2022 MO 672 AO.
Sir.
You're arrested on a charge of disorderly conduct.
Yes, sir.
I have read the charging affidavit and do find sufficient probable cause. Counsel.
And Your Honor, the offer from the state is a withhold of adjudication, credit time served, and, court costs, and Mr. Swatkowski, please.
All right, Mr. Switkowski, is that correct? You would like to enter a plea of no contest?
That's correct, sir.
All right, are you under the influence of any drugs or alcohol? Have you suffered from or been treated for any mental illness?
Since 1988.
Are you taking any medication for that?
Yes, sir.
All right, and you understand what's happening here today?
I do, sir.
All righty. Did you read over your plea form and understood the rights? And do you have any questions about anything on that form?
No, sir.
Go ahead and sign it if you have not previously. All right, now you understand finally this is punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your plea could result in deportation if you're not a citizen.
Yes, sir.
All right. I do find sufficient factual basis to accept your plea. That's quite a signature you have there. You're trying to rival my signature.
Well, heck.
That's a good one. I like it.
Thank you, sir.
I will withhold adjudication, sentence you to time served.
Thank you.
That's 2 days with 2 days credit. And just
God
I'll
bless.
impose court costs and a $50 cost of prosecution.
Yes, sir.
That's a total of $273, and I'll give you 2 years to get that paid off.
Wow. Thank you, sir.
Alrighty? Okay, you're all set.
God bless. Thank
Be
you.
released. Same to you.
Support. Thank you, ma'am.
Is that the same thing? 223 and 10?
The MO and CO, yeah.
Okay. Oh, well, they'll be happy. They'll go, hey, look, that clerk gave him a break. All right, your name, sir?
Damari Cummings.
Let me get back to your case. There we go. All right, Mr. Cummings, you're here today because you're arrested on a charge for failing to appear for no valid driver's license.
Yes, sir.
And the bond was set in the amount of $500.
And Your Honor, the offer from the state was an adjudication of guilt, credit time served, and court costs. Mr. Cummings would like to accept and enter a plea of no contest.
All right, is that correct, Mr. Cummings? You wanted to resolve this case by entering a plea of no contest?
Yes, sir.
All right, are you under the influence of any drugs or alcohol?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
No, sir.
All right, that plea form that you're going to have signed there, you understood the rights on that? Do you have any questions about the rights that are on there?
No, sir.
Okay, you understand that this is punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your plea would result in deportation if you're not a citizen?
Yes, sir.
All right.
I'm sorry. I
Yep.
did have one question.
Yeah,
Where
sure.
do I go to start the payment plan? For the...
You can go to the clerk's office. I'm going to give you 2 years. You don't have to do a payment plan. You just have to get it paid within 2 years. So you could show up in a month and give them some money and come back the next month. So that way they won't be charging anything for that. You just got to make sure you pay it off within 24 months.
Yes, sir.
Okay?
Yes, sir.
All right. Go ahead and sign that. I do find sufficient factual basis to accept your plea. I will adjudge you guilty of no valid driver's license. You'll be sentenced to time served.
2 days.
Yes, sir.
2 days with 2 days credit. I'll impose court costs and a $50 cost of prosecution, so that's a total of $273. Okay?
Thank you, sir.
You'll be released as to this case. You still got to get a license, though.
Yes.
Start studying. Go get a license.
Okay.
You know. Here, I'll give you a first couple of questions. The one with 8 sides and's red, stop sign.
Yes, sir.
One with 3 sides in yellow, it's yield.
Yes,
So you just got 2 answers right there. Okay? All right. Good luck. All right, bonded. Johnson, what about Kirkland? I read it, but I didn't, okay, so Johnson's gone. All right, your name, ma'am?
Brittany Kirkland.
All right, Ms. Kirkland. You're here this afternoon in 2021 CT 7473AO. and that is a driving license suspended and you failed to appear on that. This is the one that, yeah, Judge Gibson put a no bond on it, Dwellis. And I do, so is that one a plea or do we?
Yes, Your Honor, the offer from the state is a withhold credit time served and court costs.
All right, the only thing is, do you have any prior driving license suspended, Ms. Kirkland?
I see one out of county.
Okay, so you know if you get 3 within a 5-year period, you'll be found to be an habitual traffic offender and lose your license for 5 years. So now this will be your second one. You got to get your license fixed. You can't get another one, okay? All right, so you wish to enter a plea of no contest to this?
Yes.
All right, are you under the influence of any drugs or alcohol today?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
No, sir.
All right, the plea form, that's right there. You understood all the rights in that? Do you have any questions about the rights? You understand this is punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your plea would result in deportation if you're not a citizen?
Yes, sir.
All right. I do find sufficient factual basis to accept your plea. I'll withhold adjudication, sentence you to time served,
2 days.
2 days with 2 days credit, and I'll impose court costs and a $50 cost of prosecution. That's a total of $301. And I'll give you 24 months to get that paid.
It will be. Thank you so much.
All righty.
Okay, thank you.
All right, your name, ma'am?
Leah Augusta.
All right, ma'am, you're here today because you were arrested for the charges of robbery and felony battery. I've read that was based off of a probable cause warrant. The bond on the robbery is $5,000 and the battery is $2,500. And I'll appoint a public defender to represent you on those charges. You were out on a no valid driver's license and the bond on that is $2,000. And that's from Osceola County. Okay?
Are you revoking the bond?
No, I'm gonna leave that in place.
Okay.
Okay.
Your Honor, are there any conditions on?
Yeah, ma'am, on that, on the bonds is no drugs, no weapons, no guns, no alcohol, and no contact with the alleged victim. Okay. Did Julio Vega bond out? He was in the traffics too, a DUI?
You're welcome.
Or no, a Dwellis? Julio Vega?
What's the inmate number, Your Honor?
It is 2201-2558.
He bonded.
Yep, he bonded. Your name, sir?
Stuart Bailey.
All right, Mr. Bailey, you're here in 2 cases, 2022 CF 6301 AO and 2022 CF 917 AW. In the 2022 CF 6301, you're arrested on charge of grand theft motor vehicle. I have reviewed the charging affidavit and I do find that there's sufficient probable cause. Bond will be set in the amount of $1,000. And I'll appoint a public defender to represent you on that case. In the 2022 CT 917 AW, you're arrested on charge of no valid driver's license. And I'll set bond, I'll reduce that bond from $500 to $100 and appoint a public defender on that as well. Your name, sir?
Edwin J. Bellamy.
Mr. Bellamy, you're here for 2 cases. First of all, you're in case number 2022 CF 5658 AO. You're arrested on a charge of aggravated battery on a pregnant person. That was based on a probable cause warrant that was presented to a judge. I do find that there is sufficient probable cause. The bond on that is $5,000. If you do bond out, you're not to have any contact with
Wanda Marie Bratcher.
Yes.
BRATCHER.
For who?
Somebody.
I don't even know what it's about. Mm-hmm.
Okay, so that's good. No contact with her, all right?
So who?
Wanda is a woman that allegedly you went up to outside of a store
Huh?
last August,
Last August.
August 2021, yeah, August 20th, 2021, all right? So that's that case.
August 2021.
Yeah, so you're not to have any guns or weapons or drugs or alcohol if you do bond out. And then in the other case, it's in 2022 CF 6315 AO, possession of cocaine.
Your Honor, I
Yep.
just have a PC challenge.
Okay.
I would just argue, no PC to possession of cocaine. I believe it was 3 individuals on a sidewalk. Although the bag was in arm's reach, there's no indication that the bag belonged to my client. When I read the arrest affidavit, there's no indication that an ID was found in the bag, or that it was in fact my client's bag to begin with. So I just argue no PC.
State, any response? It is within his dominion and control when it's within arm's reach, which is what's required. I mean, at a minimum level, that's what's required.
Yes, Your Honor, I would agree with the court. However, if the court is not inclined to find probable cause, I would ask for 24 hours for more clarification if necessary.
No, I'm gonna find that there's sufficient probable cause on that, and, but I will, I'll set the bond at 500 on that one, and appoint a public defender in both cases. Defendant was also out on bond on a possession of cocaine, possession of alprazolam, and, I'll revoke that bond and set no bond.
Your Honor, I would ask that you not revoke. He was arrested March 18th. To date, the state has not filed any formal charges, and we're in June, Your Honor.
That's not filed on?
No, Your Honor, not at this time.
All right, I'll take no action.
Well, I got a question about the what is this, the 2021 case you're saying about it, like?
Yeah, that's got a bond, that's 5,000. The other one's 500. You got a public defender on both of those. In the case that you're out on bond, I took no action. Don't make me regret that. All right, so you got a lawyer on both those cases. Just keep in contact with them, okay? All righty. Your name, sir?
Eric Barrios?
Mr. Barrios, you're here today because you're arrested on a probable cause warrant for the charge of grand theft 3rd degree. And the bond on that is $1,000. I will appoint a public defender to represent you.
Yeah.
Your name, sir?
Patrick Braswell.
All right, Mr. Braswell, you're here today because you're arrested on a probable cause warrant for the charge of fleeing and attempting to elude. I have read the charging affidavit, and I agree. State want to be heard as to. As to the bond on the fleeing and attempting to elude. Is that the bond schedule? No bond on a fleeing attempting to elude?
You said it, Your Honor.
No, that was set by Judge Laurent.
No. I apologize. You said it at IAs. It usually comes in at no bond and then it gets set at
That's what I'm
IAs.
saying. Is that what the schedule is?
I can take a look. Your Honor, I'd ask for 7,500.
I was thinking 5, so I'll do that. I'll set bond amount of $5,000. And then as to the case he's currently out on bond on, has that already been filed on? It looks like
Yes.
it's set for something in August.
Pretrial in August. So yes, it has been filed on, Your Honor.
All right, I'll revoke that bond, set no bond on the other case. Appoint a public defender on the new case of the fleeing attempting to elude. Thank you, sir.
And Your Honor, Your Honor, given that, if you look, it looks like he just started his employment. Would you be, he has no failures to appear. Would you be inclined to revoke and double as opposed to revoking and holding him at no
Has
bond?
he failed to appear or anything today?
It does not appear so, Your Honor. But, Your Honor, I would argue that these are both of these offenses are with regard to driving cars, what have you. I don't know when this incident happened, but again, formal charges have been filed. There is a court date that has been set, and this incident for this case, Your Honor, don't have it. Happened last month.
Yeah, this was May 7th, the one that we're here on today.
It looks like, it may be kind of, I don't know, related, Your Honor, because he's referenced in the prior case on May 11th, and even in the arrest affidavit for this case, he's also referenced in the May 11th where he was doing surveillance. He responded back. They seem to be, I don't know. I know if I'm looking.
Yeah, the other case was from
Oh, he's saying as of.
November of 21.
Yeah, he's saying as of that date. That's why I messed up. Yep, I see it.
All right. I'll revoke the bond and set that bond at $7,500 on the case he was out on bond on. There's one motorcycle, so. All right, so it's a 5,000 and a 7,500, and appointed a public defender on the new case, and I assume you already have an attorney on the other. Was there a public defender already appointed on the other case? Yeah. Okay, already. All right, you're all set. Are your name, sir? Mr. Burleson, you're here today because you arrested on a warrant for failing to appear on the charge of carrying concealed firearm in 2020 CF 5976AO.
Correct.
There is no bond on that, and the public defender has previously been appointed. What's that? Blackman. Former defense lawyer. Okay, alrighty. Will do. Yep. All right, I have reviewed the charging affidavit in Ms. Caldwell's case, which is 2022 CF 6300AO. It's found sufficient probable cause, bond set amount of $1,000, public defender appointed.
Your Honor, she does qualify for pretrial release. Could we release her pretrial release? She has no failures to appear.
All right. Yeah,
Any conditions?
no guns, no weapons, no drugs, no alcohol. Quick break? Clerk needs a break. Clerk gets a break. Alrighty. Yep, Various Carter. Your name, sir?
Javaris Carter.
Mr. Varus Carter, you're here today in three cases. First of all, in 2022 CF 6306, you're arrested on a charge of possession of cocaine and possession of cannabis less than 20 grams. I reviewed the charging affidavit. I do find there's sufficient probable cause. On the possession of cannabis, it'd be $1,000, and I'll reduce the bond on the possession of cannabis to $100. In addition, you have two traffic cases. 2022 CT 2991AO, in that case, is a no valid driver's license. There was sufficient probable cause, set bond of $100 on that. And in the 2022 CT 2992, which is no registration, $100 on that as well.
Your Honor, he
Yep.
qualifies for pretrial release. I would ask for pretrial release.
Okay, I'll do that. PTR on all of those. Want a public defender. And are the two, probably not because they're consecutive numbers. The two CT cases, 2022 CT 2991 and 2992. What division is the 2991? They are, okay. All right, let's make sure to do that. All right, perfect.
Any
Point of public defender.
conditions, Your Honor?
Yeah, no drugs, no alcohol, no guns, no weapons, don't operate a motor vehicle without a valid Florida license.
Thank you.
Your name, sir?
Kenneth Jukes.
All right, Mr. Chooks, you're here for a couple of things. First, in 2022 CF 6296AO, you're arrested for the charge of grand theft motor vehicle. I have reviewed the charging affidavit, and I do find that there's sufficient probable cause set upon that case of about $1,000, and will appoint a public defender. You're also out on bond in two cases in 2021 CF 14397, looks like AO. Was that a failure to report for a sex
Yes.
offender? Yeah. All right, I'll revoke that bond, there'll be no bond on that. And then in case number 2021 CF 18244,
2022 CF.
2022 CF, excuse me, thank you. 2022 CF 1824 AO, possession of firearm, convicted felon, possession of firearm. Then I'll revoke that bond, there'll be no bond on this as well. Point of public defender, although actually it looks like it's,
He has
yeah,
Leon.
there's already conflicts, but we'll have to straighten that out, okay? Point of public defender cases that he doesn't have a lawyer.
And did
The
you
no
do a
valid-
bond on the no motorcycle
no.
license charge?
On which one?
He has a no motorcycle license charge. A new law offense.
Yeah, where, I don't see that. Did they just give him a ticket, or did, because it looks like on the charging affidavit, it just has the grand theft.
No, they charged him.
They didn't just give him a citation, because I don't have it. What's the case number?
I wouldn't have the case number. I have the police case number and the citation number, but usually the traffic numbers are given like later that we don't have.
Yeah, do you have the citation? As soon as they file, I mean, I assume if it's on here, they must have filed a citation, and that should have resulted in it.
It says he was issued a criminal uniform traffic citation.
It's 2201-2514. All right, in 2022 CT 2989 AO, it's up on $100. Point of public defender. All righty. Name, sir?
President Duggar.
All right, Mr. Duggar, you're here today because you're arrested on a probable cause warrant for the charge of armed burglary of a conveyance with the firearm. Have you that? It does appear to be correct.
I can't hear you.
I reviewed this is a probable cause warrant. So in other words, it was presented to a judge already and they found probable cause. State want to be heard as to bond.
Your Honor, it is a first-degree felony that is punishable by life.
So you would say you don't want a bond. Is that what I'm hearing?
Your Honor, he obtained the gun from breaking into other
Yeah.
vehicles and then continued to break into vehicles,
Right.
allegedly.
Oh, that's right, okay, I did read that one. All right, I'll set bond the amount of $15,000, no guns, no weapons, no drugs, no alcohol, and appoint a public defender. Hold on just a second, let me see.
Hold on. Vaccine.
Oh, yeah, Oh, yeah. So there's other conditions, no contact with any of the co-defendants and no contact with the witnesses or victims in the case. Okay?
Yes, sir.
All righty. Your name, sir?
There it is, Garrett.
Hi, Mr. Garrett. You're here today in case number 2022 CF 6293AO, 6293AO. You're arrested on a probable cause warrant charging you with possession of a weapon or ammo by a convicted felon. Again, that is not a case in which it should be no bond. That's not,
No?
I don't understand why that they're signing. He's magical, man. That guy, we need to talk to that guy. Everything you can do wrong, he has done wrong. From this weekend, I mean, he reset stuff that wasn't supposed to be reset.
I was about to ask who the judge was, but never mind.
Yeah, no. I mean, okay, anyways, does the state want to be heard, Esteban?
No, Your Honor.
I'll set bond the amount of $2,500 and appoint a public defender to represent you.
Thank you, sir.
No guns, no weapons, not to possess any guns or weapons while you're on bond. Your name, sir? All right, Mr. Gordon, you're here today for, in case number 2021 CF 8985AO, in which you had failed to appear. And the bonds on that are no bond for the failure to appear. That was on the possession of cocaine, possession of you alone. All right, and you already have Mr. Baird from RCC as your attorney. Name, sir?
Fedna Greer.
Mr. Guerrero, you're here today because you're in case number 2022 CF 6295AO. You're arrested on 3 charges: possession of cannabis more than 20 grams, possession of cannabis with intent, and possession of drug paraphernalia. I have reviewed the charging affidavit. I do find that there's sufficient probable cause. The first 2 counts, bonds are stated at $1,000 apiece, and the possession of drug paraphernalia reduced that to $100 bond. And you were out on bond for a carrying concealed firearm, possession of cannabis less than 20 grams.
I believe tomorrow would be a month.
And again, Your Honor, everyone knows FDLE takes more than 30 days in order to determine what a drug is.
However, he also has to carry in a concealed firearm that hasn't been filed on either.
They like to be efficient and file them at the same time.
But my argument would be, if you are inclined to revoke, you revoke and double.
All right, I'll revoke those bonds. A new bond of $5,000 on count 1 of that, and $250 on the new count on the second count. All right, and appoint a public defender in the new case. Your name, sir? All right, Mr. Jones, you're here today in case number 2022 CF 520AO. In that case, you're arrested for failure to appear on a grand theft case. Bond is set in the amount of $2,000. Looks like you already have a public defender, I think, in that case. Yeah. All righty. Thank you.
Your Honor, he has a new law offense.
Does he?
22 CF 6313.
And an add-on bond case.
Oh, okay. 2022, also, Mr. Jones, 2022 CF 6313AO, you're also in on a new case, arrested on a new charge, several charges, actually. Count 1, possession of methamphetamine with a weapon. Count 2, carrying concealed weapon. Count 3, resisting without violence. Count 4, possession of drug paraphernalia. And count 5, possession of cannabis less than 20 grams. I do find sufficient probable cause to reading those. As to count 1, possession of methamphetamine, bond set amount of $2,500. Carrying concealed weapon, $500. Resisting without violence, $500. Possession of drug paraphernalia, reduce that to $100. And possession of cannabis to $100. And I'll appoint a public defender on that case. And finally, you were out on bond.
And Your Honor,
Yep.
he was arrested January 15th of this year, and to date, the state has not filed any formal charges, so I'd ask that you take no action.
State objects.
On possession of cocaine.
And we're in June, Your Honor.
I'll take no action on that one. We got plenty on the other stuff. All right, and that'll be all. That's it, Mr. Jones. Your name, sir? All right, Mr. Langston, you're here, first of all, in 2015 CF 10167AO. In that case, you had previously failed to appear. And that's a possession of a controlled substance, possession of drug paraphernalia. There is no bond on that. And then you also have 2022 CF 6312AO. And in that case, you were arrested on charge of possession of methamphetamine and false information. I'd have reviewed the charging affidavits and do find sufficient probable cause. As to count 1, a bond of $1,000, and count 2, $500, and appoint a public defender in that case. Thank you. Your name, sir?
Good afternoon.
Afternoon. Your name?
Avery Lance.
Mr. Lance, you're here today because you were arrested on a charge of trafficking in cocaine greater than 400 grams and fleeing and attempting to elude an officer. I have read the charging affidavit, and it does appear that there's sufficient probable cause. Bond on the trafficking will be $250,000, and on the fleeing attempting to elude, $5,000. Did you want to have a lawyer appointed, at least in the short term? I mean, if you want to hire someone, you can, then they can withdraw.
I could, yeah, lawyer. I could get.
Okay, so you don't want me to appoint a public defender for you today?
Yeah.
Okay, I'll appoint a public defender, and then if you hire somebody, you can always have them withdraw.
Your Honor?
Yes.
In addition, can I ask that defendant be, comply with Florida statute 903.046, sub 2, sub F, and that is with regard to verifying the source of funds for his bonds, please. If he could just verify those are.
Yeah, if he does
Right from him.
attempt to post the bond, he'll have to verify the source.
Thank you.
Pursuant to Florida statute. All righty, sir, you're all set? Thank you.
All right.
I did. He said he did want one eventually.
Okay.
Your name? Your name, ma'am?
Javette LaPointe.
Hi, Ms. LaPointe. You're here today because you failed to appear on a charge of prostitution. And there is no bond on that capias. And I think you already have the public defender. Okay, so you need contact with your lawyer.
No.
I'm listening.
Your name? Oh, we're all set? We're done. She can go.
We're done. He
Yep.
said she can go.
We're set with her. All right, your name?
Sardell Leonard.
All right, Mr. Leonard, you're here today for a couple of things. First of all, in 2022 CF 6302AO, you were arrested on a charge of grand theft third degree, more than 750, less than 5,000. And I do find that there's sufficient probable cause, bond set in the amount of $1,000 on that charge. And second of all, though, you're out on bond on a domestic violence battery charge. I'll revoke that bond, and there'll be no bond. You'd be held without bond on that.
I would ask that you take no action on the out on bond. He has been deemed incompetent to proceed in that case.
I assume if he's out on, then he's out on a $500 bond. I thought he'd be out on a control release plan.
From what I saw, he just had a recent evaluation done. We had an evaluation done by data evaluation in November of last year. Then there's another one that was done prior to that in 2019. There was another evaluation just done July of last year as well. He's been deemed incompetent to proceed. I believe Shoemaker ordered his evaluation.
February 11th, he was released. Conditional release.
Another one.
So you didn't add any condition of him not. All right, I'll take no action on that.
Your Honor, with regard to the new law, can we have no return, please?
Yes, where's it, where's the no return to?
Walmart, located at 3101 West Princeton Street.
All right, so, Mr. Leonard, you're not to go back to the Walmart, okay? If you go back to the Walmart, and that's a violation of your release, okay? And appoint a public defender. All right, your name, sir? Mr. Lord, you're here in 4 cases, or no, actually, it's 3 cases. First of all, in 2019 CF 761AO for failure to appear, then there are 2 counts in that, and there's no bond on both of those for failing to appear. 2021 CF 6152AO, failure to appear, there's no bond on that. And finally, 2020 CF 1259 OAO, and that's also for failure to appear, and there is no bond on that. And appoint a public defender if the PD was not previously appointed. Your name, ma'am? Pardon?
Ellie Lynch.
All right, Ms. Lynch, you're here for 2 things. First of all, in 2022 CF 6316AO, you were arrested on 2 charges, possession of alprazolam and driving while under the influence. I have read the charging affidavit, and I do find there's sufficient probable cause in both of those. I'll set bond amount of $1,000 on the possession of alprazolam and $500 on the DUI. In addition to that bond will be that you not use or possess any drugs or alcohol, and that you not operate a motor vehicle without a valid Florida driver's license. Now, in addition, you were out on bond. In case number 2022 CF 688AO, fraudulent use of an identification. Looks like, did they not charge the rest of those, or those, no, trafficking, grand theft, possession of unauthorized driver's license, fraud, in a prescription, uttering a forgery, false proof of motor vehicle insurance. So I'll revoke that bond, and there'll be no bond on that. And I will appoint a public defender to represent you. Are your name, sir? All right, Mr. Masters, you're here today in case number 2022 CF 5696 AO with 3 charges, battery on law enforcement officer, resisting with violence, and a battery charge. I have reviewed the information. This was from a probable cause warrant. And the bonds that have been set are $2,500 on the battery on an officer, $2,500 resisting an officer without violence, and $150 on the battery.
Your Honor, he qualifies for pretrial release.
He does, okay.
Pretrial release.
All right. Raise your right hand, please. Solemnly swear the testimony about to give you the truth, the whole truth, and nothing but the truth to help you God.
I do.
Your name?
Clyde Masters.
All right. And how are you related to Mr. Masters?
I am his father and legal guardian when he turned 18, sir.
All right. And what is it that you wanted to tell me?
Have a document of his diagnosis from the psychiatrist and proof of my guardianship.
Does he live with you from time to time, or does he live with you?
He lives in a group home for other disabled people. I do have him on weekends pretty much about 50% of the time.
Here's the problem. If he gets out, where will he go now? Because he's not going to be able to go back there at this point in time for sure. Now, it may be at some later date, he may be able to return to that facility, but one of the conditions, if I release him, if he bonds out, will be that, first of all, he's not going to be able to have any contact with, I think the gentleman's name was Donovan Terry. And it also required no return to that Timber Ridge Trail address, which I assume is the home. So where else can he go?
So, what I would like to see happen is number one, I understand that he has to be somewhere until his medications are adjusted. And I was hoping that we could come to some kind of settlement on what that would be today.
Well, I can't, there's not anything I can do about that. In other words, the jail will do what they do. If they feel he's to be medicated, they will medicate him and they'll give him what's appropriate. I can't order them to provide something else. But my concern is that if he's released, he's not, again, the order will be that he not return there, at least on the short term, because I'm going to assume that the state's going to request that as well.
Well, then what are the options? And the thing is, I don't think he needs to spend his time in jail. That's not going to help him or us.
No, and I'm not suggesting that. I'm suggesting that there needs to be a place for him to go that is not the scene of where this allegedly occurred. That's the problem. Because if Donovan Terry were here to say that he doesn't have a problem having contact with him, that might be one thing. There's some people waving their hands in there. Who are they?
Donovan is not an employee at that home any longer.
Is that a person who lives there?
He's one of the staff members.
Okay, well, that's what I mean. He's
no longer there, sir.
Well, I don't know that. He's not here to tell me that. That's the problem. Okay, I understand that that's what you're telling me. I don't have a reason to disbelieve that, but I can't just allow the person who allegedly battered him to come back, because if you're incorrect or your information has been that you got was misunderstood, I can't send him back there. I can't allow him to go back there right now. So that's the issue. I don't have a problem with, he qualifies for pretrial release. I'd release him pretrial, which means it wouldn't even require a bond. But he can't go back to that facility right now. I expect that they probably don't want him back right now. Unless there's someone from the facility to say, listen, he can come back. We want him back. Who are the people who come into the room?
Sorry?
Oh, okay.
Hi, Glenn Demers.
Raise your right hand. Solemnly swear the testimony you're about to give you the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
Okay.
My name is Glenn. I'm the group home manager where Justin resides at. I can say that Donovan Terry no longer works for the facility as of September of last year.
And has has Justin been living there up until just now?
Yes, Your Honor.
So this allegedly happened in April of last year.
Yes, Your Honor.
Has he been there without any difficulties or any problems since, for the last year?
Your Honor, he's been Baker acted several times. He's struggling psychiatrically right now.
Okay, well, I'm talking about whether it caused problems with the staff or involved in anything along this line.
Yes, Your Honor, he's had issues like this, correct.
But you don't have a problem with him coming back there?
I would like him to go to a facility to be Baker acted first.
That's a problem. I can't order that take place. That's gonna be the issue. I mean, I can't say, all right, if you release him and then take him and to be Baker acted, that's not within my abilities. If he is in a situation where he needs to be Baker acted, then.
Well, last night, initially, this is what happened. We were attempting to Baker act him, and then we found out about the warrant. So I don't think he's actually had the.
Okay, well, so whatever it was that you were doing for the Baker Act then, I would assume that those conditions remain, so you can still go through that process. But I can PTR him and allow him to return back there. I'll still order that he not have any contact with Donovan Terry. Doesn't sound like that's gonna be a problem because he's not working there anymore.
Yes, Your Honor.
In that he have to abide by any of the rules of the facility, that he not possess any guns or weapons, that he not possess any alcohol or drugs other than that's prescribed for him. And, I mean, that's really all I can do.
Okay, Your Honor.
But you have no problem, and you're the head of the group home, for lack of a better term?
Yeah, I'm the group home manager. I do have people above me.
Okay. All right, then what I'll do is I'll release him PTR. What that means is there are conditions. He has to phone in and there has to be checking, and so I assume that somebody there will take care of that, okay?
Yes, Your Honor.
Because it doesn't sound like he's necessarily gonna be available to do that. And then, no contact with Donovan Terry, abide by the rules of the group home. So, Mr. Masters, you have to follow the rules, okay? Yes, sir. All right, you do that and not get into trouble. And look at the fact, they're here. They came here to argue for you, okay? So when they ask you to do something, they're probably looking out for your best interest, right? They're here for your best interest today. Okay, so you gotta try to think about that, all right? So I release your PTR, and you gotta follow their rules. That's the number one thing that I've told you. Okay? All right, thank you.
Thank you, Your Honor.
Thank you, guys.
Your Honor, just for state's clarification,
Yep.
you then withdrew or you removed the no return?
That's correct, yeah.
Okay, thank
Since
you.
the representative from the facility said it's okay. But no contact, but that shouldn't be a problem if the guy's not there anymore. Okay. Your name, sir?
Joseph Morris.
All right, Mr. Morris, you're here in two cases. First is 2022 CF 1993AO, and in that case, you would fail to appear on a grand theft charge, and the bond on that failure to appear is $2,500. And second of all, you have 2022 CF 6317AO, and in that when they arrested you on the warrant, they arrested you also for a charge of possession of cocaine, and I have reviewed that, and there is sufficient probable cause. Bond set in the amount of $1,000 on that charge, and I will appoint a public defender on that new charge. So I have a lawyer on both cases. Your name, sir?
Eric Parrish.
Mr. Parrish, you're here today because you're arrested on 2 counts.
Yes, Your Honor.
And that was in 2022 CF 6288AO. He doesn't?
Sir, there are certain, I guess, complications of my circumstances, sir.
All right. I do find sufficient probable cause. Set bond on the burglary of an occupied structure at $3,500, and the criminal mischief I reduced to $100. And you do not qualify for the public defender. You make $50,000 a year, is that correct?
No, I work independently, sir.
What's that?
I work independently.
Okay, so your annual salary averages $50,000, or you're at $50,000?
Actually, but it could depend, I guess. But I'm not in the well. I'm not at that state of income currently because.
Okay, well, that's the point of this form is we ask you, what is your current, what are you making? When you were out before you were arrested, what were you making? How often were you paid and what was that amount?
I work for my church, and I work independently, so I work by different kinds of opportunities and also by nonprofit. So I gather a lot of depending, and let's say I could get to 30,000 a year. I could get depending stuff like that.
What was your last check that you got from the church that you work for? How much was it?
Last check. Let's say I remember.
So the last time you got paid was November?
November.
Is that what you just said? Or did you say remember?
I could remember.
Okay.
I guess it would be. I guess possibly to close to a few thousand.
So $2,000. That was the last. Let's say the last check. And how often do you get a $2,000 check?
Well, you know, I work. You know,
I understand that it's a gig type thing, but what do you if you work for them a little bit every month?
It's varied. It's varied, I guess you would say. So
Okay.
It's not a definite figure.
What did you pay taxes last year?
No, I don't. I work with the church independently, so I don't pay.
Well, it doesn't mean you're not supposed to pay taxes. That just means it's harder work because you're not taking any taxes out of your paycheck. You got to do it yourself. So did they give you a 1099 from the church and tell you how much you made last year?
No, I didn't work with the church in that kind of, you know, as it's, you know, I worked in.
All right,
kind of private.
I can't get in. I can't get a handle on it. You wrote 50,000. You signed it. I'm going to take that as the case. You make too much money. I can't appoint a public defender.
Well, sir, I was kind of under the impression of a different kind of question.
Okay, I understand that, but you can't tell me. You're not even telling me what you do make. I need to know how much you make. What do you make? How do you live?
Well, I'm saying possibly an average of 30,000.
So 30,000. So it's not 50. It might be 30 for a year. It's still too much. Do you have another answer? 30,000 is too much still for a public defender.
Yeah. Well, how am I supposed to be able to afford a public defender?
Your Honor, in his, it looks like in all of his cases, he's had the public defender.
Is there an affidavit in those cases? Does it show a number?
That's what I'm about to see.
Because now's not the time to big dog it. Now's not to say, you're not going to impress us that you make a lot of money or that you don't. That's not what it's about. Hold on, let me finish. Now is we just need to get to see whether or not you qualify. Not everyone can have a public defender because if they did, then there would be no reason to hire an attorney, right? Because you can just get the public defender. It's only for truly indigent people. And so that's why we need that information is to determine whether or not you're indigent. My expectation is that you're working for a church, you probably don't rise above the level. 30,000 is probably even high because churches, you know, they don't make a lot of money either. So my expectation is that you probably do qualify. That's why I just need to get to that to get to a real solid number. You're just saying, well, I think I make this, I think I make that. If you make $2,000 a month, and that's high for you, so it might be less, you would qualify.
3,000 a month is what I've usually.
3,000 a month is too much.
3,000 a month.
That's 36. 30 was already too much.
There is I'm reading competency issues, Your Honor. That may be.
Oh,
Why, Your Honor?
Sir, I'm here on behalf of my church as a Seventh-day Adventist.
All right, I'm going to appoint the public defender just because he's had the PD before, and I think I agree that there potentially is some comp issues, and if we don't have a lawyer in the case, he's going to be in jail.
Resolving this case, resolving the matter. I don't want to just waste time in here or waste time with procedures or anything like that, sir.
We've had him evaluated before, Your Honor. There's competency.
Yeah, I agree. I'll appoint you a lawyer, okay? Bond set in $3,500 as to count 2, the burglary, and $100 on the criminal mischief.
Your Honor, sir, may I ask a question, sir?
Yeah. One more question.
Excuse me?
Go ahead, one more. You got one. Go ahead.
Is it possible to procedure bond at this time?
What does that mean, to proceed my bond?
Procedure, to proceduralize, or to process, to go with the bond, I forget.
Can you bond out? Yeah, sure. It's,
Actually, he has a hold for his state
Oh.
probation, Your Honor.
for where?
There is a violation of probation, I don't know if it's been
He's a
violated yet.
VFOSC, and they're gonna complete the BOP, so he's not getting out.
Oh, there's a hold on you, sorry. I was,
That's his. Yeah, that's his. He has.
All right.
okay, all right.
Thank you very much, sir.
Okay, take care. All right. Your name, sir?
Say Dominic Ross.
All right, Mr. Ross, you're here for, looks like, 1, 2, 3 different cases. In 2021 CF 7129AO, that is a probable cause warrant charging you with burglary of an occupied structure and petty theft. Bond set in the amount of $2,500 on the burglary of an occupied structure. I'm going to reduce that bond on the petty theft to $500, and appoint a public defender to represent you in that case. As to 2020 CT 7157, hold on, where is that? There we go. That is for failure to appear on a no valid driver's license in front of Judge Allen. And bond is set in the amount of $1,000 on that. And then finally, in 2021 CF 7129AO, that is also a probable cause warrant, 2 counts in that, a petty theft and a
Your Honor?
What's that? Did I already say that one?
Yes, you've already.
Yeah, the
said
other
that
one's a
one.
failure to appear. I'm sorry, 2020 CF 14639 is a failure to appear, and there's no bond on that. And I'll appoint a public defender on the new case, or if they're, oh, well, yeah, those are, none of them are new.
Your Honor, with regard to the new case, are there any conditions like no return?
Oh, yeah, no return, no drugs, no weapons, no alcohol. No. Is that the 21 CF 7129? Yeah, don't return. That is, hang on just a sec. I'll get that for you. To the 11565 University Boulevard, and that's the Cold Stone Creamery, where the alleged burglary took place. No contact with victims, no drugs, no alcohol, no guns, no weapons. All right? Okay, Rodriguez bonded. All right, sir. Your name? Mr. Schubert, you're here on 2 cases. In the first case, you were arrested on a charge for 3 charges: possession of fentanyl, possession of methamphetamine, and possession of drug paraphernalia. I read the charging affidavit. I do find that there's sufficient probable cause. As to the possession of fentanyl, it'd be a bond amount of $1,000, possession of methamphetamine, $150, and possession of drug paraphernalia, $100. And you were also out on bond in 2022 CF 4472AO.
Yes.
In your honor, the state has not filed. My client was arrested back in April
They haven't filed on that yet.
and he was arrested in both cases, 2022 CF 44748 back in April, and again, neither case has been filed on today.
So one's a grand theft, criminal mischief, and the other's grand theft, criminal mischief, possession of methamphetamine, possession of drug paraphernalia. So there's 2 cases?
Yes, your honor.
20, it's about a month and a half. All right, no action. Your name, sir? All right, Mr. Smith, you're here today because you, in 2022 CF 6275AO, You're arrested on charge of possession of cocaine, possession of drug paraphernalia. I have reviewed the charging affidavit. I do find sufficient probable cause as to the possession of cocaine, bond set in the amount of $1,000. I'm going to lower the bond on the possession of drug paraphernalia to $100, and I'll appoint a public defender for you to represent you. All right? Thank you. Your name? All right, I have reviewed the affidavit in 2022 CF 6294AO. Set bond count 1, carrying concealed firearm, $2,500. Count 2, petty theft, $250. Appoint a public defender to represent. And revoke the bond in 2021 CF 3012, no bond.
Your Honor, can I ask for a no return?
And no return.
No firearms?
No firearms, no weapons, no drugs, no alcohol. Your name, sir? Your name? All right, Mr. Tillman, you're here today because you're arrested in 2022 CF 6314AO. And in that case, you're arrested for possession of methamphetamine, ecstasy. I have reviewed the charging affidavit. There is sufficient probable cause. Bond set in the amount of $1,000, and I will appoint a public defender to represent you on that. A condition of bond will be that you not possess any drugs or alcohol. As to case number 2022 CF 4268AO.
Your Honor, the state also has not filed. My client was arrested April 16th, and the state has yet to file formal charges. So I'd ask that you take no action.
So we got ROR on those. Was that because it was a 33?
Well, it was bond and ROR.
Oh. Okay. Okay, no action. Tearing me down. All right. Your name, sir? Mr. Vasquez, you're here today because in 2022 CF 6308, you're arrested on charge of possession of 20 grams or more of cannabis and possession of cannabis with intent to sell. I have reviewed the charging affidavit. Do find that there's sufficient probable cause. Set bond amount of $1,000 on count 1, $1,000 on count 2, and I'll appoint a public defender to represent you. Your name, sir? Your name? All right, Mr. Williams. You are here today because you're arrested for failing to appear.
No, Your Honor.
Is it failure to appear? No. Looks like it's a new charge. You're arrested on a, oh, that's what it was, on a probable cause warrant for the charge of trafficking in 14 grams or more of, what did they file that as? Hang on. Oh, okay. I see what happened. So this is a refiled case.
Yes, Judge.
All right. 'Cause originally the case had been null prost. All right. That's why it didn't make sense when I was looking at that.
Yeah, he had bonded out early on the same charges.
All right. And so the refiled information has, I guess, one count on it, according to the arrest affidavit, and that is the trafficking in fentanyl, 14 grams or more, on the refiled information. Is that correct, State? Am I?
Yes.
Got that right? Okay.
That's correct, Judge.
All right. Did you want to be heard, counsel?
Yes, Judge, I was just asking, first of all, Tim McLean on behalf of Derek Williams, who was present and standing to my right. Judge, I would ask that the court at least give him the same bond that he posted. I think it was $150 bond, I think, the last time. He had actually posted bond on these cases. We was in front of the judge getting ready to plea. well, we had set a plea. Actually, it was a negotiated plea with the state, and they backed out, and we were gonna plea the next morning in front of the judge, and they showed up and no prosed the case. And I think it was because they didn't have a lab report as to the fentanyl, but he did in fact bond out on this very same case back in January, and never failed to appear in court, and was.
So it looks like in January, it was a possession of cocaine and a possession of drug paraphernalia.
Yeah, but he was arrested on all these. He was arrested on all this child endangerment and it was trafficking in fentanyl. There were several charges he was arrested on. And I think the bond was $1 million. I don't know why the state didn't file the trafficking. Just, but pursuant to the allegation, the amount was there. It seemed to be an oversight, but nevertheless, he still bonded out. And he's having to be arrested again and bond out again based on their mistake.
Yeah, so they only filed on the possession of cocaine and the possession of drug paraphernalia.
Right.
Yeah, and
Originally.
on this case, in January of 2022, what the attorney is saying, he was only arrested on possession of cocaine, possession of drug paraphernalia, neglect of a child, and another possession of drug paraphernalia. He wasn't arrested on the trafficking charge.
I think he was.
No, he wasn't.
Yeah, he was.
On the
According to the,
trafficking?
if you
Yeah.
look at the original complaint,
The original complaint, he was arrested on the trafficking.
trafficking in cocaine, 50,000,
Yep.
trafficking in fentanyl, 1 million,
Yeah, he was arrested.
neglect of a child, possession of drug paraphernalia.
Right.
And then that was January 12th when that was filed.
Oh, it was filed on, but that's not what he was arrested in IMS on.
No, that's what the complaint, that's what he's arrested for.
Yeah, that's.
And if you look on the original, and I'm looking at the first appearance information sheet from January, it has them all listed on there. Trafficking cocaine, trafficking fentanyl, neglect of a child, possession of drug paraphernalia. And then for whatever reason, the state, their information they filed in February only had the possession of cocaine and the possession of paraphernalia.
Right. And we were set to plea in front of the plea to the bench on those cases, and they showed up in no problem.
And there was a bond motion filed in February. And February 25th, Judge Navarro set bond at $1,500 on the possession of cocaine, $150 on the possession of drug paraphernalia, and deleted bonds on any uncharged counts, which were those counts.
But my point is, Judge, he sat in jail that entire time because of these same charges.
But now what we're looking at is they null-prossed those 2 counts, but now we're back on a refiled information and it was a probable cause warrant for the other charge that didn't get charged, the trafficking charge that didn't get filed on. Because we're not really sort of in the same situation as we were before.
But Judge, he spent 45 days in jail on the first arrest because the bond was $1 million,
Right. I get it. I mean, he was arrested on the charge.
right?
Then at some point, the state, for whatever reason, did not file on, except for the possession of cocaine. So they didn't file on everything, file on possession, cocaine possession. So then subsequent to that, the bonds were reduced to that 1,500. And then for whatever reason, subsequent, my guess, if I had to hazard a guess, they either got something from FDLE prior to that, or they said, we're not gonna take a plea on a possession of cocaine in fear that it may have attached jeopardy, which I don't think it would have, but not with those charges because they're not lessers of that. And I think potentially it still was chargeable, but I think in abundance of caution, my expectation is that they null prossed it instead of allowing you to plead to something under that case
That's
number.
what happened, Judge.
And now we're back because they have asked for, they refiled it as just the trafficking case and have let everything else go to the wayside. So they've sort of flipped to the other side of the coin that they were working with before.
And I guess my argument is, Judge, that it's the same case. He should be arrested once and should, whatever bond he paid or was subject to, he should be deemed satisfied. And he should be allowed to continue his case out on bond as it was, simply because the state made a mistake in filing or not filing. He should
But had they not made that, it would have been, it was $1 million bond. I mean, my point is that the bond that he posted was not on this charge. And it was not, it's not even, the only relation is that they were arrested at the same time. In other words, it's not that he was charged with possession of fentanyl or something, and then they null prossed the case, and then instead of it being a possession, now it's a trafficking, but it's the same drugs. It's different drugs, it's different charges in there.
But I think the point is, I'm making, he was arrested on these charges, and he had a substantial bond.
Well, he had a $1,500 bond.
$1 million bond at first, and we
Well, sure,
spent
I
45
understand that,
days.
But I mean, that's the kind of the point, is they never filed on that case.
Yeah, they never filed on that case.
So once they filed whatever it was, then that bond didn't apply. Now, I think that's a good argument to say that whatever credit that he had before, obviously, he's entitled to that credit for time served against anything that may result from this. But I don't know that that really, to me, logically would say, well, the court's in some way precluded or as bound to not impose any bond more than that $1,500. That $1,500 was a bond that would be for possession of cocaine, not for the trafficking charge. I mean, usually the situation we have with this, for example, in county court would be a DUI that for something happens, they don't have a witness, they null pross it the day of trial, and then they refile it, and it's not different. It's the same charge, and so the person was bonded out, and usually I would say, well, we're not going to, make them bond out again. This is not the same situation because it's different charges.
No, but I guess what my point is that initially he was arrested on these charges under $1 million bond.
Right.
Couldn't post it. He sat in jail for 45 days.
Right.
State didn't file. So my point is that arrest and that sitting in jail for 45 days, I know he can get credit for time served,
Right.
but it should be deemed sufficient to satisfy the bond requirement. He was going to court each time, and I just simply think that he should remain on bond. He didn't fail to appear. He was there every time we had court. He was ready to plead. And I think we should just allow that case to continue as it was, because the state just simply dropped it in order to refile the exact same case. It might not be the same charge, but it's the exact same case.
But I mean, and I understand what you're saying, but my response to that is that, yes, he did, but he didn't bond out when they still were potentially going to go forward on this charge. So we're sort of back in that same situation, because now they are going forward. But and so the fact that he was in jail, and now I think that had there been a bond reduction, before they filed the information and didn't file on the trafficking, I might have a tendency to agree with you. I'd say, well, whatever the bond was, if they reduced it from 1 million down to, let's say, 25,000, something along those lines, then I would say, okay, logically it makes sense. It's the same charge, so therefore, you know, to seek more would seem to be punitive. But in fact, as soon as they did not file on that case and they were not seeking anything on that case at that point in time, then that bond didn't count anymore. Then Judge Navarro deleted those bonds.
Yeah, but I think they got the benefit of having him stay in jail for 45 days from an arrest based on that charge because he couldn't bond out. And now he's back before again. They're getting a second bite of the apple to arrest him again.
But if they had filed a charge, he would either be, if he didn't bond out, he'd be in the same situation, right? In other words, he couldn't make the bond then.
Yeah, he couldn't make the bond then.
So if there hadn't a bond motion hadn't been granted, he'd still have been in jail. So it's not like he was disadvantaged. As soon as they didn't file on it and you filed the bond motion, it went away.
No, I'm saying he's being disadvantaged now by having to be rearrested twice, having sat in jail on this same charge previously for 45 days.
Right.
Under $1 million bond, and now they decided to voluntarily dismiss the case, rearrest him again, and now he's facing another $500,000 bond.
But he never made the bond in the first place. So it's, I understand. I see what you're saying, but I think that there's nothing untoward about it. It's unfortunate that, you know, it happened, but it is what it is. You know, that's the state's prerogative to null process or whatever. They filed and again, I assume that what happened was somebody in charging or somebody the line prosecutor looked at it and said, well, wait a second, why is this person pleading to possession of cocaine and we had this other charge? I don't know. I'm going to assume that's what happened. State, do you want to be heard?
Your Honor, I agree with everything the court has said. When Mr. Williams was arrested, there were a number of charges there. However, what the state actually filed on was I believe it's an F3. It was just a possession of cocaine, hence the bond of $1,500, which Mr. Williams posted. And once the case was null pros, that bond was discharged. So actually, as of right now, he's not out on bond. There is nothing for him to continue being out on bond for because the case was null pros. He was never charged with trafficking in fentanyl, so this would be the first time that he is posting bond on this offense. Originally, it was set at $1 million, and I believe at IA's it was reduced to $500,000. Here we are, it's now $500,000.
And what makes me think that it was they thought their mistake was being made is what they filed to get a capias issued. And let's see who signed that. Looks like Judge Roach signed that. Looks like her signature, I think. Was the original charging affidavit, from what I can see. It looks the probable cause supporting document is that original charging affidavit. So that would indicate to me it wasn't like they felt at the time it was null pros. They didn't have, they had some problems with probable cause because they just used the same one to send it back through and say, okay, well here, this is what we're asking for. And my assumption is that they, because they'd only filed on the one, they sent it through, and then Judge Roach issued a $500,000 bond. And that's why we're here today. All right, I'm not inclined to change that at this point. I think that you can certainly file a bond motion with Judge Navarro, and it looks like it'll still be in her division, and see what she feels in the case. Again, had it been, let's say it was a trafficking case and they filed it as a possession and he bonded out and then he came back and now they refiled it as a trafficking, I might be inclined to agree. But I think what's happened here is it's a completely separate, case. It's a charge among the package of cases that they filed.
Well, it's the sex, I think it's the exact
And
same,
actually looking at it.
it's the exact same case, Judge. It's just I was actually in contact with the prosecutor, and
Well, I mean, I understand it all stems from the same arrest,
Right.
without a doubt. Absolutely, I agree with that. But,
with the
and
court,
actually looking at it, what's confusing to me now, it's even more confusing, is count one, it says, is trafficking in 14 grams or more of fentanyl. And then they filed it as possession of cocaine. Count four on the original charging affidavit was trafficking in fentanyl 28 grams or more. So I'm not even certain as to why there would be two separate.
well, since he had a $500,000 bond on the trafficking and fentanyl more than 28, and they've now filed less than 14, the bond, I think the court has the discretion to reduce the bond, and that with that respect, if we're gonna use the same logic we're using to justify him having to post another bond, that they filed initially they filed a far more serious charge, then they filed a lesser in this particular case. So I think the bond should be reduced since it was $500,000.
Well, it was originally $1 million, so it is.
Originally $1 million.
The
And the
Judge
court,
Roach, who obviously you must have considered that. And also, though, I guess it was trafficking in cocaine originally, the count one was 50,000, but it doesn't come up as that.
yeah. But I thought it was
in the
reduced.
Summary, which I'm not sure why that happens. In the summary on Odyssey, it says trafficking in 14 or more grams of fentanyl is count one, but that actually on the charging affidavit was trafficking in cocaine over 28 grams. But I'm gonna stay the bond at 500,000. No drugs, no weapons, no guns, no alcohol, and obviously Judge Navarro is going to be the end result on that. That's going to be up to her. She can make a determination as to whether or not she feels it's appropriate or not.
All right.
All righty.
Thank you, Judge.
Thank you, sir. Somehow I missed it. Your name, sir?
Perrion Wilson.
All right, Mr. Wilson, you're here because you're arrested in 2022 CF 6276AO, and that's a two-count information. Count one is carrying concealed weapon or unlicensed firearm, and count two, possession of 20 grams or less of cannabis. And I do find there was sufficient probable cause. As to count one, the bond's $2,500. I'm going to reduce the marijuana bond to $100, and I'll appoint a public defender to represent you. You're also out on bond in 2022 CF 27521AO, looks like. A possession of cocaine, possession of cannabis.
In your honor, he was arrested back in March 12th of this year, and the state has not filed on that case, so I'd ask that you take no action.
All right, I'll take no action. It's just a simple possession. Okay. All righty. I'll leave that bond in place. And then we have, where is the Portuguese? Good afternoon. Do we have the Portuguese interpreter?
Yes?
Oh, okay. Have you been sworn today?
I'm sorry, this is the interpreter. Are you speaking to me?
Yes, yes, ma'am. Have you been sworn?
No.
All right.
No, I just got this call.
Do you solemnly swear to translate from Portuguese to English, from English to Portuguese, to the best of your ability?
Yes.
All right. And the defendant is in the courtroom. So from now on, you just translate that. Your name, sir?
Qual o seu nome, senhor?
Iago, Felipe, Fialho, Evangelista.
All right, sir, you're here today because you were arrested in 2022 CT 1387AO.
Você está aqui hoje porque você foi preso em 2022?
And in that case, it's a failure to appear in court.
E nesse caso, você precisou aparecer aqui no tribunal?
Your Honor,
Yes.
there was an offer from the state to resolve the no valid driver's license with an adjudication of guilt credit time served.
All right, sir, if you would like to resolve your case today, you could enter a plea of no contest to the charge.
I'm sorry, this is the interpreter. Do you mind repeating if in case he wants to resolve his case today?
Yes, he can enter a plea of either guilty or no contest.
I'm sorry, your voice cut it again. He needs to appeal or?
No, he can enter a plea
Okay.
of guilty or no contest.
Aham. Senhor, se você quiser resolver o seu caso hoje, você precisa entrar com um apelo ou de culpado, ou então de que não tem nada a declarar.
If he does that, I will sentence him to the time that he is served in jail, and there would be court costs of $301.
300. I'm sorry, in this case,
Yes, if he enters a plea, he would be sentenced to the time that he has served, so he would be released, and I would impose court costs of $301.
se você fizer isso, fazer um apelo, você vai servir pelo tempo que você passou na prisão, então você vai ser solto, e eu vou aplicar um custo de corte de $301.
Sim.
Is that what you wish to do, or would you like the case set for trial?
É isso que você quer fazer, ou você quer que o caso continue sendo julgado?
Mas eu tenho que pagar agora?
Do I need to pay right now?
No, I will give you 24 months to pay the $301.
Não, eu vou te dar 24 meses para você pagar os $301.
Ok.
Is that what you want to do? You would like to resolve it today?
Então é isso que você quer fazer? Você quer resolver hoje?
Sim.
Yes.
Okay. Are you under the influence of any drugs or alcohol?
Você está sob a influência de alguma droga ou álcool?
Não.
Não.
Have you suffered from or been treated for any mental illness in the past?
Você sofreu ou foi tratado por alguma doença mental no passado?
Não.
Não.
You understand that entering this plea today, you're giving up certain rights.
Você entende que entrando com esse apelo hoje, você está desistindo de alguns direitos?
You have the right to go to trial and have the state prove the case beyond a reasonable doubt.
Você tem o direito de ir para julgamento e ter o caso o Estado provando o caso acima de qualquer dúvida?
But if you resolve the case today, there will be no trial and the case will be over today.
Mas se você resolver o caso hoje, não vai ter nenhum julgamento e o caso termina hoje.
Mas para resolver o caso hoje, eu tenho que pagar Sim.
But in order to resolve the case today, I need to pay?
Yes, you'll have 24 months to pay the full amount.
Sim, você precisa pagar, mas você vai ter 24 meses para poder pagar o valor inteiro.
Sim, ok.
All right, and the last thing is, you understand that this is punishable by up to 60 days in jail and up to a $500 fine. That's not going to happen, but that would be the possible maximum.
Eu quero que você também entenda que isso é caso para punição de até 60 dias na prisão ou um valor de $500. Não é o caso hoje, mas é o máximo que você poderia estar enfrentando.
And finally, that your entry of your plea could be used against you if someone sought to deport you if you're not a citizen.
Finalmente, esse uso desse apelo pode ser usado contra você se alguém quiser te deportar caso você não seja um cidadão.
All right, I do find a sufficient factual basis. I will adjudge you guilty of no valid driver's license.
I'm sorry, say that you find
I do find a sufficient factual basis, and I will adjudge.
Eu acho.
Go ahead.
Eu achei os fatos suficientes como base.
I will adjudge you guilty of no valid driver's license and sentence you to the time you have already served in jail.
E eu vou julgar você como culpado por não ter uma licença de dirigir válida e estou enviando você já para o tempo que você já serviu na prisão.
I will impose court costs and a $50 cost of prosecution, which is a total of $306.
I'm sorry, do you mind repeating?
Sure. I will impose court costs and a $50 cost of prosecution, which totals $306.
E eu vou impor alguns custos do tribunal e também $50 do valor do julgamento e também isso traz um total de $306.
And I'll allow you 24 months to pay the total of $306.
E eu vou te permitir até 24 meses para poder você pagar esse valor total de $306.
Ok.
Alrighty, and you'll be released on this case today.
E você vai ser liberado desse caso hoje.
Okay, thank you. Thank you, ma'am.
Thank you for your services.
Okay,
Bye-bye.
take care.
I have created a Patreon page for those of you who want to support my channel. All patrons will receive access to the new private Bond Court Discord server. All video content will remain on my YouTube channel for free. Supporting me on Patreon is not required, but it is greatly appreciated. Thank you to everyone for watching my channel, liking my videos, and leaving comments. Bond Court is now in session.
All right, good afternoon, everyone. We are on the record for first appearances today. May I have appearance for the state?
Good afternoon, John Paul on behalf of the state.
And for defense?
Good afternoon, Your Honor. John Mancini on behalf of the Public Defender's Office.
All right, good afternoon, Mr. Mancini. And who is appearing for pretrial release today?
Patricia Jenkins for pretrial release.
All right, hi, Officer Jenkins.
How are you doing?
All right, folks, my name is Tom Young. I'm a circuit judge in the 9th Judicial Circuit sitting in Osceola County. We're here for first appearances today. That means we're going to be discussing whether there was probable cause for your arrest, and if so, the conditions of release, including whether there should be a bond, and if so, how much. And we're not going to be talking about the specific facts of your case. So you are all entitled to be represented by a lawyer. I'm going to get the interpreter on the phone now, or on the line now, before I go into that, so I don't have to repeat myself.
Good afternoon, Your Honor. This is Rafael Barrera, State Certified Court Interpreter. I have been previously sworn.
Good afternoon. We're doing first appearances at the jail, and I need your assistance with general advising before we call the first case.
Certainly, Your Honor.
All right. As I was saying, everyone today is entitled to be represented by a lawyer in connection with their cases.
Como ya he dicho anteriormente, todos aquí presentes tienen derecho a ser representados en el día de hoy por un abogado referente a sus casos.
If you are not already represented by privately retained counsel, I'm going to appoint the Public Defender's Office today to provisionally represent you.
Si ya usted no tiene contratado a un abogado particular, voy a designar las oficinas del defensor público de manera provisional para que los representen.
You can still hire a private attorney if you wish, or if you wish to have court-appointed counsel, you will need to complete the required financial affidavit.
Si usted desea, puede contratar su propio abogado, un abogado particular, pero si desea continuar con los servicios del defensor público, va a tener que completar la solicitud, o sea, el affidavit financiero.
If you qualify for appointment of counsel, the court will appoint counsel after you have completed the required affidavit.
Si usted reúne los requisitos para que el juzgado le designe un abogado, se le designará al abogado tan pronto usted complete la solicitud.
All right, thank you. Our next, or our first case rather, is Josian Peña Nunez. He has two cases, 2022 CF 1600, 2022 CF 1538.
Thank you, Your Honor.
Good afternoon, sir.
Buenas tardes, caballero.
Sir, you were arrested based on warrants issued by another judge in the circuit. There is probable cause.
Señor, usted fue arrestado debido a una orden de arresto que fue emitida por otro juez. En este circuito se determinó que existe motivo fundado.
In case number 2022 CF 1538.
En el caso 22CF 1538.
Your bond is, you were arrested for aggravated battery and your bond is $10,000.
Usted fue arrestado en el cargo de agresión agravada. Su fianza está programada en $10,000.
The conditions of bond are no contact with the alleged victim, maintain a separate residence. You may return one time with law enforcement.
Las condiciones de esa fianza es que se le prohíbe trato con la presunta víctima, tiene que mantener una residencia separada, se le permitirá regresar una sola vez acompañado de un agente del orden público para recopilar sus pertenencias personales.
The one-time return with law enforcement is to obtain your personal belongings.
Como le dije, regresa una sola vez con un agente del orden público para recopilar sus pertenencias personales.
You may not possess any weapons, firearms, or ammunition while on pretrial release in this case, and you may not return to the location except with law enforcement that one time.
Durante el transcurso de su libertad provisional no se le permite portar armas de fuego, armas blancas o municiones, y no se le permite regresar al lugar de los acontecimientos con la excepción de esa única vez acompañado de un agente del orden público.
In case number 2022 CF 1600, you are arrested for grand theft of a motor vehicle.
En el caso 22CF 1600 fue arrestado por un cargo de hurto mayor, robo de un vehículo.
Your bond in that matter is $3,500.
En ese caso, su fianza está programada en $3,500.
And the conditions of the bond will be to not return to the location of the alleged offense at 4636 West Earl of Bronson Memorial Highway.
My apologies, Your Honor. You cut out on the address. Could you kindly repeat that for the interpreter,
Sure,
please?
the address is 4636 West Earl of Bronson Memorial Highway.
Thank you, Your Honor. No se le permitirá regresar al lugar de los acontecimientos, específicamente el 4636 West Earl of Bronson Memorial Highway.
And no contact with the alleged victim.
Y no se le permite trato con la presunta víctima.
All right, thank you, sir.
Gracias, caballero.
Sorry? for everyone. Unless they advise me they have a private counsel, that's why I did it at the front. So everyone is provisionally appointed today. All right, our next case is Orlando Rodriguez Velez, 2022 MM 1201.
President approaching, Your Honor.
Good afternoon, sir.
Buenas tardes, caballero. Good afternoon.
Sir, you were arrested for battery domestic violence.
Señor, usted fue arrestado en un cargo de agresión violencia doméstica.
There is probable cause.
¿Existe motivo fundado?
Sir, if I do not allow you to return to the residence that you were sharing with the alleged victim, where will you be living?
Caballero, si yo no le permito a usted regresar al lugar que usted compartía con la presunta víctima, ¿dónde va a vivir usted? Well, clarification, Your Honor. Repítame, señor, no se lo entendió bien. In the rehab I was living at.
Okay. All right. So you do qualify for pretrial release conditions with a bond.
Señor, usted cumple los requisitos para el programa de libertad provisional con una fianza.
We don't have a victim here today, so based on to testify here in court. So what I'm going to do is I'm going to set a relatively low bond with pretrial release conditions. The bond will be.
I'm sorry, Your Honor, go ahead.
I was going to say the bond will be in the amount of $500.
No tenemos presente una víctima para que testigo en el día de hoy. Le voy a programar una fianza relativamente baja, $500 con condiciones de libertad provisional.
Other conditions of bond will be no contact with the alleged victim, no return to the residence, and you may not possess any weapons or firearms.
Condiciones de la libertad provisional: no se le permite trato con la presunta víctima, no puede regresar al lugar de los acontecimientos, tiene que mantener una residencia separada y no se le permitirá portar armas de fuego o armas blancas.
The judge who issued the arrest warrant also ordered a condition of no alcohol consumption.
Y el juez que emitió la orden de arresto también indicó una condición prohibiéndole la bebida alcohólica.
Okay, thank you, sir.
Gracias, caballero.
Our next case is Rene Pena Colon, 2022 MM 1258.
My apologies, Your Honor. 22 MM, and I missed the rest.
1258.
Thank you, Your Honor.
I'm going to go through these. They're bringing Mr. Pena Colon from the back, Mr. Interpreter.
Your Honor, we're having there's a small mix-up. If you 1 second, Your Honor. You're asking, looking for Mr. Pena, Your Honor?
I'm sorry?
You're requesting Mr. Pena, Your Honor?
Correct. He's the last Spanish interpreter, I believe. All right. Good afternoon, sir.
Buenas tardes, caballero.
Sir, you were arrested for battery.
Señor, usted fue arrestado en un cargo de agresión.
I have reviewed the affidavit. There is probable cause.
He revisado la affidavit, determino que existe un motivo fundado.
You do qualify for pretrial release conditions with a bond.
Usted reúne los requisitos para el programa de libertad provisional con una fianza.
This is an unfortunate family situation with some extenuating circumstances. Mr. Peña-Colón, where will you live if I do not allow you to return to your home?
Señor Peña Colón, ¿dónde vivirá usted si es que no le permito regresar a su residencia?
Viviría con mi suegra.
Well, I could live with my mother-in-law.
Is your niece still living with you and your wife?
¿Su sobrina aún vive con usted y su esposa?
Sí.
Yes.
Pero ahora mismo está en el hospital en Park Place.
Well, but right now she's in the hospital. She's in Park Place.
Where will she live when she's released from Park Place?
¿Y dónde viviría ella cuando le den de alta de Park Place?
Ahí tendríamos que buscar.
We would have to look for a place.
Bueno, sería con mi suegra, que es su abuela, pero.
It would have to be with my mother-in-law, who is her grandmother.
All right, it's a complicated family dynamic. So what I'm going to order is that you may not reside at your home as long as your niece is residing in the home.
Es una dinámica familiar un poco complicada, por lo tanto voy a ordenar que usted no viva en el hogar siempre y cuando su sobrina se encuentre viviendo allí.
You must have no contact with your niece, who is the alleged victim in this case.
No se le permitirá trato con su sobrina, que es la presunta víctima en este caso.
You may not possess any weapons or firearms while the case is pending.
Mientras que el caso esté pendiente, no se le permitirá a usted portar armas de fuego, armas blancas.
If your niece is home, when you're released from jail, you may return one time with law enforcement to get your personal belongings.
Si es que su sobrina se encuentre viviendo en su casa, cuando usted lo liberen, se le permitirá regresar a usted una sola vez acompañado de un agente del orden público para que usted recopile sus pertenencias personales.
Again, you may live at your residence if your niece is not staying there.
Para recalcar, usted puede vivir en su casa siempre y cuando su sobrina no se encuentre allí.
Mr. Paul, is there a reason I should not RRR Mr. Peña-Colón?
¿Hay alguna razón por la cual no le puedo dar libertad bajo palabra, señor Peña Colón?
I would advise the court, I did not see any criminal history for him, so I would defer to the court on that.
Le tengo que avisar a su señoría que no vi antecedente penal en el caso de él, así es que voy a diferir a su señoría.
I believe under the circumstances that Mr. Peña-Colón is a candidate for ROR, so I will grant non-monetary release.
Creo que bajo las circunstancias el señor Peña Colón unos requisitos para libertad bajo palabra, por lo tanto lo haré de esa manera.
Sir, I want to emphasize, however, that if you have contact with your niece or if you are at the residence when she is, that would be a violation of the conditions of release, and you would be rearrested and placed back in jail. So it's, even though I'm letting you out of jail without a bond, you will be back in jail if you violate the conditions.
Señor, quiero recalcarle que aunque yo le estoy dejando salir bajo palabra, usted no puede vivir en la residencia a la misma vez que se encuentre su sobrina. Si usted lo hace de esa forma, será un incumplimiento de su libertad provisional y de esas condiciones, y usted volvería a ser arrestado, regresaría a la cárcel y tuviera que enfrentarme a mí de nuevo.
You understand?
¿Me entendió?
Entendí.
I understand.
Okay, thank you, sir.
Muchas gracias, caballero.
So at this time, we're going to take up Matthew Torres, 2022 CF 1588. And Mr. Interpreter, I believe we are concluded, but if you with interpreter cases, but if you could make one last announcement to see if anyone else needs your services.
Certainly, Your Honor. Su atención, por favor, si hay alguna otra persona presente que necesite los servicios del intérprete, por favor, alce la mano en este momento.
Your Honor, I had identified one other individual, Mr. Luis Roman Gonzalez.
Is that him there?
It is not. That is Mr. Matthew Torres.
All right. Yeah, let's go ahead and take the other gentleman. Sorry. Let's take the other gentleman first so we can allow the Spanish interpreter to go after we do this. This is, say the name again?
Mr. Luis Roman Gonzalez.
Okay. So there are 4 cases, Mr. Interpreter,
Yes, Your Honor.
and they are 2022 CT 1498, 1499, 14500, no, 1500 and 1501.
Thank you, Your Honor.
Mr. Roman Gonzalez, good afternoon.
Buenas tardes, señor Román González. Good afternoon.
Sir, you were arrested on warrants issued by Judge Epperson for failure to appear.
Señor, usted fue arrestado por órdenes de arresto emitida por el juez Epperson por falta de comparecencia.
In each of the cases, you failed to appear for arraignment.
En cada uno de esos cargos usted faltó de comparecer en una vista incoatoria.
And Judge Epperson has set bonds. In case number 1501, your bond is $100.
El juez Epperson ha programado las siguientes fianzas. En el caso 1501, su fianza está programada en $100.
In the other 3 cases, your bonds are $250 each.
En los otros 3 casos, la fianza está programada en $250 cada uno.
Is there a next court date, Madam Clerk?
On demand.
All right. It's an on-demand court date.
La próxima fecha de comparecencia será programada.
Thank you, sir.
Gracias, caballero.
Mr. Mancini, was there anyone else you identified? No, Your Honor, that was all. All right, Mr. Interpreter, thanks so much for your help today.
You're welcome, Your Honor. Have a good weekend.
All right, you too. All right, so this is Matthew Torres, 2022 CF 1588. We do have the sign language interpreter here in the courtroom.
Yes, Your Honor. She is not quite visible on the camera, though, Your Honor. It seems to be very focused on where you are sitting.
Oh, can you come up behind me, perhaps? She's coming around. Are you able to see now?
Yes, Your Honor.
Okay, perfect. All right, good afternoon, Mr. Torres. Sir, you are here because you were arrested for 3 charges. You were arrested for burglary of an occupied dwelling. You were arrested for criminal mischief of more than $200 and less than $1,000. And you were arrested for trespass into an occupied structure or conveyance. You do qualify for bond, and you qualify for pretrial release conditions with the bond. Your bonds are in the amounts of $5,000 on count 1 and $500 each on counts 2 and 3. There is probable cause for the arrest. I did appoint the public defender to represent you provisionally. If you wish to have court-appointed counsel, I need for you to complete the required affidavit. If you qualify, the court will appoint counsel to represent you throughout this case. All right.
I will.
Do you have any questions, sir? Oh.
I will pay it. But I don't have any family. I don't know. I
understand that. It's very hard for me to understand my mind, something with my mind. It's just hard for me to understand. Can I write something down, or can I get a piece of paper with it written down?
Well, the Public Defender's Office has been appointed to represent you for today's purposes, so you can communicate with them and they can assist you in completing an affidavit if you need a court-appointed lawyer. And then the public defender will bring your case to the judge who is covering your case for any issues that need to be addressed.
All right, that's fine. I understand. So, I don't know, judge, lawyer, I don't know.
So the public defender can communicate with you in writing and can help you. Mr. Paul was going to say something.
I would just ask that if he is released, he be ordered not to return to the location.
All right, thank you, Mr. Paul. I think I addressed this yesterday on the record. Let me look at the paperwork. So you may not return to 3625 Weathersfield Drive.
I'm sorry, Your Honor, what is the address again?
3625 Weathersfield Drive. And you may not have contact with Sammy Costello. Or other witnesses. Okay, thank you, sir. Okay. Kind of right in the middle, so. I appreciate it. Okay, yeah, I'm right in the middle. I was hoping this would happen one end or the other. Would you know, can you all notify Tabitha? Yeah, thank you. We don't even have our full roster of people. All right, our next case is case number CF 07009507 from Polk County, and it is Michelle Santiago Haskins.
President approaching, Your Honor. Defense at this time would be requesting a waiver of the reading of the underlying in the VOP, Your Honor.
Okay, thank you. Good afternoon, ma'am.
Good afternoon.
You were arrested on an alleged violation of probation charge out of Polk County. The judge there issued the warrant and set zero bond. So you will be transported to Polk County. You'll see a judge there about terms of release or resolution of the case. If there are any issues that arise before you're transported, the public defender here has been appointed to assist you. Okay?
Thank you.
Thank you. Next case, John Dillon Santoro, 2021 MM3041.
He's President approaching, Your
Good afternoon, sir. Sir, you were arrested on a warrant issued by Judge Sanders Morency for failure to appear at arraignment. She set a bond for you in the amount of $1,000. Okay? Is there another court date for? On demand. All right, so it's an on-demand court date. You don't have one set yet. Okay? Thank you, sir. The next case is 2022 CF 1598 Edgar Baez.
He's President approaching, Your Honor.
Good afternoon, sir. Sir, you were arrested on a warrant issued by Judge Madrigal for possession of heroin and possession of drug paraphernalia. There is probable cause. Officer Jenkins, I don't see a cover sheet for Mr. Baez. Is that because it was a warrant arrest?
Yes, sir, and it was an added charge. He's already incarcerated here.
Okay. Can you tell me anything about Mr. Baez's background?
No, sir, not right now, because we don't, once we have an added charge and they're already here, we don't run the criminal history, but we can see when we find it, if we still have it, because we only keep it for like 30 days.
I see. Okay, thank you. Mr. Paul, do you have any information?
Just that he is being held on 22 CF 1318 for possession of cocaine.
All right, does he have no bond in that case?
If I could have one moment, Your Honor.
Tell me that number again.
22 CF 1381. He had his first appearance on May 13th, and he was given a bond of $1,500.
So he's not been released on that case. All right. So consummate with that case, I'm going to reduce the bond on count 1 to $1,000 and count 2 will be $500. So your bond in this case will be $1,500 total. You may not possess or use any drugs or narcotics without a valid prescription will be the condition of the bond. Okay. Thank you, Mr. Baez. All right, and Daquan Johnson, 2022 CF 1594.
President approaching, Your Honor. He is in the cage. It'll be one moment before he's brought forward.
Okay. Good afternoon, Mr. Johnson. Sir, you were arrested on a warrant issued by Judge Madrigal. The charges are burglary of a conveyance, grand theft, and grand theft of a firearm. There is probable cause. The bond amounts total $4,500. They are $1,500 on count 1, $500 on count 2, and $2,500 on count 3. The conditions of bond are no contact with the alleged victim, no possession of any weapons, firearms, or ammunition, and no return to the flea market at 5405 West Earl Bronson Memorial Highway. Okay, thank you, sir. That brings us to 2022 CF 1603, Juan Diaz.
Your Honor, there was an event that required his removal from IAs today. We'd be requesting a 24-hour reset at this time.
All right, so this will be heard by the emergency duty judge over the weekend. 2022 MM 1256, Ruben Gonzalez.
President approaching, Your Honor.
Good afternoon, Mr. Gonzalez. Sir, you were charged or arrested on the charge of resisting an officer without violence. There is probable cause. I'm going to reduce your bond to ROR. Well, actually, you qualify for direct PTR, so I'm going to release you without requiring a bond, but it will be pretrial release conditions, okay? All right, thank you, sir. Evelyn Harkins, 2022 CF 1604.
She is present, Your Honor. It'll just be a moment. She is in the back. While not a probable cause argument, defense would have a request in this case, Your Honor.
Okay. Hello, Ms. Harkins. Mr. Mancini, do you wish to waive the reading?
Yes, Your Honor.
All right, Ms. Harkins, you were arrested on a misdemeanor count. There is probable cause for the arrest. Mr. Mancini, you had a request, you said.
Yes, Your Honor. This client has been represented by our office for a long period of time. I believe it goes back possibly 10 years. Since that time, she has been found incompetent to proceed multiple times. And this, coupled with the nature of this offense relating most likely to that incompetence, defense would be requesting if Your Honor would consider ROR for this client.
Is your office going to be able to have good communication with her so that you can?
We will do everything in our power to make that happen, Your Honor.
State, do you have any objection to ROR?
No, Your Honor.
All right, Ms. Harkins, I'm going to grant you release on your own recognizance. Condition of release will be that you maintain in touch with the Public Defender's Office and you don't return to the Walmart at 4400 13th Street in St. Cloud. Okay? I'm sorry, what did you say?
Yeah, I will explain that, Your Honor. She's asking about the Public Defender's Office.
Okay, yes. The Public Defender's Office is appointed to represent you today. They'll be in touch with you, okay?
Your Honor, if I may just have a moment.
Sure, please.
We are ready to proceed, Your Honor.
Okay, thank you, sir. All right, Takesha Johnson, 2022 CF 1605.
President approaching, Your Honor.
Officer Jenkins, this references other legal constraint. Can you give some background on that?
Yes, sir. She has a warrant out of Texas. Me?
Yes, ma'am.
Yes, sir.
The reason I ask that is it affects some of the things I can do. Ma'am, you were arrested on the charge of possession of a weapon by a convicted felon from another state. There is probable cause for that arrest. I'm going to reduce the bond in this case to $5,000. I'm going to order that you not possess any weapons or firearms. Of course, that would be a new law offense if you did, but I'm going to order that. I'm going to order that you not return to 4003 Santa Maria Drive, which is the Venetian Bay Apartments. The Public Defender's Office has been provisionally appointed to represent you. If you wish to have them appointed throughout your case, you'll need to fill out the required affidavit. If you have this warrant from Texas, they will be able to explain to you what you can expect, okay? Mr. Mancini, is there anything else we need to address with Ms. Johnson?
I do not believe so, Your Honor.
Okay, thank you. All right, Katie Taylor, 2022 CF 1606.
President approaching, Your Honor, defense would have a probable cause argument to one of the counts in this case.
All right. Afternoon, Ms. Taylor. Ma'am, you were arrested for the charges of aggravated battery causing great bodily harm or disability or disfigurement, and for battery, misdemeanor battery. Mr. Mancini, your argument?
Yes, Your Honor, my argument goes to the first count, the aggravated battery with great bodily harm or permanent disfigurement. Specifically, this was charged under Florida Statute 784.0451A1, which says intentionally or knowingly causes great bodily harm or permanent disability or permanent disfigurement. I do not find any facts in the four corners of this affidavit that point to great bodily harm, permanent disfigurement, or disability, Your Honor.
All right, Mr. Paul, do you wish to respond?
Your Honor, I would submit that likely that's a scrivener's error, and it should have been based on the facts presented in the probable cause affidavit 784.0451A2 uses a deadly weapon. If the court was inclined not to find PC, I would ask for 24 hours to perfect that with an amended affidavit.
All right, I'll give the state 24 hours with regard to, so there is, I agree with the public defender, there's no probable cause for count one, there is for count two. I'll give the state 24 hours to amend the affidavit. All right, so this will be addressed by the emergency duty judge tomorrow.
Yes, Your Honor.
Okay, thank you. Edward Zabley, 2022 MM1259.
President approaching, Your Honor.
Good afternoon, sir. Good afternoon. Sir, you were arrested on the charges of trespass on property other than a structure or conveyance and resisting an officer or resisting arrest, actually, without violence. There is probable cause for these charges. Your bond in this case is going to be $250 on the trespass, $500 on the resisting. Conditions of the release will be not to return to Wawa at 4397 West Earl Bronson Memorial Highway in Kissimmee. No contact with witnesses. You're also out on bond in case number 2020, actually you're on probation in case number 2022 MM1900. The probable cause for the arrest in the new case is violation of condition 5 of the order of probation in 22 M1900. So I find on view violation and order that you be held on zero bond in that case. All right. Thank you, sir. All right, Rancis Profit, 2022 MM1247.
President approaching, Your Honor.
Mr. Paul, I reset this one at Ms. Carrasco's request yesterday. I don't see an amended affidavit.
I was not provided one either, Your Honor.
I'm sorry?
I was not provided one either, Your Honor.
Okay.
We attempted to obtain one, and the officer chose not to provide one.
Okay. There might be probable cause if it was written differently, but the way it's written, it's conflicting, and so I find no probable cause. You'll be released ROR on this charge. You were arrested, sir, and I think I addressed this with you yesterday. You were arrested on the charges of resisting an officer without violence and trespassing in a structure or conveyance. I have found no probable cause for those, and so you're released on your own recognizance. The state can still file charges. All my finding is that in writing, they did not state probable cause. Doesn't mean that it doesn't exist. All right? For both counts. All right, Mr. Ricker, 2021 CF 2446 and 2021 CF 3061.
Yes, Your Honor, I've been informed by corrections that he is still detoxing. We would request another 24-hour reset.
Okay, Mr. Ricker's case will be, this is the second reset, so tomorrow will be the last. So that will be heard by the emergency duty judge. Then the last case I have before me is Clivis Woodson, 2022 MM 1203.
Yes, Your Honor, he is present. He is in the back. It'll be a moment before he's brought forward.
Yes.
All right, good afternoon, Mr. Woodson. The clerk's office brought this before the court today, I guess at the request of the jail. I had to ask why it was back before me, and apparently I ordered a $1,000 bond on your new case with pretrial release conditions, but you don't qualify for pretrial release conditions. So I'm leaving your bond at $1,000, but I'm removing the additional conditions on that case. You still, though, are being held without bond in the earlier case, 2020 CF 912. So the only change from yesterday is the removal of pretrial release conditions in the new case, which is 2022 MM 1203. Okay.
Thank you, Your Honor.
Mr. Mancini, are you aware of any other circumstance on that we need to address?
No, Your Honor, I believe that is all we have in the jail.
Okay.
Your Honor, on this, the case, the 20 CF 912, is that bond gonna be revoked?
Yeah, that was revoked yesterday.
Okay.
Yeah, and that doesn't change. It was just the pretrial release conditions.
Okay, thank you.
Yeah, thank you, Officer Jenkins. You all have a terrific weekend.
Thank you, Your Honor.
Thank you. All right, that concludes first appearances from the jail. Can someone disconnect us, please? I have one right here. Do I need to sign? Is that, or it's not from last week? It's yeah, okay.
Yes, please.
Good morning, Your Honor. This is Rafael Barrera, State Certified Court Interpreter. I have been previously sworn.
All right, good morning, defendant's about to put the headset on now.
Thank you.
Thank you, Your Honor. Your Honor, the interpreter can confirm the defendant is able to hear through the headsets.
All right, sir, your name?
Margarito Hernandez Lucero.
Margarito Hernandez Lucero.
All right, sir, you're here for two matters. You were arrested on a charge of violation of probation on your one DUI, that there is no bond on that. And that was in 2019 CT 5322AO, and in 2019 CT 5799AO, also a violation of probation on another DUI charge. There's also no bond on that. I want a public defender to represent you on both of those charges. Okay, all right. Yeah, do you want to just go ahead and enter denial and put it on the PD, on the POP docket?
That's fine, Your Honor.
All right, we'll go ahead and take the denial. We'll set those for the violation of probation status. I think one's Johnson and one is my wife.
I have both of them.
Oh, they are? Okay, they probably put them together.
Division 61, VOP status, June 28th at 10 o'clock, courtroom 6B.
All right. That's it for the cases? All righty, thank you, sir. Have a great week.
Your Honor, yes, you as well, Judge. Can I just ask you to kindly confirm that first case number? I got 19 CT 53 and I missed the last couple numbers.
22.
Thank you, Your Honor. Have a good weekend.
All right, you too. Bye-bye. Good morning. Your name, ma'am?
Anastasia Robinson.
Ms. Robinson, you're here today because you're arrested for several charges. Two battery on law enforcement officers, one domestic violence battery, and resisting an officer without violence. I have reviewed the charging affidavit, and I do find that there's sufficient probable cause. Now, this occurred at, or allegedly occurred at 1129 West South Street. Is that right? Is that your home?
1129 South Street, yes.
Yeah, is that where you live?
My address.
Is that where you live?
Yes, sir.
And who else lives there also?
My mom comes down from Jacksonville to visit me, but it's just me. I just live there by myself.
Okay, all right. Raise your right hand, please. Solemnly swear the testimony you're about to give you the truth, whole truth, and nothing but the truth, so help you God.
Yes.
Your name, ma'am?
Satrina Melendez.
What was the name again?
Satrina Melendez.
All right, and how are you related to the case?
That's my biological daughter.
Okay. All right, and you were the alleged victim in the case?
Yeah, but I'm not a victim.
All right, tell me, are you have any fear of her?
Absolutely not. Called the police because she was having a medical crisis. My daughter is schizophrenic. She takes medicine 3 times a day. She takes 6 different types of medicines, and she was actually going to see her doctor because she's going to state for 3 to 6 months. She does have a mental judge here at the Orange County Courthouse. I just wrote him a letter last week. Judge Martinez was a woman. She needs mental help. I called the police to do a medical crisis intervention, and when they came in, they just came in very rough with her, and they ended up just charging her with a bunch of stuff on law enforcement. She was supposed to be Baker Act. She was called, when I called the police the first time, they went to the wrong house. So by the time they got rerouted and got to us, they come in there running in there with guns blazing, and they tackled her down, and they said that she pulled someone's hair, and that's why she went to jail. My daughter's never been arrested a day in her life. She needs mental help. She needs her medicine.
All right, so, and are you at the South Street address now, or you don't live there?
No, I don't live there, but she can't just be on her own like that. She has to be monitored. I have power of attorney. She can't just be on her own. She has to be monitored and watched throughout the day, especially when it's time for her to take her medicine. She takes 6 different types of medicine. So she has to be watched to ensure she's taking her medicine.
Well, unfortunately, there's not much I can do about that. I can't effectuate that, so hopefully that'll occur. All right. I do find sufficient probable cause. As to the battery on law enforcement officer, I'll set bond amount of $500. Second count, $500. Domestic violence battery, $500. And then resisting without violence, $100. And so are you going to be at that address? Are you going? I think she said you're from Jacksonville. Will you be heading back to Jacksonville?
No, what's going to happen is while I'm here, I'm going to see about her going back into treatment, back into a facility.
Yeah.
To see if I can get her back into a facility.
All right. Well, what I'll do then is I'll just order that she not have a hostile contact with you, all right, because you're an alleged victim. But she can return to the home, to her house there, and hopefully you can get her somewhere where you can, where she can get some help. Okay?
Yeah, she needs help.
All right,
Actual
she's also not to possess any guns or weapons, no drugs, and no alcohol. The only drugs she's allowed to take are prescribed drugs.
prescribed medicine, no
Okay.
anything else.
All right, thank you. You understand all that, ma'am?
Yes, sir.
All right, and I will appoint a public defender to represent you.
Thank you so much.
All righty.
Am I done?
This was the lady who was trying to get pled over the last couple of days. All right, your name, ma'am? Your name?
Margaret Buckley.
All right, Ms. Buckley, you're here today because you were arrested on a charge of disorderly conduct, and we had tried to get you over here a couple of days ago. I do find that there was sufficient probable cause, and I could set a bond, but I think that they had made an offer in the case that you might be interested in taking.
There was an offer, Your Honor, as a withhold and credit time served, and I spoke with Ms. Buckley before court, and we went over the plea form.
All righty.
I believe she wishes to resolve today.
All right, Ms. Buckley, you wish to enter a plea of no contest and resolve your case, is that right? All right, are you under the influence of any drugs or alcohol today?
No.
All right, go ahead and sign that. All right, and have you suffered from or been treated for any mental illness in the past?
No.
Now that plea form, you understood the rights. Do you have any questions about the rights on it that you've signed? Do you have any question about what's on that form? Okay, you understand this is punishable by a maximum of 60 days in jail, up to a $500 fine, and that the entry of your plea could result in deportation if you're not a citizen. Understand? All right. I do find sufficient factual basis to accept your plea. I'll withhold adjudication, sentence you to the time that you have served, and I'll impose court costs and a $50 cost of prosecution. Total on that's going to be $233. And I'll give you 2 years to pay that. All right, so 24 months, okay? And you'll be released as to this case. Okay? All right, good luck. 24. Oh, I don't know. What was the time served?
3 days.
3. The next person that I have listed is Lawrence Corns. Why? We know why he's here?
From the hospital, Your Honor.
Yeah.
But I looking in Odyssey, I'm not sure.
I assumed he'd been in the hospital for that long, since December, was it? This is when I think he was arrested.
But the PD entered a notice of appearance and a not guilty plea in March. It was set for pretrial in March, and I think May 19th, and on May 19th it was continued. I'm not sure what we need to accomplish here.
Has an information actually been filed?
And it looks like it might have been already reset for another pretrial in front of Judge Calderon. Yeah, it's up for 7/28 pretrial now. Good morning, Mr. Corns. Trying to figure out why they brought you here today. Not sure. How long have you been in the hospital?
November 26th.
Yeah,
December.
okay. I thought maybe there was something else, but the court file seems to indicate that they've just sort of been moving along. Are there no bonds been set on it?
He has 3 no
They did IAs.
He doesn't have any bonds for 3 of the charges.
Well, it's burglary of occupied dwelling, so. Who did that? Oh, okay, that's what happened.
Reset this.
Roger McDonald, when it came for IAs, said reset within 24 hours of hospital release. I guess he couldn't read that big sign that's in the office back there. It says, do not reset for anything other than PC. All right, so Mr. Corns, you're here this morning. That answers the question. For a burglary of an occupied dwelling, aggravated assault, dating violence, aggravated assault, and criminal mischief. And I did read the charging affidavit, and I do find that there's sufficient probable cause. Do you have a place to go You were living at the Ella J. Gilmore Street address?
Oh,
Is that right?
no, I have no.
That's not your address?
Well, yeah, I would, right?
Okay.
Right now.
All right, but if you get out, do you have another place to go?
Yes, sir.
Where's that?
Back, 9210, back on the road.
Okay, and is that with a friend or a family member?
My ex-wife.
Okay. All right, state want to be heard as to the bond?
No, Your Honor. He is entitled to bond on all of the offenses.
Alrighty. As to the burglary of a occupied dwelling, I'll set bond in the amount of $5,000. Aggravated assault, the dating violence is at the amount of $1,000. The simple aggravated assault, I'm going to reduce that to $1,000, and the criminal mischief will be $100. If you do bond out, you're not to return to 423 West Ella J. Gilmore Street. You're not to have any contact with Tanya Arnold and Elijah Givens. And you're not to possess any guns or weapons or any drugs or any alcohol, okay? I will appoint a public defender to represent you on that. The PD's already there, so that's it. Yeah, I think they're both victims. All right, good luck, sir. Man. Yeah, Mr. Maxwell, I think we were trying to get brought back because they made an offer. What I need to do is like get a piece of paper this big and just write, do not reset unless for PC, and then just stick it right here. Obviously. I mean, seriously, the whiteboard back there, you can't miss it, and it's as big as that TV screen. Is that Mr. Maxwell? All right, George, you're here because you were arrested and charged for alcohol, possession of open container of alcohol. I have reviewed the charging affidavit, and I do find there is sufficient probable cause. I think they had made an offer in the case, is that right?
It's generally a withhold of adjudication,
Yeah.
credit time served.
I think we had reset him from a couple of days to try to get it done.
Your Honor, I did have a chance to speak with Mr. Maxwell about the state's offer as well as went over the plea form with him.
All right,
Maybe
Mr.
just
Maxwell,
as
you
a-
want to enter a plea of no contest then and get sentenced to time served on this charge?
Yes, sir.
Okay, are you under the influence of any drugs or alcohol today?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
Yes, sir.
All right, you understand what's going on here today, though?
Yes, sir.
You know what this charge is about?
You know what the charge is about?
Yes, sir.
Okay. All right, and you understand the rights on that form? Have you signed it yet?
Yes, sir.
Do you have any questions about anything on that form?
No, sir.
All right, you understand that this is punishable by up to a maximum of 60 days in jail and up to a $500 fine, and that the entry of your plea could result in deportation if you're not a citizen. I expect you are, but I have to tell you that. You understand all that?
Yes, sir.
All right, Mr. Maxwell, I will accept your plea. I'll withhold adjudication, sentence you time served
4 days.
with 4 days. I'll impose court costs of, and a $50 cost of prosecution, total of $233. And I'll give you 2 years, 24 months to pay for that, okay?
All right, sir.
You're all set. You'll be released as to this case. All right, now we get to the meat. Are your name, sir?
Nicholas Agostino.
All right, Mr. Agostino, you're here today because you're arrested on 2 charges, battery on a person over 65, domestic violence, and battery domestic violence. I have read the charging affidavit, and I do find that there's sufficient probable cause. Now, were you living at the Alpert Drive address?
Yes, that's my mother's home, that's all.
Okay, and do you have another place to go other than where your mother is living?
She died now, because she dropped those charges down I was down there. My wife, my granddaughter, my mother went down. The judge dropped the charges.
Not these.
And the building collapsed.
Not these, it's January.
Yeah, it was the second.
No.
I was there.
This happened, you were arrested on, yesterday at,
wasn't arrested
at 1:20. Right? What's that?
I wasn't arrested, yes.
Well, how,
2
come
days
you-
on the
let me ask you
2nd.
this, why are you here then?
Because
How
I
did
came
you
in
get it to
probation.
jail?
I came in probation.
And then you got picked up for battery, on a person over 65?
No, I was picked up on the 2nd, and they shipped me up to,
All right, it's simple. I do
Yeah,
find,
no, no, I understand.
I do find that there is sufficient probable cause.
Okay, I'll go.
You are not to return to 6932 Alpert Drive. At this point in time, there's no one here.
Okay.
You're gonna have to find another place to stay.
Okay,
All right? I'm gonna order that you not have any contact with Patricia.
no, she's passed.
You got to let me talk,
Yes, sir, but,
or you'll just be here, I'll have them bring you back next week,
okay.
okay?
My daughter, my mother, my grandchild. all
You're just
died
gonna
at the
keep talking. You're just gonna keep talking.
I just want you to know.
You told me that 3 times already. I don't care.
Yes, sir.
Okay? You're not to have, if they're dead, then it's, no contact is easy. I doubt that they're dead, because this allegedly happened yesterday, and unless your mother died
I
at
know
some
you're
point
wrong.
after 1:30 yesterday, she's alive. So no contact with Patricia Agostino. All right? No contact whatsoever. You're not to return to 6932 Alpert Drive. You can't go back there, other than one time with law enforcement. So you can go back there one time with law enforcement, so you can get your personal items. But you cannot go there to reside. You must keep a separate residence than other than that place with Patricia Agostino. You're not to possess any guns or any weapons or any drugs or any alcohol
I
whatsoever.
understand you.
All right? And I'll step on the amount of $1,000 on count 1, $500 on count 2. And I'll appoint a public defender to represent you. Your name, sir?
Rodriguez Conquest.
What's that? Conquest. Yeah. Okay. Yeah, Mr. Agostino does have a violation of probation out of county. And I will, and there's no bond on that. Thank you. All right, Mr. Conquest. You're here today because you're arrested on a charge of battery domestic violence with one prior domestic violence. And I did review the charging affidavit, and I do find that there's sufficient probable cause. Your name, raise your right hand, please, ma'am. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Your name?
Lucero Pugh.
All right, and you are the alleged victim in the case?
Yes.
Okay, and this is from a probable cause warrant. The allegation is that this occurred on May the 24th. Are you here because you do not want to have contact with Mr. Conquest, or you do wish to have contact with him?
I wish. That's my child's father.
Okay, well, that's not an answer necessarily. Just because he's your child's father, if you don't want to have contact with him, I can make that happen.
No, I do want to have contact.
Okay. You understand I can't protect you if I don't have that ability, right?
Yes, sir.
Okay. So you would have no problem with him having no hostile contact with you then? That means he can contact, but he can't raise his voice, can't yell at you, can't throw stuff at you, that kind of thing.
Okay.
Does that work for you?
Yes, sir.
Okay. Do you guys live together?
Yes, sir.
Is that at the West Jackson Street address?
Yes, sir.
Okay. All right. Okay, so I'll let him come home, but he can't be hostile to you, all right?
Yes, sir.
Okay. All right, Mr. Conquest, you heard all that, right?
Yes, sir.
Okay, so I will set bond in the amount of $500. I'm going to require that you have no hostile contact with Lucero Pugh. Can't have any hostile contact. That means you can't raise your voice, can't send her a mean text, can't do anything like that, okay?
Yes, sir.
All right. I'm going to order that you not possess any guns or weapons, and that you not use or possess any drugs or alcohol.
Yes, sir.
Okay, and I will appoint a public defender to represent you. I'm going to take no action on the driving license suspended bond. All right, thank you, ma'am.
Okay, thank you.
All right, your name, sir? Your name?
Joseph
Last name?
Lyons.
All right, Mr. Lyons, you're here today because you're arrested on 2 charges Battery, domestic violence, strangulation, and felony, which is a felony, and battery, simple battery, domestic violence. I've read the charging affidavit. I do find that there's sufficient probable cause. Do you have a place where you, oh, this did not happen at the home. Were you living with Madeline Gonzalez?
No,
No, she has her own place?
I guess, I don't know.
What do you mean you don't know?
I don't know.
Haven't you guys been dating for 3 months?
No.
So you don't know her at all?
No, I mean, I know her, but I don't know her that good. No, I just know she a crazy prostitute, that's all.
That's nice. All right, well, what I want to do is I'll set bond in the.
I need ROR, I can't afford anything.
Well, you're not getting ROR, so
I guess
that's
I'm
not
saying.
happening. I'll set bond amount of $1,000 count one, $500 count two, and then I'll order that you not have any contact with Madeline Gonzalez, none whatsoever, okay?
Oh, but I'm
You're not to
serious.
possess any guns or weapons, you're not to use or possess any drugs or alcohol,
Yeah,
okay? Now, if you don't really know her, then that should be easy, that you don't have any contact with her,
that's
right?
what I'm saying.
Yeah, okay. All right, no problem. Keep in contact with your lawyer. Your name, sir?
Matteo Giovanni Nazario.
All right, Mr. Nazario, you're here today because you're arrested on a charge of false imprisonment and domestic violence battery. I have read the charging affidavit, and I do find sufficient probable cause. Now, this happened at a hotel, right?
Correct.
Allegedly, yeah. And the alleged victim in the case, she does not live with you, right?
No, we used to live together and
Right.
then we
It was
separated.
an old relationship.
Yes.
All right, so, and that's Bobby, B-O-B-B-I, one second, Wollenberg, right?
Yes, Your Honor.
W-O-L-L-E-N-B-E-R-G, okay. So there would be no reason that you have any contact with her.
Yes.
Okay, now let me ask you, where do you live? You don't live at that McCoy Road address, that was a hotel.
That's a hotel.
You have a home of your own?
No, I do not. I work and stay at hotels.
Okay, so that's where you would plan to go, is back to a hotel then?
Not that specific. one.
Just any, yeah,
Yes.
I imagine they probably trespassed you from there, they don't want you
Yes,
back
sir.
there. All right, okay, no problem, then, what I'll do is, as to the false imprisonment, I'll set bond in an amount of $1,000, $500 for the domestic violence. I'm gonna order that you have no contact with Bobby Wollenberg, and that's B-O-B-B-I, last name Wollenberg, W-O-L-L-E-N-B-E-R-G. You're not to possess any guns or weapons, you're not to use or possess any drugs or alcohol, and I'll appoint a public defender to represent you.
All right. thank you.
Okay, all right. Your name, sir?
Ronell Ross.
All right, Mr. Ross, you're here today for a couple of things. You're arrested for 3 charges. Count 1 is carjacking with a firearm, count 2 is child abuse, and count 3 is dating or domestic violence. I have read this is based off of a probable cause warrant that was issued after a judge signed that warrant. Now, let me get back to that. I gotta make sure. Here it is. Do you live with
What?
Esmeralda? Let's see, no. Yeah, Esmeralda, let me see if at Washington, in Charles, Washington. You don't live at the same address as those 2 people, is that right?
Your Honor, that Charles Washington is from Pennsylvania, and me and Esmeralda Washington was residing there, and then I just started moving away because we was going through a breakup.
All right, so 14615 Gateway Point Circle, whose house is that?
Me and Esmeralda Washington.
All right, so she is still there as far as you know?
Yes.
Okay, so you can't go back there, you're gonna have another place to go, understand? Okay? If you bond out, so you're gonna have to be able to do that. And you're not gonna have any contact with Esmeralda or Charles, right? Okay, so as I said, I do find that there's sufficient probable cause. I will set bond on the carjacking amount of $5,000.
Your Honor?
Yep,
Yeah, carjacking with a firearm is a first-degree felony punishable by life. At this time, the state is asking defendant be held no bond.
You are.
yeah, I mean,
Go ahead.
We're able to set a bond, Your Honor, if inclined.
Yeah, I mean, here's the thing. I understand that, and that this type of thing is inherently dangerous, but this is not really the run, I mean, it's not the run-of-the-mill carjacking case where just somebody
Because
goes
he
up and
had
takes a
gun
car from somebody they
and
don't
he
know.
took her car?
Well, yeah, I mean, you understand what I'm saying, the facts of the case, if you read the facts of the case, it was involved in this interaction with somebody he knew. It's not like you're driving down the street and somebody took their car. I think that there's a difference in that. Is it technically carjacking? Yeah, I think it is. There's probable cause for it, for sure. I'm not saying that.
So because it wasn't a stranger, it doesn't rise to the same level?
I don't think so.
But you don't think the terror was still the same, especially since there was a child involved?
I think it may be, but I look at it, it is different. So I'll set bond amount of $5,000. The child abuse to be $1,000 and the battery domestic violence $500. And then again, no contact with Esmeralda, Washington or Charles, Washington. You're not to return to the address that we related before, and that was 14615 Gateway Point Circle, Orange County. Okay, I'll appoint a public defender to represent you on that. And you are out on bond on carrying concealed firearm. Existing no action. I will revoke that bond, and there's no bond on that. And I think the public defender's already been appointed on that. Your name, ma'am? Your name? Good morning.
Turner, Jarquilla Turner.
Hi, Ms. Turner. You're here today for 3 charges. You're arrested on a burglary, a dwelling, a battery, domestic violence, and criminal mischief. I have reviewed the charging affidavit, and I do find that there is sufficient probable cause. It was actually based on a probable cause warrant that was signed by a judge already, but I agree with that judge. Now, where are you going to go? There we go. You raise your hand, please? Solemnly swear the testimony you're about to give me the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Your name, sir?
Mikael Abrams.
All right. And you are the alleged victim in this case, is that right?
Alleged, but.
Yes?
I'm not a victim.
At least that's what they said.
That's what they said.
Okay, gotcha. And do you live at the 2605 Reef Court address? Is that your address?
Yes, sir.
Okay. And was Ms. Turner living there also, or no?
No, sir.
Okay. So she has her own place?
Yes, she does.
Okay. And are you here to tell me that you don't want contact, or you would like contact with her?
I'm not here to tell you I don't want contact. I want contact.
All right. And no hostile contact would be okay? In other words, if I tell her she can't raise her voice, she can't threaten you, can't do anything along those lines, that would be fine?
I mean, that's normal behavior, but not to do, but yeah.
Okay, so that you think will, that's enough for you, is what you're saying?
That's yes, sir. Yes, Your Honor.
And do you have a problem with her coming back to your Reef Court address, or you don't want her to come to your place?
I don't have a problem coming anywhere where I'm at all.
All right. Then what I'll do on the burglary of a dwelling, I'll set bond amount of $1,000. The battery will be $500, and the criminal mischief $100. And you're not to have any hostile contact with him. That means you can't raise your voice. Don't throw a brick at the front door or anything like that. Don't do anything hostile towards him. All right, because if you do, that's a violation. You're not to possess any guns or any weapons. You're not to use or possess any drugs or alcohol. Okay.
Question, Your Honor. I did have a question.
Sure, you have a question?
Yes, sir.
Sure, go ahead.
All right. So as far as the bond goes, are all those the numbers that you name? Are all those basically like $100 each?
You gotta talk to a bondsman to see what they will charge you. If you wanted to post with the county, it would be $1,600, $100, $1,500, $100.
Right.
And you get all that back if you have that money, then and you can let the county hold it. Right. You get it all back. If you go through a bondsman, of course, they're going to take a portion of whatever they require you to pay,
right,
and then go from there. But it just depends on the bondsman as to how much you have to pay. Okay?
Understand.
All right. Did you have a question? I thought you were about to say something too.
Yes,
So I'm bonding out, but how does this work? Like, as far as, I guess I still have these charges?
Yes, you do, yeah, but you have a lawyer now, so make contact with the public defender's office. They'll chase it down for you and see where it goes.
How do
okay?
I drop
The
the
state, well, and that's gonna happen. I was gonna say that you can contact the state and let them know as the alleged victim what you want to have happen. Of course, they're gonna decide whether or not to do that. It's not totally up to you, but will have that opportunity. Okay?
Okay.
And just stay in contact with your lawyer. If you bond out, make sure you call the public defender's office. You get as soon as possible as you can talk to your lawyer about the case. Okay?
Thank you.
All right. All right, your name, sir?
Kingsley Adams.
All right, Mr. Adams, you're here today because you're arrested on charge of battery domestic violence. I have reviewed the charging affidavit, and I do find that there's sufficient probable cause. Now, are you living at the Auver Boulevard
Yes, sir.
address? Okay. And I guess it's your brother that's the alleged victim?
Yes, sir.
Is he still there?
Yes, sir.
I assume he lives there, yeah. So do you have another place, since he's not here, do you have another place to go in the short term? Because I can't let you go back there, and I'm not gonna let you have any contact with him for right now. Now, that may change, but as it stands today, because he's not here to say that he's okay with that, I'd have to order no contact. So is there another place you can go, other family members, anything like that?
I honestly would just figure that out when I get out.
Okay, all right, well, you can do that. What I'll do is I'll step on, now you do qualify for pretrial release, which would not require a monetary bond. The pretrial release does require that you call in, and there's some things you'll have to do. So I can either set a $500 bond and you'd have to post a bond, or I'll just give you PTR and you won't have to post a bond. Which one would you want me to do?
The PTR is a
All
pretrial
right,
release.
I'll release you with pretrial release conditions. You're not to have any contact with Christian Dwayne Adams, and you're not to return to 5924 Auver, and that's AUVER Boulevard, number 307. You're not to possess any guns or weapons. You're not to use or possess any drugs or alcohol. Okay, and I'll appoint a public defender.
Thank you.
Your Honor, are you giving a one-time return?
Yeah, oh yeah, that's right. If you want to go back there one time, if you have any items, you can go back one time with law enforcement. So if you want to go back, if you have clothing or anything you need from the house, you can go back one time with law enforcement. Just call one of the, either the sheriff's office or the local police, and they'll go with you, and you can get everything, and then you're, okay?
A statement, if I may.
Yep.
I actually was planning on moving out in the next month.
Yep.
So is there a kind of way like I could get off this lease, like just completely, and I don't have to?
Well, you have to talk to a lawyer about that.
Okay.
If you're on the lease, then, that's going to be up to you and the landlord, okay?
Okay, thank you.
All righty. Come on up, ma'am. Your name?
Mary Jo, French Whited.
What happened to Artisan? Yisrael Artisan?
Mental health, Your Honor.
Okay,
We'll wait for parents, Your Honor.
all right, then I do find sufficient probable cause to set bond in the amount of $500. No contact with it's her, Avital, AHVITAL, Artisan, ARTIOSON, and Altsmona, ATSMONA, Artisan. No contact, no return to 7135 Wild Blackberry Trail. And return there for one time to pick up items. No guns, no drugs, no alcohol, no weapons. Point of public defender. And in the bond, the case he's out on bond, or revoked the bond, no bonds. Okay, back to you, ma'am. Sorry about that. And you are Mary Jo French-Witted?
Yes.
Okay. You're here because you're arrested on a charge of battery domestic violence. Wait a second, hold on, I'm in the wrong one. Just a sec. I have reviewed the charging affidavit, and I do find that there's sufficient probable cause. The Allen Street address, is that where you live?
Yes, sir.
And your husband lives there, Daniel?
Yes, sir.
He's not here, so do you have another place to go other than that? You're gonna have to find a place to go. Since he's not here, I can't let you go back there, at least on the short term, okay? So I'll set a bond for you, but I'm gonna require that you, or I'll let you go with pretrial release conditions, because you do qualify for that. But you're not gonna be able to go back to your house, and you're not gonna be able to have contact with him until the domestic violence judge says that's okay, because he's not here to tell me that it's okay. Sure, go ahead.
I have a farm there. I have horses and dogs and stuff.
Is there, I mean, it's not like you're gonna go live in, in the hay in a barn or something. There's a place to live, right?
Pardon me?
There's a place for you to actually sleep and everything, and you're not gonna just be sleeping in the barn with the horses, are you?
I have a horse trailer. I can pull to the barn and plug it in.
Okay. All right, well, would you want me to set a bond of $500, which would require a monetary bond, or I can release you with pretrial release conditions, and it wouldn't require a monetary bond?
I have a moment to confer. Your Honor. I believe she just wishes to request bond, Your Honor.
Okay, I'll set a bond amount of $500. Condition which that you not have any contact with Daniel Whitted at this point. No contact whatsoever. You're not to return to 6160 Allen Street. You can go back there one time with a law enforcement, a member of the law enforcement who will go with you, and to pick up personal items. You need clothing or toiletries, things like that. You're not to possess any guns or weapons. You're not to use or possess any drugs or alcohol. Okay? And the public defender is appointed.
Thank you, Your Honor.
Okay, good luck. Yes. All right, I have read the charging affidavit. I do find that there's sufficient probable cause. She's not to return to 3405 Mission Bay Boulevard, number 267. And she's not to have any contact with Jorge.
Burgos.
Yes, Jorge Burgos. No guns, no weapons, no drugs, no alcohol. And appointed public defender.
Defense waives the appearance as well.
Already.
Bond, Your Honor?
What's that?
How much is the bond?
500. Your name, sir?
Moises Musenden.
Okay, so you're here.
Moises Musenden.
All right, you're here today because you're arrested on a charge of battery, domestic violence. I have read the charging affidavit, and I do find that there's sufficient probable cause. And were you living, okay, no, this was not there. Are you living with Miss Kaczynski?
Yeah.
You guys do live together?
Yes.
All right. And that, so she's not here, so you're not be able to have contact with her for right now.
Correct.
Okay? So I'll order that you not have, there's no contact with Jennifer Diane Hazinski, Hazinski. And what is the address that you guys were residing at together?
Yes, sir. I was at 2321 Lake Deborah Drive, apartment 328, Orlando, Florida 32835.
Okay, so you can't go back there, okay? You need to go somewhere else,
Yes, sir.
all right? And you're not to possess any drugs or alcohol, use or possess, and you're not to possess any weapons or firearms,
Yes, sir.
okay? And I'll appoint a public defender to represent you. 500.
Sorry?
And I appoint a public defender, so we have a lawyer,
Oh, okay.
okay? What's- Oh, yeah. Oh, and you can go back to your house one time with law enforcement to pick up any clothing or personal items you may need. So you just got to call one of the local agencies and they'll come with you.
Yes, sir. Do I have a bond?
Yeah, $500.
500?
Yep.
Oh, I'm sorry. Thank you.
Mm-hmm. I say it? No one heard it. Everyone asked, so maybe I didn't say it. Thought I did. Your name, sir?
Ryan Royer?
Mr. Royer, are you here today because you're arrested on a charge of domestic violence battery? I have reviewed the charging affidavit, and I do find that there's sufficient probable cause. Were you living at the Binion Road address? Is that your address?
The what, sir?
Binion Road?
No, that's, we're staying at a campground.
Oh, that's a campground,
Yes,
okay. Is Crystal still, as far as you know, staying at that campground?
As far as I know, last thing I knew, she was at the hospital, and I think she was gonna go to detox and into a program last I knew, because that was the plan,
Okay.
because we were both homeless, we were just waiting on some more money.
All right, well, what I can't, since she's not here, what I have to do, I can't let you go back to that campground.
Okay, that's
Right? So you're not gonna be able to return to 2929 South Binion, Binion Road. And you're not to have any contact with Crystal Colburn. Okay, no contact with her for right now. I will set bond for you in the amount of $500, and with those conditions, also, you're not to possess any drugs or alcohol or use them. You're not to possess any guns or weapons. And if you still have some stuff there, in other words, if in your
My mother picked everything up, because I'm gonna be staying probably with my mother
okay,
when I get out.
so there's the tent's gone and everything is there. You don't. Have
Yes,
to
my mom went there and got everything.
All right, perfect. Then you don't have to go back there at all. All righty.
All right, thank you, sir.
And appoint a public defender. Your name, sir?
Lorenzo Santiago.
All right, Mr. Santiago, you're here today because you're arrested on a charge of battery, domestic violence, and I have read the charging affidavit. I do find that there is sufficient factual basis for that, a probable cause. Now, this occurred over by Costco on University, so that's not your address. Were you living with the alleged victim?
No.
Or not? Okay. Raise your right hand, please. Solemnly swear the testimony you're about to give you the truth, the whole truth, and nothing but the truth to help you God.
Yes.
Your name?
My name is Norielyn Crystal Quinn.
All right, and you are the alleged victim in the case?
Yes,
Is
sir.
that right? Okay. And you guys weren't living together?
No, sir.
Okay, all right. What is your address?
7728 Lady Francis Way.
Okay, and what is your address?
7710 Trent Street, Orlando, Florida.
Okay. And are you here because you want to have contact, or you want me to say that he's not to have contact with you?
Yes, I want contact, please.
Okay, so if I order no hostile contact, you'd be okay with that?
Yes, I'll be okay.
Okay, all right. So I'll order that I can order that you have no hostile contact with her, okay? That means you can't raise your voice, you can't throw anything in her vicinity, you can't text her anything mean, nothing like that. You understand that?
I understand.
Okay. Now, you are eligible for pretrial release, so I could release you without a monetary bond, but there are conditions you got to phone in and some things you have to do if you're on pretrial release. Or I can just set a bond of $500. Which one would you prefer?
I'll take the conditions.
Want pretrial? All right, I'll release you with pretrial conditions. You can have no hostile contact with, and I'll spell it, it's Nuri, that's the first name, Aylin, Ayln, second, Crystal Quinn, Quin. No hostile contact with her. You're not to use or possess any drugs or alcohol. You're not to possess any firearms or weapons. And you can go back to your place, and if she wants to come there, she can, but again, no hostile contact with her, okay? And I'll appoint a public defender to represent you. Your name, sir?
Dimitri Youngblood.
Mr. Youngblood, you're here today because you were arrested on a charge of battery domestic violence. I have read, it's based on a probable cause warrant, which was signed by a judge, another judge, different judge. And I have read the charging, I read that, and I agree with the probable cause. Now, the 4566 Ebony Street, were you living there?
At the moment, That's not my address.
That's not your address, okay. That was where there was a party or something, right?
No, that's what we'll stand at for a little while.
Where are you living?
At 1437 King Court,
Okay, and where does Tarina live?
at the address.
Same address, she lives with you?
That's my
No, she lives at this one, the one I read off, okay. So where this allegedly occurred is where she lived, you live somewhere else. So there's no reason for you to go back to that address, right? To where the party was or where she lives? Okay, perfect. All right. I will set bond the amount of $500. You're not to have any contact with Tarina, and her last name is Youngblood also?
Yes, my wife.
All right. No contact with Tarina Youngblood at this point in time. All right, that may change if the domestic violence judge wants to do that, of course you can. And you're not to return to 4566 Ebony Street at all. Now, do you have any things there, any stuff at all that you would have to go there?
I have a lot of clothes stuff there.
At 4566? All right. Well, you can go there to, with law enforcement to pick up your items, okay? But you have to take law enforcement with you. Okay, one time, that's it. All right, and as I said, no, you're not to use or possess any alcohol or drugs, and you're not to possess guns or weapons. And I will appoint a public defender to represent you. Okay? Your name, sir?
Christopher Gonzalez.
Just a sec. Mr. Gonzalez, you're here because you're arrested on a out-of-county warrant from Collier County on the charge of possession of a weapon. There is no bond on that. Collier County will be notified that we have you, and hopefully they'll come and get you.
Could we be appointed in the interim, Your Honor?
Yeah, in the interim, I'll appoint a public defender. Green did, all right. Mr. Green was arrested on an out-of-county warrant.
We'll waive the appearance.
All right, $5,000 on the first count, $1,500 on the second, and $500. And I'll appoint a public defender in the interim. All right. Ferguson was arrested on an out-of-county warrant. There is no bond. And I'll appoint a public defender in the interim.
We'll waive that appearance as well, Your Honor.
Your name, sir?
Good morning, sir. Please, can I ask a question, please?
What is your name? What's your name?
My name is Jandro Lopez E. Malpica.
Okay, all right. Did you have a question? Do you want to ask the lawyer, or do you want to ask me a question?
Just a moment to confer.
Okay, sure.
And how you know whether or not.
I'm excited.
Gonna take a donut with you before you go? All right. Man, you're gonna have a lot of donuts left over. Clerk's office, will they eat them down there? All right. Unless all of a sudden people start chowing on them before we get done. Y'all set?
Yes, Your Honor.
Okay. All right, Mr. Lopez, you are here. You're arrested on a warrant out of St. Lucie County on a driving license suspended. The allegation is that you failed to appear for arraignment. There is no bond on that, and I will appoint a public defender to represent you in the interim.
You aren't able to change that bond amount, Your Honor?
You're not supposed to. No, I can't do it. They don't want us to do it. I'm getting in trouble.
Sorry, please. Can I ask you something, please?
Sure.
What's going on in this case is that this Sports and Lucy, I went to prison in 2016. I was having a bad life. Now, it has passed a lot of years. My life changed. I have been working. My wife is pregnant from 5 months. But what's going on in that case is that I was in prison for 2 years, and then they never took me to take care of the case. When I came out from prison in 2018, I went to Miami. I live in Miami. I went to DMV. They gave me all papers, and I have my license valid right now. I don't know what's going on, sir. I really don't know what's going on. I don't want to be in jail no more. I have been years without being in jail.
All right, hold on. Just hold on just a second. Hold on. Can we check his driver's license and see if it is valid? Can we burn a license for him? I have a driver's license number.
Yes, Your Honor, hold on.
Does anyone have access to David?
I do. I'm looking it up.
I just want to see if it is valid. That may change my position. I might risk it. I guess it looks like he did not get a driving while suspended here because he got stopped for speeding, and that's how they picked him up. And it is a 2016 case. Although I'm not certain how he could have gotten it reinstated if there was a failure to appear still out there, even if you paid the late fee. I mean, I guess it could have done that.
I'm sorry, sir, for bother, but I went to school, traffic school in Miami. I know that for that ticket, and I don't know what's going on, sir. I really don't know. I don't want to be in jail. My wife is pregnant 5 months. I'm going to lose my job. It's a really old case. I had never been in trouble in years. I'm doing my life better. I'm just trying to resolve these things, so I don't want to go back here never in my life.
While you're up there, grab it down. Thanks. It's crazy. How did that happen? It says it's valid. All right, I'll step on.
The state objects, Your Honor, this is an out-of-county
I
warrant.
understand. His license is valid. It's a 2016 case.
Understood, Your Honor, but this is still out of county, and you have appointed the public defender. They should be able to argue that very quickly, get him returned, get this resolved. He should not be given a bond by an Orange County judge.
Well, during COVID, we did have the ability to do it.
Do you still have that ability, Your Honor?
I believe so. I don't think that that AO has not been changed. The one concern I have is what court date are we going to give him to report for? That's the difficulty. And it does look like he was in prison, got released in 2018. I don't know when this is a 2016 case. He had a 2-year sentence. So there's a possibility that he was in prison when this capias was issued, which would have been illegal anyways. I mean, they shouldn't have issued a warrant for him if he was in prison. He's in state custody.
Would you be able to give them a time span to report to court? Or
Yeah, I mean, that's problematic because then it's not, I mean, I can't really order him. I could, I suppose, as a condition of bond that he report, but if he goes to the clerk's office and they go, we don't have anything on this, we don't know what this is, that's the problem. All right, I'm gonna leave it at no bond. I said, the way that we were doing it before was we would have a court date, and I just don't, at this point, there's nothing I can do. I apologize, but I just can't do it. So we'll contact St. Lucie County, and hopefully they'll come and get you pretty quickly, I imagine. No bond on a driving license suspended. Your name, sir?
Maurice Patterson.
Hi, Mr. Patterson, you're here because you're arrested on a warrant for the charge of driving while suspended out of Brevard County, and the bond is $2,000. Okay. No, I didn't have it. I don't have it. Did you? Oh, yeah, we don't have this one either. I don't have Rodriguez at all. Yes, I do have Serrano. They bonded out? All right. And then the next one I have is William Kerner, Devontae William Kerner. All right. And your name, sir?
Deontay William Kerner.
All right, sir, you're here today because you're arrested on an out-of-county warrant. The bond is $250. It's out of Brevard County for a driving license suspended. Okay?
Yes, sir.
And appoint a public defender in the interim. Okay, your name, sir?
Darius Bush.
Bush, you're here because you're arrested on a charge of violation of community control. To your case real quick. And it's based on a warrant signed by the judge, and there is no bond on that. And I will appoint a public defender to represent you. On who? Oh, Mr. Bigney's already filed a notice in your case.
he has a private attorney?
Yeah, he has private. That must be why he called me yesterday. I missed a call from David, and that must have been telling me he's going to be doing that. All right, your name, sir?
Deion Denson.
All right, Mr. Denson, you're here for a violation of probation on your aggravated battery with deadly weapon and robbery with no weapon, and there is no bond on that. I'll appoint a public defender to represent you.
I'm sorry, who is this?
Deion Denson?
And what charges do you have for him?
I had it as a violation of community control or probation.
Oh, okay. Do you also have?
Yeah, yep, we have another one,
Yes.
2022. And you also were arrested on a charge of aggravated battery with a deadly weapon and battery. The bond on the aggravated battery is $5,000 and on battery is $500. And let me take a look real quick and see. Battery victim, alleged victim. And on the battery charge, you're not to have any contact with Wynita Cohn. That's Wynita, Cohn, last name Cohn. Katrina Harris, Marcus Wright, and Eric Ojudun, Ojudun. And no return to. I can say that the vicinity of a 600 block of West Jackson. No guns, no weapons, no drugs, no alcohol as well on that. And I'll point a public defender on the new charges too. Okay? Your name, sir?
Marco Harris, sir.
Okay. All right, Mr. Harris. You're here in 2019 CF 16308AO, and that's a violation of probation signed by, it was Judge LeBlanc, but at any rate, there is no bond on that. You want to, and I'll appoint a public defender to represent you. Your name, sir?
Marcus Hill.
All right, Mr. Hill, you're here because you're arrested in 2017 CF 9504. It's a violation of probation, and there is no bond on that. I will appoint a public defender to represent you. Your name, sir?
Marquise Lamont.
Mr. Lamont, you're here today because you're arrested on a violation of probation in 2018 CF 17256. And currently there is no bond on that violation of probation, and I will appoint a public defender to represent you. Yes. All right, I will appoint a public defender for Mr. New.
We'll waive the appearance, Your Honor.
All right, and he's being held on a violation of probation. There is no bond on those. Your name, sir?
Pedro Santana.
Mr. Santana, you are here today because you were arrested. You've got two cases. First of all, for a violation of probation in your grand theft and scheme to defraud, and there is no bond on that. And, whoops, that's in 2016, CF 14537BO. And in 2022, CF 5767, two charges, actually four charges: dealing stolen property, violation of Pawnbroker Act, grand theft, and petty theft. This is based off of a probable cause warrant signed by another judge. Bond set $2,500 on the dealing and stolen property, $500 on the pawnbroker violation, and $1,000 on the grand theft, and $500 on the petty theft. And I'll appoint a public defender to represent you on that case as well. Yes.
Robert Scott is downtown court.
Oh, he went downtown?
Yes, sir.
Can we waive his appearance for this?
Already, yeah.
If it's a VOP?
We'll go ahead. On the VOP, there's no bond on that. I appoint a public defender on the violation of community control.
On Robert Scott?
Robert Scott.
Isn't there a $2,000 bond?
Oh, is it 2,000?
20 CF 11274?
Yeah, you're right. It is 2,000. Mark Blackman in soft. Okay, yeah, and he does have a private attorney. Let's see. Yeah, from March. Oh, that's Mike LaFay's case.
Does that change the waiver of his appearance then?
I mean, I suppose it should.
Is the court able to waive sua sponte?
I think, I think I can. He already had, his attorneys filed a notice. He had, I don't think. He was in Seminole County. Because Chelsea Simmons already filed a notice of appearance, written plea of not guilty and waiver and all that, so I think that it's done, so don't have to worry about that, yeah. Just waive, court will waive his appearance. Okay. Your name, sir?
Antonio Maximo Luna.
All right, Mr. Luna. Are here for a violation of probation on your DUI case, and there is no bond on that, and I'll appoint a public defender to represent you. What's that? Oh, yeah, do you want to go ahead and enter a denial?
Yes, Your Honor.
Enter denial. We'll go ahead and set that for a violation of probation status or hearing date. What is the date?
Division 80, BOP status, July 29th at 8:30, courtroom 9C.
You say 9:30, I'm sorry?
Yes.
Thank you.
Okay. Yeah, the one we wanted to read.
Back to this office in Orange, and I kept thinking, oh my God, something happened. I didn't disconnect out of Osceola. We're here. And I have late lunch, so it's my responsibility. We're taking alternate lunches, Your Honor, so there's always an interpreter available, even through lunch nowadays.
That's good to know. Thank you.
Yeah.
All right, she is wearing the headset.
She can hear the interpreter.
Your name, ma'am?
Wendy Fernandez. Wendy.
Wendy Fernandez.
All right, ma'am, you're here today because you were arrested on a charge of driving while license suspended as an habitual offender and an officer without violence. I have reviewed the charging affidavit of probable cause on the set of, I'm going to reduce it to $1,000 on the driving while suspended and $100 on the resistance without violence. We'll appoint a public defender to represent you. Also out on bond in 22 CF 3938AO. Drug paraphernalia, I assume that's not been filed on yet. And also on the 2022 CF 3483AO, possession of fentanyl, possession of cocaine, possession of drug paraphernalia, and drug license as a habitual traffic offender. In that case, 2022 CF 6357, I'll revoke that bond. There'll be no bond in that case. The other bond I'll leave in place.
It's a no.
One that has the drive on suspended. Yes.
And said no bond.
Yeah, they'll take no action on the other one.
It's a no bond, Judge.
Yep. And that's it for interpretive cases. Alrighty, thank you, ma'am.
You're welcome, Your Honor. Have a great weekend.
You too. So should I also fire up the?
Welcome to an Econo meeting. You are entering the meeting now. You are the only participant.
So alone. Okay, we'll just figure it out. All right, your name, sir? All right, Mr. Alphonse, you're here because you were arrested on off a probable cause warrant for the charge of written threats to kill or do bodily harm. The bond set on that is $50,000. I will appoint a public defender to represent you. If you do make bond on that case, you're not to possess any guns or drugs, no weapons or alcohol, and you're also not to go to the campus of Freedom High School, I think it was. Yeah, Freedom High School, all right? Appoint a public defender to represent you.
You should have called us.
You're all set. All right, your name, sir?
Dennis Ramos.
All right, let's see. Mr. Ramos, you're here for a few cases. First of all, in 2021 MM194, you failed to appear, and so in 2 battery charges. And those bond, there is no bond on those. However, if you qualify for mental health pretrial release, then they will. You can be released to that program. In addition, you have a new charge in 2022 CF 1287AO, battery on a firefighter or EMT. And bond is set on that case at $1,500 or mental health, and I'll also put that same condition, or mental health pretrial release. And I will appoint a public defender to represent you. Yep. Yeah. No, it was 0 or mental health pretrial release. Yeah. And then this one, it's 1,500 or, and I added them, or. All right, sir, your name? Romano, let's see. All right, you're here today because you were arrested on charge of possession of a controlled substance without a prescription based upon a probable cause warrant signed by another judge. Bond is set in the amount of $1,500. I'll appoint a public defender to represent you on that. Is there another case? Nope, that's all he's got. Thank you. Your name, sir? Your name?
Rodney.
You can keep it out. Just talk through it to the. Go ahead.
Wadney Armand.
Hi, Mr. Armand. You're here today because you're arrested on 3 charges in 2022 MM 3707AO. 1 count of trespass on property after warning, and 2 counts of resisting an officer without violence. I have read the charging affidavit, and they do find sufficient probable cause. Bond set amount of $500 on the trespass, $100 on the resisting, and $100 on the second resisting. And I'll appoint a public defender to represent you.
Your Honor, there was an offer to resolve.
Okay.
I did speak with Mr. Armand before the court, went over the plea form with him, and I believe he wishes to resolve no contest. He just
Okay.
needs to sign the plea form.
Is that, and what is the agreement?
I'm sorry, an adjudication, time served, and no return.
Okay. All right, Mr. Armand, is that what you want to do?
Not go back to the lake yet.
Okay, but you want to enter a plea of no contest today and resolve it?
Just a moment, Your Honor.
Okay, sure.
Can you sign the plea form
Yep,
first?
go ahead.
This is the plea form,
Yeah,
correct?
finish signing that.
So the plea is basically saying that he was right.
No, you-
Oh, yeah, definitely.
Okay, all right. You were busy signing, and you got that confused. All right, so you're gonna enter a plea of no contest. Are you under the influence of any drugs or alcohol today?
No.
Have you suffered from or been treated for any mental illness in the past? All right, you understand the rights on that form? Do you have any questions about anything on that form?
No.
You understand that the trespass is punishable by, actually, all of these are punishable by up to a year in the county jail, up to $1,000 fine, and that the entry of your plea could result in deportation if you're not a citizen.
Can't see you.
Understand all that? Mr. Armand?
Yes, sir.
All right. I do find sufficient factual basis to accept your plea. As to count one, I will judge you guilty, sentence to time served. Count two, judge you guilty, sentence to time served. Count three, guilty as sentence to time served. I'll impose court costs and a $50 cost of prosecution. That's a total of $273. I'll have you pay that within the next 24 months. And then finally, you're not to return to, and do we have an address there?
Okay. Can I get a bus pass?
It's Lake Eola. They have the address as 512 East Washington Street.
All right, you're not to return to 512 East Washington Street. All right, thank you. What's the time served? Two? 2. Your name, ma'am?
Tanya Harris.
All right, Ms. Harris, you're here today because you were arrested on a charge of battery. I have reviewed the charging affidavit, and I do find sufficient factual basis. I will set bond on, oh, wait, what was it? Is it already at 500? Yeah, the bond set on that is 500. If you do bond out, you're not to possess any drugs or weapons, any alcohol or firearms, and you're not to return to the 4532 South Orange Blossom Trail, where this allegedly occurred, okay?
It says something about pretrial release, something.
No, you have a $500 bond, you don't qualify for pretrial release. You're also, yes,
I apologize. If they could also be a no contact?
all right, and no contact with, isn't it like a out of,
David Gant.
yeah, I think he's an out-of-town deputy. Yeah, no contact with Mr. David Gant either.
Oh, what if I can't get bonded out because I can't get in contact with my mom? They let me use the phone at the bucket.
What are the two cases that she's out on bond on?
A lady did come to my cell when I was in the holding, talking something about pretrial release. I don't know. Wait, hold on, man.
Well, she probably came to talk to you, to ask to see if you qualify, but you don't qualify.
Oh, I don't.
Yeah. They have to get the information from you to decide whether you can or you can't.
Your Honor, I believe they're both trespass cases, but candid to the court, there also does appear to be competency issues.
All right, I won't take any action on this. All right, good luck.
So,
Your name, sir?
Thomas Leslie Jordan III.
All right, Mr. Jordan. You're here today because you were arrested on a charge of violation of repeat
Violation
violence.
of injunction?
Yeah. I do find that there's sufficient probable cause. Bond is set in the amount of $250 on that, is that right? And then you're out on bond currently.
Yes, sir. Those charges were back in March 7th. They still have yet to file any charges on those. And I've been bonded out a few times on those.
A few times?
Once.
All right, I'll take no action on that, but if you do bond out, you're not to return to first of all, to abide by the conditions of the injunction that is in place. More importantly, you're not to return to 5524 Gamer Drive or Gamar Drive. And you're not to have any contact with Jack Niederreiter, Niederritter.
Right now, I really don't have no money or anything, and I really didn't, I wasn't.
Hey, Dave, no, hold on.
Don't talk about the case because they're recording it and it could be to your detriment. But you're not to have any contact with him or to go back to that address. That's simple, okay? Because if you violate the injunction, you'll be back. All right, and I'll appoint a public defender.
Cynthia Snyder Wind is medical, Your Honor.
We'll waive the appearance, Your Honor.
All right, was there an offer in that case? So I'll reset it for Monday to see you. If,
You can reset it, that's fine. There was an
I
offer.
mean, I'll go ahead and I find probable cause and we'll set the bonds.
I would just reset it to Monday. Just
wanna do
sometimes
that?
judges want to reset it for Saturday, which
Yeah, no,
you can reset it for Monday.
Was there two? Who is it? Oh, maybe. Duval, yeah. I mean, was there an offer in the case? Do you think she'll?
Yes, there was, Your Honor.
She's got two. All right, I'll reset it for tomorrow just to see. If Judge Dubois, if she's not out, then he can decide what he'll do. I'll let him know that we did that for a possibility that she could plea.
I'll address one of them now then, Your Honor.
Okay.
With regard to 22 MM 3721, possession of drug paraphernalia, the state announces a no information.
Okay. So that just leaves the one, and I'll reach out to him, let him know that it's been rolled till tomorrow, and that that was for purposes of a possible plea.
Thank you, Your Honor.
Yes. Yeah. All right, sir. Your name?
Trevor St. Joseph.
Okay. All right, Mr. St. Just, you're here today because you're arrested on a charge of, or two charges, resisting officer without violence and disorderly conduct. I've read the charging affidavit. I do find that there's sufficient probable cause. The bond is $500 on the resisting and $250 on the disorderly conduct.
Your Honor, we would just have you stay those bonds. He has been working with his attorney as well. At the out-of-bond case has been moved to pretrial diversion. So I would have you take no action on that, but.
So the 2022, that case MM is going to pretrial diversion?
It's been referred, Your Honor. He's not been approved at this time. Okay. He was only referred May 25th. And it's for essentially the same charges, Your Honor.
Yeah, that's what bothers me. Well, yeah, I'll revoke that bond. It's gonna be no bond. It's the same thing. He's still out there fighting. And
Would you consider?
if it turns out it's pretrial diversion, obviously, then, you know. if
Would you
it's-
consider? Would you consider setting a bond in the out-on-bond case instead of revoking outright?
It's currently now 500. Can't really read what it says. Or maybe it might be 500, 500. It's 1,000. All right, I'll increase the bond on those to 1,000 each. Because I assume that's what it looks like. I see cash 500, then it says cash 1,000, so I can't tell. Hold on. Yeah, it's confusing too. All right, so I'll revoke and then set new bonds, 2,000 on count one and 1,000 on count two. And the public defender's already been appointed, so.
Thank you, Judge.
Your name, sir? Your name?
Tyshawn Marquis Thomas.
Your name?
Tyshawn Marquis Thomas.
Mr. Thomas, you're here on a charge of trespass in an occupied structure. Have you the charging affidavit? I do find sufficient probable cause. Is there an offer?
There was an offer to resolve, Your Honor, an adjudication, time served, no return. Did have a chance to speak with Mr. Thomas before court. I believe he wishes to resolve no contest. He just needs to sign the plea form.
Oh, is that correct, Mr. Thomas? You want to enter a plea of no contest?
That's correct.
All right. Go ahead and sign your plea form. All right. Are you under the influence of any drugs or alcohol today?
No, sir, of course.
Have you suffered from or been treated for any mental illness in the past?
No, sir.
At that plea form that has those rights, you understood those. Do you have any questions about the rights?
No, sir.
You understand that this is punishable by up to a year in the county jail, up to $1,000 fine, and that the entry of your plea would result in deportation if you're not a citizen. You understand?
Can you explain that last statement again, Judge?
Sure. That this is punishable by up to a year in the county jail, up to $1,000 fine, and that the entry of your plea could result in deportation if you're not a citizen.
Oh, so basically, if
All right. I do find sufficient factual basis. I will adjudge you guilty, be sentenced to the time you've served in the Orange County Jail, and I'll impose court costs, $50 cost of prosecution to the state. It's a total of $273, and I'll give you 24 months to pay that. You're also not to return to, as an order of the court, to 1518 Roscommare Avenue, Roscomare. If you do return there within the following year, and the court's made aware that you are subject to a contempt citation, in which you could be sentenced up to 180 days in the Orange County Jail. All right, you'll be released as to that case.
And the outer.
No action on the bond case. All right, your name, sir?
Antonio Tillman.
Hi, Mr. Tillman, you're here today because you were arrested on charge of trespassing in a structure of conveyance. I have read the charging affidavit. I do find that there is sufficient probable cause.
There was an offer to resolve, Your Honor, an adjudication of guilt, time served, no return. I did have a chance to speak with Mr. Tillman before court. We went over the plea form, and I believe he wishes to resolve today.
Okay, Mr. Tillman, is that right? You want to enter a plea and resolve your case?
Yes, sir.
Okay. Are you under the influence of any drugs or alcohol today?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
No.
All right, you read over that plea form, understood those rights. Do you have any questions about the rights?
Yes, sir.
You do?
Huh?
You have any questions about the rights?
No.
All right. You understand this is punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your plea would result in deportation if you're not a citizen.
Yes, sir.
All right, I will accept your plea. I will judge you guilty of the offense, be sentenced to time served.
Okay.
All right, there'll be court costs and a $50 cost of prosecution, total of $273. And I'll give you 24 months to pay that. Finally, I'm going to order that you not return. And what is the address? Blank.
6700 Central Florida Parkway.
6700 Central Florida Parkway. Not to go back there for a period of 1 year. If you do go back there and the court's made aware of you, are subject to contempt citation, which could result in up to a 180-day jail sentence. Okay? All right, you'll be released. Your name, sir?
Dwayne Alfred Philip Weber.
Okay, Mr. Weber, you're here today because you were arrested on a charge of disorderly intox. And I have read the charging affidavit. I do find that there's sufficient probable cause.
There was an offer to resolve, Your Honor, an adjudication, time served. I spoke with Mr. Weber before court, and I believe he wishes to resolve today. No contest plea.
All right, Mr. Weber, is that true? You want to enter a plea of no contest and resolve your case?
Yes, sir.
All right, go ahead and
Yes,
sign
Your
your plea form. All right. Are you under the influence of any drugs or alcohol today?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
Yes, sir.
And you understand what's happening here today, though?
Yeah.
Understand what the charge is all about?
Yes, sir, I do.
All right. You also understand that your, the rights that were on this plea form, you signed it, and do you have any questions for me about them?
No, sir.
Okay, this is punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your plea could be used against you in a deportation proceeding if you're not a citizen. You understand all that?
Sir, I do.
All right, I do find sufficient factual basis, I will judge you guilty and impose court costs and a $50 cost of prosecution, sentence you to time served. The court costs and cost of prosecution will be a total of 270, wait, is it a county case or a city case? Okay, so 273, and I'll give you 24 months to pay it. Okay?
Thank you, sir.
All right, you're all set.
Have a nice afternoon.
All right, your name?
Jeremiah Matthew Lambert.
Mr. Lambert, you're here today because you're arrested on your petty theft charge for failing to appear. Looks like they actually had filed a motion to quash the capias, but just didn't get it there in time. Is this on a VOP? I was on a VOP. There is no bond on that, and appoint a public defender if you don't already have one. Looks like I think you do because somebody filed a motion for you. Yeah, just failure to appear. Yep, give them a new date. We'll get-
Division 82, VOP status, July 7th at 9 o'clock, courtroom 9B.
So I'm gonna be here for a long time, probably.
Potentially, but you have an attorney, and the attorney will speak to the state or in the judge and see if there's a possibility of getting you a bond set or something. So it's not a guarantee.
Wash, that was supposed to happen.
Well, I think that was yesterday.
It was actually today.
Yeah,
It was-
so
I was supposed to go in today.
whoever your attorney is, they got it served before they could get it done. So your attorney can speak to Judge Gibson about that.
And I don't have to worry about a bond or anything.
Not at this point, no.
So basically,
The capias that she issued was a no bond capias, so.
awesome. So basically, right now, I just
Meaning there isn't a bond, so you can't bond out.
can't bond out right now. So I have to wait for
Yep.
my,
Your attorney will speak to the state and the judge. Okay?
all right, thank you.
Your name, ma'am? Your name?
Selena
Last name?
Perez Vasquez.
All right, ma'am, you're here today because you were arrested for failing to appear on your prostitution charge. The bond is set in the amount of $2,000, and it will appoint a public defender if not previously appointed.
All right. Okay.
Your name, sir?
People Hampella.
All right, sir, you're here today because you're arrested on a charge of open container. I do find there was sufficient probable cause.
Your Honor, there was an offer to resolve, I believe, the state on behalf of the city, withhold and time served. I spoke with Mr. Hempella about the state's offer, and I believe we went over the plea form, and I believe he wishes to resolve with no contest plea.
All right, so you wish to enter a plea of no contest, is that right, sir?
Yes.
Okay, go ahead and sign your plea form.
And I spoke with him as a friend of the court, so there's no need to appoint us.
Okay.
Save $50.
All right, sir, are you under the influence of any drugs or alcohol today?
No.
Have you suffered from or been treated for any mental illness in the past?
No.
All right, you understood the rights on this form. Do you have any questions about the rights on the plea form that you signed? Any questions about the form? Any questions?
I think you covered everything.
All right. You understand that this is punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your plea would result in deportation if you're not a citizen?
Yes.
All right. I do find sufficient factual basis. I'll withhold adjudication. You'll be sentenced to the time you've served in the Orange County Jail. I will impose court costs and a $10 filing reimbursement, so it's going to be a total of $233, and I'll give you 24 months to pay that. Okay?
Sounds perfect.
All right, you're all set? Your name, sir?
Douglas Scott Mall.
Mr. Mull, you're here today because you're arrested on a charge of soliciting without a permit. I have reviewed the charging affidavit, and I do find sufficient probable cause.
Your Honor, there was an offer to resolve a withhold and time served. I spoke with Mr. Mull about that state offer, as well as went over the plea form, and I believe he wishes to resolve no contest. I spoke with him as a friend of the court.
All right, Mr. Mull, is that what you want to do, is enter a plea of no contest and resolve this? Okay. Are you under the influence of any drugs or alcohol? Have you suffered from or been treated for any mental illness in the past?
No, sir.
All right, this plea form, you understood the rights before you signed it. Do you have any questions about the rights on the form? And you understand that this is punishable by a maximum of 60 days in jail, up to a $500 fine, and that the entry of your plea would result in deportation if you're not a citizen?
Yes, sir.
All right, I do find sufficient factual basis. I'll withhold adjudication, sentence you to time served. I'll impose court costs and a $10 filing reimbursement, to a total of $233, and I'll give you 24 months to pay that off.
Thank you,
Okay?
sir.
All right, and I'll
Your
take
Honor-
no action on the bond.
Your Honor, what case number do you have for the?
For this case, I have 2022 CO 662AO. Is that what you have?
I didn't find a correct one. That makes sense. Thank you.
I'll try to remember to yell it out for you guys and for the court reporter.
Thanks.
All right, come on forward, sir. Your name, sir? Your name? Last name? Hi, Mr. Tachi, you're here today because you're arrested on a charge of disorderly conduct. I have reviewed the charging affidavit, and I do find sufficient factual basis. In that case, it's 2022 MO 676AO.
There was an offer to resolve. The state's offer on behalf of the city was a withhold time served. Spoke with Mr. Tachi, went over the plea form, and as a friend of the court, I believe he wishes to resolve no contest.
All right, Mr. Tachi, is that correct?
Yeah.
All right, are you under the influence of any drugs or alcohol?
No.
Have you suffered from or been treated for any mental illness in the past?
Yeah.
You take any medication for that?
Yeah, I do.
And you understand what's happening here today? You understand what this charge is about?
Yeah.
Okay. You have any questions about anything that's on this plea form here? The one that you signed, any questions?
No.
Or you understand that disorderly conduct is punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your plea may result in deportation if you're not a citizen? You understand? Okay, I do find sufficient factual basis. I'll withhold adjudication, be sentenced to time served. I'll impose court costs and a $10 filing reimbursement. That's gonna be a total of $233, and I'll give you 24 months to get that paid off. Okay?
Thank you.
All right, you'll be released as to this case. All right, your name, sir? Your name? Your name? Good morning. Your name?
Ricardo Francis.
All right, Mr. Francois, you're here for two or three cases. First of all, you're charged, you were arrested for a charge of driving while license suspended. I did review the charging affidavit, and I do find that there is sufficient probable cause. Bond set in the amount of $500 on that. And then you were also arrested on a charge of resisting an officer without violence, and that's in 2022 MM 3714AO. Bond set in the amount of $500 on that. Those are the two. Now, I'll appoint a public defender to represent you.
Yes.
Your name, sir?
Hi, Your Honor. My name is Isaac Milan Sepulveda.
All right, sir, you're here today for two things. First of all, in a driving while license suspended charge, you failed to appear on that, and bond is set in the amount of $2,500. And that was in 2020, I think, CT 2616. Hold on, I lost my spot.
I think that one is.
No, that was 2019, right?
Yes, sir.
Yeah.
I mean, yes, Your Honor.
All right, so in the 2020 2616, You failed to appear for a no valid driver's license charge. And I'll set that bond at $100. I'll lower that bond. And I'll appoint a public defender for you in both cases.
Maria Velasquez Alamanza, bonded.
Okay.
Sabor Abdullah is in the house today.
We'll waive the appearance, Your Honor. It's a FTA.
All right, I do, set bond in the amount of, what is it,
Your Honor, it's an
1,000?
FTA.
What's that?
It's an FTA.
Right. Okay.
Is it in, no, it's a felony FTA.
We're on Abdullah, Sabor Abdullah.
Oh, it's a, yeah, there is no bond on that, according to the warrant. Yeah, we'll waive his appearance, yeah. And your name, sir? All right, Mr. Aquino. Mr. Aquino, you're here, you're arrested on 8 charges. I have read the charging affidavit, and I do find that there's sufficient probable cause on those. The first charge is sale or delivery of fentanyl. The bond is $5,000. Second charge, possession of drug paraphernalia with intent to sell. Bond of $2,500. Third is possession of firearm by convicted felon, $5,000. Possession of firearm by convicted felon, or ammo by convicted felon, that's $5,000. Trafficking in fentanyl, 28 grams or more. State, want to be heard?
You want to, I'd have to look at the schedule because considering.
From what we were
that
talking about yesterday, I think it was $1 million if it's over 28.
It could well be, but because there's also a weapon, it could also be a PBL, Your Honor. I think actually it is a PBL based on the trafficking amount, that it's over, it's 4 grams is trafficking. So 28 and a weapon, I believe, is punishable by life, Your Honor.
Is that the charge? Or was it just trafficking?
Well,
Yeah,
it does
they didn't,
say
I don't think that, well, I don't know, they didn't write that in, so.
No, they did not.
I'll set it at $1 million. Possession of firearm and commission of felony, that count 6, lower that to 1,000. Unlawful use of a two-way device, 2,500, and delivery or manufacture of drug paraphernalia, reduce that to 1,000. And I will appoint a public defender to represent you.
Your Honor, there is a 9th charge.
There is?
Another, yeah, there's another possession of firearm by a convicted felon.
Another 1,000.
Any conditions, Your Honor?
Yeah, if you bond out, you're not to possess any drugs or weapons, no firearms, no alcohol. Were there any co-defendants? I didn't see any. Yeah, I think that's it. Okay, that'd be it. And again, the public defender is appointed. Your name, sir? Your name? All right, Mr. Bruce, you're here because you're arrested on a charge of driving while suspended as an habitual traffic offender. I have reviewed the charging affidavit, and I do find sufficient probable cause. I'm going to lower that bond to $500 and appoint a public defender for you.
Your Honor, did you notice that he had a VOP for a DUI just last year?
No?
October of
That
2021.
was probably what caused him to be habitualized. That was probably the last strike. Yeah, I'm gonna still leave it at 500 because they'll file this as a it'll get kicked down to county. It always does. Everything runs downhill. Your name, sir? Hi, Mr. Chooks. You are here today because you were arrested on 3 charges. Or 2 charges, I guess. Yeah, possession of methamphetamine and possession of drug paraphernalia. The bond on the possession of methamphetamine is $1,000. The bond on the possession of drug paraphernalia is $100. If you do bond out, no drugs, no alcohol, and I'll appoint a public defender to represent you.
Just a moment to confer, Your Honor.
Now, here's one with a private attorney that no one's. So you said the one was here live and two said they were going to appear virtually, right? Okay. Oh, it wasn't green, I guess that. Let's see. They probably could hear us, though, right? They're like, hey, out there. See if they Easy, slow. It's black. All right, there's somebody. Counsel, which case are you here on?
I assume you're speaking to me,
Yes, I am.
correct? Okay, I'm here on John Luciano.
Okay, we're not quite to that. Just want to make sure we didn't get past you. So we haven't called this case yet. We'll be there in a second. All right, sir.
I'll hang tight.
Yeah, all right. Your name, sir?
Colin Glennon.
Mr. Clennon, you're here today because you were arrested for failing to appear in your fraudulent use of personal identification. There is no bond on that failure to appear.
Yeah.
And I think you have an attorney already in the case. Did you hire Mr. Reese?
Yes. I was actually arrested for an outside warrant at Madison County, and the failure to appear was I was arrested when I arrived at the courthouse yesterday, so that's how that happened.
Well, the one thing that I have right here in front of me was for a failure to appear here in 2019 CF 9491BO. Okay. All right. And Mr. Reese is in the case. All right, your name, sir?
Anthony Lee Day.
Okay, Mr. Day, you're here in two cases. First of all, 2021 CF 11512AO. In that case, it was a grand theft. You failed to appear. And there is a bond in the amount of $500 on that. And in the other case, which is 2021 CF 6334, the failure to appear on a leaving the scene of an accident, and there's a bond in the amount of $500 on that. And I think the public defender has already been appointed in your case. All right. Thank you, sir. Hmm? Sure. Okay, that was the one. Did the state see that? When I was looking at it, it said 500 on the actual arrest, but the warrant that's attached to it says 4,000.
I don't know which one you're referring to, Your Honor.
Oh, Day, the last guy we just did.
And are we talking about the felony or the CT?
The felony.
4,000 does make a lot more sense.
I thought so too. That's why I flipped the page, but then I forgot when we got to it, because I noticed that when I was reading it. So that was actually in 2021 CF 11512AO. What do you guys, you show it as 4,000 or is that? Okay. Yeah, so we need to let them know that it is actually 4,000. That's what it should have been. Yeah, let's do that.
And I apologize because I don't have warrant on.
That's okay, that's all right.
4,000
When
per
she
the
showed it to
warrant?
me, I remember reading it thinking, oh, I need to remember that, and then of course I remembered to not remember or whatever. Anyways, your name, ma'am?
Brianna Espy.
All right, Miss Espy, you are here for a number of things. Let's let's see, first in 2022 CT 6353 AO, it's three counts, possession of fentanyl, possession of cannabis, less than 20 grams, and grand theft third degree of a motor vehicle. I have read the charging affidavit, and I do find sufficient probable cause. The bonds are $1,000 possession of fentanyl, $100 possession of cannabis, and $150 for the grand theft motor vehicle. And I'll appoint a public defender for you on that case.
Your Honor.
She does? All right, well, yeah, you're right, I missed it. And then the second case is 2022 CT 3032 AO. In that case, it's a no valid driver's license, and I do find sufficient probable cause. I'll set that bond at $100 on that one. And the public defender is appointed as well. Now, did you want PTR?
Yes,
Oh.
yes, please, Your Honor.
Hold on, what's the other? Yeah. So, she's not out on something else, right? No. All right, so you want pretrial release conditions? All right, I'll release you with pretrial release conditions. You're not to possess any drugs or alcohol, or consume either of those, and you're not to possess any weapons or firearms, okay?
Sir.
And I will appoint a public defender to represent you.
Your Honor, can I have a moment to confer?
Sure.
You just want those conditions for the 353 case?
Yes. Oh, no.
Do you want any conditions?
No, just on the felony. Don't worry about it. She can just do, oh, you know what, she doesn't want to do the bond. Yeah, then go ahead, same conditions.
Your Honor, can I have the case number for the CT case, please?
The CT case is 2022 CT 3032 AO. No valid. Oh, Mr. Day, I misspoke before on the grand theft failure to appear. The actual amount that was on the warrant is not 500, is actually 4,000. I misspoke. On the grand theft motor vehicle, it's 4,000. That's what the judge required. Okay, so it's 4,000 on one and 500 on the other. But you're still eligible. Luciano. Okay. Your name, sir? Your name?
John Luciano.
All right, Mr. Luciano. There he is.
Your Honor, Jason Willis on behalf of John Luciano.
All righty. Mr. Luciano, you're here because you were arrested on from a probable cause warrant for the charges of.
Your Honor, waive the reading of the charges.
All righty. I do find sufficient probable cause.
Would you be inclined to please set bond on those?
State want to be heard?
Yes, Your Honor. With regard to count one, that is a first-degree felony. Actually, that is a life felony, Your Honor. Having read the probable cause affidavit where the defendant said that he thought that it was a dream, and he couldn't say that it didn't happen, state would ask the defendant be held no bond, at least on count one.
Counsel, response?
Your Honor, I believe that he is no threat. There is an injunction, I believe, that was scheduled for today in place. I believe he lives out of state. He will have no contact with the victim or their family. I don't believe he is an immediate threat. I believe a bond is appropriate in these circumstances.
Where are you going to go, Mr. Luciano, if you do have a bond?
I will talk to my daughter.
Where does she live?
Randall.
Your Honor, and his daughter is been in contact with our office. She is assisting with his representation.
And he doesn't have any priors or any other criminal history?
Not that I know of, and not that the defense is aware of.
Your Honor, just for clarification, Did counsel say that defendant was going to leave the jurisdiction? That he was going to leave the area?
No, I think he said he's not
I
from
did
there.
not,
Yeah, but
I
he
don't
said
think,
that.
I think he lived,
Go ahead.
I'm sorry, Your Honor, I didn't mean to interrupt.
Sorry.
I do believe he lives out of state. I did not say that he was going to leave the jurisdiction.
Oh, okay.
Yeah, Mr. Luciano said that he was going to speak to his daughter about staying here, and she lives in Orlando.
Ah, okay.
So, okay, all right, as to count one, I'll set bond the amount of $15,000. Count two would be $5,000, and the last count would be $1,000. And no contact with any of the alleged victims or the alleged victim's mother. Let's see if we've got those names. No return to the alleged victim's address. Do we have that?
Your Honor?
Is that 2500 West Colonial? Yeah.
Your Honor, the state would ask for considerably more on count one, considering that we give million-dollar bonds for drug offenses that are not life felonies. This is a life felony where there is a victim and probable cause has been found.
Your Honor, I would just respond to that is a reasonable bond. I would ask that you leave the bond as is.
Yeah, I mean, I think the difference is, in a $1 million case, that's because that's a person is, also too, there are firearms and all that. It's more of a danger to the community. Not that this is not an egregious allegation, but it's more confined. So I'll leave them as I've pronounced. No contact with Tanya. Do we have a last name? I didn't see one. Tanya Cancel is the mother, and so no contact with her, no contact with any of Miss Cancel's children or any witnesses or the alleged victim in the case.
Your Honor, I would also ask for supervised contact with any minors.
Okay, that's fine. Yeah, if you have, I'm just gonna say no contact with any minors. That's even easier. No contact with any minors. Does your sister have kids?
Daughter.
My daughter?
Your daughter, I'm sorry, yeah.
Oh, she does.
Okay, that's good. And no guns, no weapons, no drugs, no possession or use of drugs or alcohol. And I think that's it.
Thank you, Your Honor. Your Honor, I have nothing further before the court may be.
Yes, you may.
Thank you.
In a parking lot. Who's Flukes or Flakes? That's Flakes. All right, let's just go ahead. Counsel, what case are you here on? Oh, it froze just when I spoke. I'll come back. All right, Mr. Flakes. That isn't your attorney there, is it? Is it? Is that do you have an attorney?
Yes, Your Honor.
Was that your attorney that was on the video, do you think? I don't. Are you here on Mr. Flakes?
Can you hear me?
Yes, I can.
Yes, sir. My name's Ben King. I'm appearing on behalf of Mr. Arroyo for Mr. Flakes.
Okay, all right. All right, Mr. Flakes, you're here because you were arrested. Hold on a second.
We'll waive the reading of the charges, Your Honor.
All right. There it is. And you're here for failing to appear on those charges, and currently there's no bond set on those, all 12 counts for the failure to appear. All right, and you do have an attorney already, so we won't consider that. Is there anything that you wanted to be heard on, counsel?
Your Honor, it was my understanding that it wasn't a willful failure to appear, and that I I didn't get the details as to why, but we would request that a bond be set for these charges, please.
Let me take a quick look here and see what we got. Actually, looking at it, it looks like what occurred was the state filed a motion to revoke the bond on March 28th because of an allegation of new offenses. And there was a hearing set, and it looks like the defendant failed to appear at the hearing. And the bond was revoked then. There was a capias issued. I don't know if they ever went forward with the motion to revoke the bond.
Yeah, I understand it. What I was informed was that his appearance at that hearing was that he missed it on accident. I didn't get the details as to why. I was only given this while I was on my lunch break. So I wish I had more information for the court, but
Yeah, okay, I'm looking at the court minutes now. It reads, this is the court minutes from that April 11th hearing with Judge Barber, and the notes indicate, court read the state's motion and reviewed the probable cause on a new charge. The court finds probable cause the defendant violated conditions of release. The court grants the state's motion to revoke bond. Court orders the bond forfeited and revoked. The court dates remain as previously set. Counsel for the state to set a status hearing prior to April 18th. So we're gonna go ahead and I'll leave those as no bond, and he has an attorney. So, all righty.
I appreciate your time, Your Honor. Thank you.
Thank you.
That's all I have. Have a great day, everyone.
You too.
And Mr. Flakes, Mr. Arroyo will be in contact with you soon.
Okay.
Thank you, everyone.
Thank you.
Okay.
Take care. Your name, sir?
You are the only participant.
Did they get you to record that?
Flanders.
It does sound kind of like you, though. Well, probably not to you because your voice sounds different to yourself, but don't you guys agree that it kind of sounds like her? Like if, she was like just kind of waking up, like, because her voice is a little deeper than that, but it's funny. It just hit me right then. I hadn't thought of that before. I've heard that 1,000 times, but. All right, your name, sir?
David Brian Flanders, sir.
All right, Mr. Flanders, you're here today because you were arrested on a charge of possession of cocaine, possession of drug paraphernalia, and you had failed to appear. Or is that a probable cause warrant? It was a warrant. The bond on that is $1,000 on the possession of cocaine, and I'll make it $100 on the possession of drug paraphernalia. Yeah, it's 1,000, and I'll reduce it to 500, from 500 to 100. Yeah, so leave it at 1,000 for possession and 100 for paraphernalia. And appoint a public defender to represent you, sir. Your name, sir? Your name?
Edwin Fuentes.
All right, Mr. Fuentes, you're here today because you were arrested on charge of driving while your license was suspended as an habitual traffic offender. And I do find that there's sufficient probable cause I will set the bond in the amount of $500. Appoint a public defender to represent you.
Just a moment, Your Honor.
Sure.
He does qualify for that.
He does. Does he want that?
That's what I'm conferring with him about.
Alrighty. Should look at that.
They just stay the bond, Your Honor.
Alrighty. Why not?
Hello.
Hello. Your name, ma'am?
Hi. My name is Brandy Guzman.
Hi, Ms. Guzman. You're here today because you were arrested on charge of aggravated battery with a deadly weapon. I have reviewed the charging affidavit. I do find that there's sufficient probable cause. Bond is set in the amount of $3,500. If you bond out, you're not allowed to possess any guns or weapons. You're not allowed to possess or use any drugs or alcohol. And you're not to go back to the hotel at 2500 33rd Street, okay? So you can't go back to that hotel and have any contact with Clive Ford, F-O-R-D, the alleged victim, okay?
Okay.
And I'll appoint a lawyer for you, so you'll have the public defender will be appointed for you. Mm-hmm. Your name, sir? All right, Mr. Howard, you're here today because you were arrested on 3 charges. Count 1 is possession of cocaine with a weapon. Count 2 is carrying a concealed weapon. And finally, possession of drug paraphernalia. I do find there's sufficient probable cause. The bond on the possession of cocaine is $7,500. Carrying a concealed weapon is $1,000, and the possession of drug paraphernalia, reduce that to $100. And I'll appoint you a public defender to represent you, so you have a lawyer, okay?
Your Honor, no weapons, no firearms?
Yeah, no weapon, firearms if you bond out.
Do you also have a VOP?
Did he?
He needs to come back.
Singh, he needs to come, the other one
Didn't
needs to
see
come
it.
back. He had a VOP.
Did he have a VOP?
Yes.
Oh, it's now to county.
Oh,
Okay.
never mind. Yeah, it doesn't get addressed here, right? Because it's out.
We can do it now.
Okay.
No, it's for today.
Yes, if you could, yeah.
That's in the out of county queue, that's all.
Oh, okay. That's all right. All right, sir, you also have a violation of your probation from, what county was this? And from out of county, and there is no bond on that, so, and I'll appoint a public defender in the interim on that one. Come on up. Your name, sir? Right, sir, you're here, you're arrested on 2 charges, grand theft, 3rd degree of motor vehicle, and resisting officer without violence. I've reviewed the charging affidavit. There is sufficient probable cause, bond set in the amount of $1,000 for the grand theft and $100 on the resisting. You do qualify for pretrial release, which would not require a monetary bond, but there are conditions that you would have to live up to. Would you rather have me set a bond, or would you like to be released with pretrial? Okay, I'll set the bonds in. If you do bond out, no guns, no weapons, no drugs, no alcohol, okay? Your name, sir?
Jaquez Maddox.
All right, Mr. Maddox, you're here because you were arrested for a number of charges from a probable cause warrant. And those charges are as follows. Fleeing and attempting to elude with lights and sirens activated, that's a bond of $3,500. You have a driving license suspended with a $500 bond, and a resisting officer without violence, a $250 bond. And I will appoint a public defender to represent you.
Does he have any ICE holds?
I think he's got an immigration hold, so.
I can't.
He has an immigration. You have
Yeah, Your Honor. Oh, I can't talk to him.
Okay. Yeah, yeah, tell him. Yeah, there's a federal immigration hold on him, so. Okay, yeah, check that one.
Are we sure that he has an immigration hold? He's adamant that it wouldn't apply to him, that he's born here, been to prison, on the birth certificate that states he's a naturally born citizen.
Born Leesburg, Florida. It's the wrong person or something.
Are you on federal probation?
Yes, sir.
So maybe it's just a federal hold for that? I don't know.
He's asking.
So it might not be an actual ICE hold, it might just be a federal hold because of the probation or parole in the federal system. All I can say. I mean, you can only, mention it.
U.S. Marshal.
Yeah, it's U.S. Marshal. Just make sure you speak to your attorney about that, and then they can try to track that down for you too. But it may not be immigration, it may just be the marshals before your federal probation. That would be my guess.
Yeah, because that's crazy.
Yeah. I don't know if that's better, because if it's a parole violation, you go back to prison. If it's immigration, you might end up back in the Bahamas or something. Free trip. Your name, ma'am? All right, Ms. McElhaney, you're here for several things. First of all, in 2022 CF 2606 AO, you were arrested based on a probable cause warrant for the charge of grand theft, 3rd degree. And the bond in that case is set at $5,000. The next case you have is another grand theft, and that's in case number 2022 CF 2694 AO, and again from a probable cause warrant signed by another judge. And the bond in that case was set at $2,000. And then finally you have a third grand theft case, and that is 2022 CF 2833 AO, and the bond that was set in that case is $1,000. Sure, yeah, 1,000, okay? And then I'll appoint a public defender to represent you on those. You also have some out-of-county holds. You have, according to this. See, I'm looking now. You don't have it? Okay. Oh, did we already deal with those?
That hasn't been addressed.
Okay.
Broward County and Palm Beach County.
Okay. We don't have them. They're not in the queue.
No.
All right, so there's potentially some Broward County holds, so when they come up with those, we'll deal with that too. Is that, you said Broward and where?
Palm Beach.
Palm Beach. Gold Coast. Your name, sir?
Neil Paul Morgan, Jr.
All right, Mr. Morrison, you're here in 2022 CF 6322 AO. First of all, in that case, you were arrested on charge of trafficking in a controlled substance. Bond is set on that case in the amount of $100,000. And you also are here in 2022 CT 3033 AO, and that's a driving under the influence, and I have reviewed that charging affidavit, and there is sufficient probable cause, and bond on that case is set in the amount of $500. Conditions on those bonds will be that you not possess any drugs, use or possess any drugs or alcohol, do not possess any weapons or firearms, do not operate a motor vehicle without a valid Florida driver's license. Okay, thank you. And I'll appoint a public defender in both cases.
Your Honor, just to confirm, on the CF 22 CF 6322, is the bond 50,000 or 100,000?
100, that was what they said on the correction.
Okay, thank you.
So I put it at the 100, what's on the correction. I think that's what, they think they had 50, it was supposed to be 100. Okay, sir, your name? Your name, sir?
Alexis Negron Rodriguez.
All right, sir. You are here because you were arrested for failing to appear in 2021 CF 14858AO with possession of heroin, possession of cocaine, and possession of a controlled substance with intent. Whoops, wrong one. Negron Rodriguez. Okay, no. And the bond, for just one charge, did they not file any other one? The bond on the possession of failure to appear on the possession of heroin is $1,000. Check. Yeah, and that's all they filed on, so that's just a $1,000 bond, and I'll appoint a public defender to represent you. No, it was, no, her name was McElhenney or something. Did I? Do we have Natasha Miles? See, she said, huh? Did Natasha Miles bond out?
We don't have her on our list.
You got a booking number?
She could have, because it was $320. Two of the bonds are $323. And the other one's $1,500. Dunya, 22, here's her inmate number, 22012623.
You bonded.
She bonded? She bonded. You were right. Your name, sir?
Ian Petrie.
All right, Mr. Petrie. You are here today because you were arrested on several charges. There's a count of robbery, a count of petty theft, a count of resisting without violence, and a count of battery. I've read the charging affidavit. I do find that there's sufficient factual basis. The robbery bond is $5,000. The petty theft is $100. The resisting is $100, and the battery is $100. And I'll appoint a public defender to represent you. And it does look like you have a hold out of Osceola County, an ID hold.
Your Honor, I would ask for a no contact and no
And
return.
on that, let's see, who was that? It was, if you do bond out, you're not to have any, first of all, you can't return to the Super 8 Motel at 5900 American Way, and you're not to have any contact with Teresa Duff.
Who's Teresa Duff?
D-U-F-F.
Who is Teresa Duff?
That's the alleged victim in the case.
Alleged victim. Who? And no, Your Honor, may I ask? I'm asking a question about my case. I'm in court now. I'm allowed to ask the
Okay,
judge.
go ahead, ask the question, because they're about to take you out. Let's go. What's the question?
Teresa Duff, I don't even know who that is. And then not only that, when I was picked up and brought in here, I was never read no charges. I was never read an affidavits. I was never read my Miranda rights. And not only on top of that,
Did they interview you or take a statement? All right.
There was none. So I need to know what's going on before I go.
Okay, well, I just told you what it is. The allegation is a robbery, petty theft, resisting without violence, and battery. That's what the allegation is, and you have an attorney, and they'll bring out the reports and show it all to you.
Well, I would like a speedy trial. Can I have that?
You can speak to your attorney about that.
No, I would like to say now. I would like.
Oh, you have an attorney now. You have an attorney.
Go that way.
Hard to believe that when the officers tried to arrest him, he was difficult. I don't see how that could be. Your name, sir?
Jonathan Rosado.
All right, Mr. Rosado, you're here because you're arrested on 3 charges. Possession of cocaine with intent, possession of cannabis with intent, and finally, possession of drug paraphernalia. I have read the charging affidavit. I do find there's sufficient probable cause. And we'll set the bonds as $15,000 on the first count, $150 and $150 on the second count, and $100 on the third count. And I will appoint a public defender to represent you. So you have an attorney. Sanchez? Okay. All right, your name, sir?
Frank Sassini.
Mr. Sassini, you're here on 2 cases in 2022 CF 6360AO You were arrested on a charge of possession of fentanyl. I have read the charging affidavit, and I do find that there's sufficient probable cause. The bond on that is $1,000, and I'll appoint a public defender to represent you. And then the second charge was driving while the time your driver's license was suspended, and as an habitual traffic offender. And I did find sufficient factual basis there, and I'll reduce that bond to $500, and I'll appoint a public defender to represent you on that as well.
Your Honor, he otherwise does qualify for pretrial release.
Oh, he does, I'm sorry. Yeah, did you want to, so you can either do the bonds, or I can, you can be released with pretrial release conditions. So in other words, there wouldn't be a monetary bond, but you do have to call in, and there's some things that you have to do to qualify and to stay on pretrial release. Do you want to just keep the monetary bonds, or would you like to do the pretrial release?
I think he'd prefer the pretrial release, Your
All
Honor.
right, we'll release you with pretrial release conditions. And you're not to operate a motor vehicle without a valid Florida driver's license. You're not to possess or consume any drugs or alcohol, and do not possess any firearms or weapons. All right. All right, your name, sir?
Nathaniel Sanchez.
All right, Mr. Sanchez, you are here today because you were arrested for, on a probable cause warrant for 2 charges. Sexual battery on a child between 12 and 18, and count 1 and count 2.
Your Honor, both of those offenses are life felonies. So state would ask defendant be held no bond.
I would just have you set reasonable bond conditions, Your Honor, if inclined.
Were you still living with your family when you were arrested?
No, Your Honor. I haven't lived with my family for 5 years.
So you were not living at the Pecky Cypress Way?
No, Your Honor. I live in Seminole County now. I moved out as soon as I got back from the military. They actually kicked me out because of who I decided to marry.
Because of what?
Who I decided to marry upon coming back.
He doesn't have any prior criminal history? All right, so as count 1, I'll set a bond amount of $25,000, count 2, $25,000. No contact with any minors, no contact with, first of all, no return to the Pecky Cypress address. Let me get that. And that is 9759 Pecky Cypress Way. No contact with Alicia Sisson,Cisson, or Frankie Sisson, Cисson. or the alleged victims, their children, or any other witnesses. You're not to have any contact with any minors. So you can't live anywhere where there are any minor children or have any contact with any minor children at all. No guns, no weapons, no drugs, no alcohol.
Just a moment to confer, Your Honor.
What's that?
Just a moment to confer. Thank you.
$31 felonies, so more than half of this afternoon. And that's in just that one stack.
Let's give us a call.
Yeah, Martha was saying something about Thursday and Friday. All right, your name, sir?
Romel Smith.
All right, Mr. Smith. You are here in 2022 CF 6350AO. In that case, you were arrested, and there's a number of charges. I have reviewed the charging affidavit, and I do find sufficient probable cause. As to carrying concealed firearm, $2,500 bond, tampering with physical evidence, $1,000 bond, unlawful discharge of firearm, $500 bond, and disorderly conduct, $250 bond, and I will appoint a public defender to represent you on those charges.
Your Honor.
Yep.
Can I be heard as to count two?
Yes.
As to probable cause on that, I would consider an ROR on count two. At the beginning, I think he made, the officer in the affidavit wrote he allegedly made a spontaneous utterance that talked about the other gun. And then at the end of the affidavit, he said that he was allegedly trying to conceal that information. I believe the utterance may have been enough to allow police to get to the weapon, so I don't know if there was any tampering to speak of, at least in the facts of the affidavit.
There was no tampering.
Hold on. State, you want to be heard?
He also does qualify for pretrial release.
Okay.
No, Your Honor.
All right, does he want to go into pretrial release? That will make it not. I thought this was the one where some of the cartridges got.
I think you'd prefer pretrial release if you're inclined, Your Honor.
Yeah, I would, if he qualifies, I'd give that to him. Okay. All right, so you want pretrial release conditions? All right. Also, you're not to possess any weapons or any firearms. You're not to use or possess any drugs or alcohol. And you're not to return to the 1598 Americana Boulevard address. No contact with, there's somebody. The witness that they have listed is the maintenance man. His name is Jose Rodriguez. No relation, no contact with Jose Rodriguez. I think he's a witness. Okay, and I appoint a public defender to represent you. Your name? Yeah. Your name?
Bryson Washek.
Mr. Washek, you're here because you're arrested on a probable cause warrant for the charges of dealing in stolen property and receiving money from a pawnbroker.
Your Honor, this client also qualifies for pretrial release.
I do find sufficient probable cause. I can set a bond in these cases, or you can be released on pretrial release. Which one would you like? Would you like to go do
Pretrial release, please.
All right. I will release you with pretrial release conditions. Additional conditions: you're not to use or possess any drugs or alcohol. You are not to possess any weapons or guns. And I'll appoint a public defender to represent you. Okay. Your name, sir?
Alan Whitehead.
Mr. Whitehead, you are here today because you were arrested on a probable cause warrant signed by a different judge. The bonds on that are as follows. Defrauding a financial institution, the bond is $15,000. And then there are an additional,
Your Honor,
yes,
he also qualifies for pretrial release if inclined.
all right. Also an additional, let's see, 7 fraudulent use of personal identification information. Do find probable cause for those. There's a grand theft third degree and a scheme to defraud. And I do find probable cause on all of those. The bonds that would be said to be 15,000 and all other counts 1,000. However, you do qualify for pretrial release. Is that what you would like to do? You want the pretrial release? All right. There will be those conditions that come along with that. I will release you with pretrial release conditions. Also, you're not to use or possess any drugs or alcohol. You're not to possess any firearms or any weapons. And you're not to return to Westgate Resorts, any Westgate Resort property, or contact any witnesses.
Yes, sir.
All right, and the public defender is appointed. All right.
Thank you, Your Honor.
Mhm. Perfect. Hello, are you there?
The interpreter is on the line?
Oh, there we go. Have you been sworn today?
No.
Okay.
Can you raise your right hand, please? Do you solemnly swear to translate from Creole to English, from English to Creole to the best of your ability?
I do.
Thank you. All right, and defendant is in the courtroom. Could you please state your name?
Est-ce que qu'a dit non?
Attendez, ça dit.
I can't hear what you said.
Attendez, question là.
I can't hear the question.
All right, is your name Jean Octavius?
Est-ce que non c'est Jean Octavius?
Oui.
Yes.
All right, Mr. Octavius, you're here today because you were arrested on several charges.
Monsieur Octavius ou la jodi parce que tu es arrêté avec plusieurs charges.
It is 6 counts of sexual battery with a child between 12 and 18 by a person with familial or custodial authority.
This is it. Could you please repeat for the interpreter?
Sure. It is 6 counts of sexual battery on a child between 12 and 18.
So, yo chargé ou avec 6 comptes de hold on 1 second. OK, yo chargé ou avec 6 comptes de batterie bat sexuelle un petit moun qui entre l'âge 12 à 18 ans.
And there is no bond on those charges.
Ou pas gen aucun congestion pour nan charge sa yo. Ça veut dire que ou pas ka payer aucun cob pour sortir.
And I will appoint you an attorney. The public defender's office will represent you.
Ma ba un avocat public défense bureau yo y a représento.
All right, thank you, sir.
Merci, monsieur.
Any conditions, Your Honor?
Yeah, well, yes, no contact with the alleged victims, no contact with any witnesses, and no guns, no drugs, no weapons, no alcohol,
No contact with any minors?
and no minors at all.
Ou pas supposé entrer en contact avec victime nan, ou pas supposé gen aucun contact avec victime nan, aucun contact avec témoin, aucun contact avec mineur, ou pas supposé utiliser drogue, alcool, ou pas supposé gen zam à feu.
All right, thank you. Thank you, ma'am.
Merci. You're welcome, Judge. Thank you for using our service. Bye-bye.
Bye-bye. And then we have Benjamin Klongerbo.
They say he bonded, Your Honor. Looking number.
Just a sec, I will. It's not on here, is it on here? Oh, there we go. Yeah, 22012634.
Yes, he bonded.
Bonded.
It looks like we're on the record. Ms. Merced, good morning again.
Good morning, Your Honor.
And who is my public defender? Miss?
Courtney Daly, but I'll only be covering Orange County.
Okay.
She will be covering Osceola.
All right, I think,
Alicia Smith on
go ahead
behalf
and give
of
me
the
your
public
name again.
Courtney Daly.
Miss Daly?
Yes.
Okay. And Ms. Merced, you will be covering both Orange and Osceola County, correct?
Yes, Your Honor.
And who is my public defender covering Osceola County?
Alicia Smith on behalf of the Public Defender's Office, Judge.
And what's your last name again? Spell it for me.
Smith.
Smith, okay.
Smith.
Got it. Thank you, Ms. Smith. I appreciate it. All right. So the court
And
is,
this is Jorge Bonilla, State Certified Court Interpreter.
oh, go ahead. Thank you, Mr. Court Interpreter. We appreciate you too. Look, Jacavius Denard Smith.
Yes, ma'am. Your Honor, David Bigney on behalf of Mr. Smith.
All right, Mr. Smith, the court has reviewed the probable cause affidavit in your file, and will read as follows: possession of cannabis with intent to sell or deliver with a weapon, 3 counts. Possession of cannabis less than 20 grams with a weapon, 3 counts. Possession of cannabis less than 20 grams, 1 count. Possession of a firearm by a convicted delinquent, there were 3 counts. And possession of a firearm by a convicted felon, 3 counts. And possession of a firearm or ammunition by a convicted felon, 3 counts. And grand theft, 3rd degree of a firearm, 1 count. With regard to bond, I'll hear
Thank you, Your Honor.
defense counsel would like to say.
Thank you. With regard to probable cause, I've got several probable cause arguments on some of these counts. With reference to the first 3 counts, possession of cannabis with intent to sell, there is 1 bag, slightly over the misdemeanor amount, packaged weight of 30-point-something grams. It's not bagged separately, 1 bag, no scales, no drug paraphernalia, no ledgers, and nothing to suggest that there would be any intent to sell. So we would argue that there is no intent to sell, nothing to support any probable cause on the possessions with intent to sell. As far as counts 4, 5, and 6, and I'll include count 7, the possession of cannabis over 20 grams. The thought process with that, again, there's 1 bag, so you've got 1 count, not 4 counts. So they're just capitalizing over and over again on 1 baggie. 1 baggie, packaged weight, 30 grams. So we would agree that there's probable cause for 1 of those 4 counts, but just 1 of those 4 counts, and none for the other 3. Counts 8, 9, and 10, there were 3 firearms located in the front hood area according to the probable cause affidavit. We're not contesting that there's probable cause on counts 8, 9, and 10. However, on counts 11, 12, 13, 14, 15, and 16, we're contesting probable cause on all of those, and that it is at bare minimum duplicative charges. It's they're either charging him as a juvenile or charging him as an adult, but they're charging him for the same weapons over and over again. And as charged, they're suggesting that there's a lot more firearms than they've listed, and we're stipulating to the counts on the firearms on counts 8, 9, and 10. So if he's a probable cause on those 3 counts, then there should not be any probable cause on 11 through 16. As far as count 17, They're suggesting that one of the firearms was stolen, but there's nothing within the four corners of the affidavit to suggest that Mr. Smith had any knowledge that this firearm was stolen. There's nothing to suggest that he had knowledge of any of the firearms to begin with. But certainly as it relates to this particular one, and whether or not it was stolen, there's nothing within the four corners of the affidavit suggesting when this firearm was stolen. Was it stolen minutes beforehand? It was recovered years beforehand? Nothing along that line. There's no statements, so there's no probable cause. So from a probable cause standpoint, we're conceding one of the counts between counts 4 through 7. We are stipulating to counts 8, 9, and 10, and that there's no probable cause for any of the other counts. As far as the bond amount on any of the accounts, any of the counts, we would ask that other than the primary offense, that all following counts be $100 or ROR.
Ms. Merced?
Your Honor, State would request a reset in order to obtain supplemental reports as to the counts that have been challenged for PC. I believe that's counts 1, 2, 3, 5 through 7. And I believe counsel indicated they would concede to 8, 9, 10.
And Your Honor, we'd object.
Well, I won't be granting a reset as to counts 1 through 3.
Your Honor, may I argue as to 1 through 3, Your Honor?
Well,
For those counts, the officer did indicate that he obtained dealer wallets from the defendant's person where the bills were bundled and separated into different denominations, which would be indicative of the intent to sell, given the amount of marijuana that was obtained, which was a total weight of 30.35 grams.
There's no indication of the amount of money.
the court's not going to grant a reset as to count 1, 2, and 3. The court finds probable cause as to count 1, and no probable cause as to count 2 and count 3. And as to count 1, the court will order a bond of $500. As to count 4, 5, and 6, the court finds probable cause as to count 4, but not count 5 nor count 6. I'm not going to grant a reset as to that either. The court will set bond at $500 as to count 4. As to count 7, the court finds probable cause and allows bond at $1,000 as previously requested. As to count 8, 9, and 10, Ms. Merced, what do you have to say as to count 8, 9, and 10?
Your Honor, I believe those are the counts that counsel has conceded.
Oh, I'm
and
sorry. You're absolutely right. I'm sorry. I misspoke. The court does find probable cause as to 8, 9, and 10. Bond remains at $5,000 for 8, $5,000 for 9, and $5,000 for 10.
Would the court consider lowering the bond on 2 of those 3?
What Ms. Merced? Well, let me get through. Let me get through 11 through 16, and I would like Ms. Merced to respond to your argument as to 11 through 16. But hold that thought, and Ms. Merced will be allowed to respond to that as well. Ms. Merced?
Your Honor, as to counts 11 through 16, again, State would request a reset to obtain a supplemental report to confirm the number of firearms that were in the vehicle.
So there were 3 firearms that were identified, and the counts 11 through 16 have to do with the status of prior status of the defendant as a convicted felon and or a convicted delinquent. So since the court has found probable cause of the convicted delinquent, would it be duplicative to also find probable cause as a convicted felon?
I don't believe so, Your Honor, because looking at this, it indicates that he has prior He has previously been adjudicated delinquent and also had felony charges, and I would have to pull up his history to confirm whether it's,
I can tell the court the history, and I'm sure once it's pulled up, it'll be verified. The only adult charge out there is a withhold time served, I believe, $1,000 fine to a possession of marijuana over 20, and that was about 28 grams.
And how old is the defendant now?
He's 19, and that was a withhold of adjudication, so he is not a convicted felon as an adult.
The court will find probable cause as to counts 11, 12, 13, 14, 15, and 16, and will order $150 as the bond.
On each count?
Yes, sir. The court finds probable cause as to grand theft third degree of a firearm, and the bond will stay at $1,000. Now I'll hear any argument on reduction of the bonds that the court has already announced, as well as response. Oh, yes, the court has neglected to indicate that I will be RORing the defendant as to count 2, count 3, count 5, and count 6.
As far as reducing the bond, Your Honor, the amount, typically the biggest charge, or it's not uncommon where the biggest charge stays at the standard and the subsequent charges are then reduced to 100 or ROR or something along that line, a much smaller bond amount. This is not something, the extra amount isn't something that is going to assure that he shows up any more than what the bond is. There's no indication that he's ever missed a court appearance, a required court appearance, and to my knowledge, he has not. And certainly with my experience with Mr. Smith, he has not missed any. So the necessity to have a duplicative charge, have the same bond as the first one, I think is unnecessary. So we would ask that on the counts 8 and 9. I'm sorry, was it 8 and 9 or 9 and 10? 9 and 10, I think it is. We would ask that those be reduced from $5,000 to $100 or $150 as you had on the other firearm counts.
Ms. Merced.
Your Honor, state would object as state would argue that the bond remains, as Your Honor's already stated, $5,000 as to each count.
The court will grant the motion as to only count 9 and 10, and will reduce the bond to $150. The court will also reduce the bond in count 17 to $150. The bond remains at $5,000 in count 8, $1,000 in count 7, $500 in count 4, and $500 in count 1. Any further orders that the state would like to enter with regard to bond in this case?
Your Honor, state.
You want me to order no possession of any firearms or weapons as a
Yes, Your
condition of
Honor.
bond? The court will enter an order of no possession of firearms or weapons as a condition of bond. Anything further, Ms. Merced?
No, Your Honor.
Anything further, Mr. Bigney?
No, Your Honor.
All right. Thank you.
Thank you.
Do you say Osceola? And are we on? Yeah, I think we are, because the attorney spoke. Well, the attorney heard me before, so. All right, good morning, everyone. The court is going to begin with the initial appearance proceedings, and as I call your name, please come forward to the podium, and please understand that we're going to be going pretty fast here, pretty quickly. If I'm going too fast for you, you can tell me if you don't understand something. I will be appointing the public defender to represent each case. Patrick Alexander.
Can we reset him, Judge?
Yes, is there a reason why? We
He
can
just wanted
reset
to be
him.
reset.
All right, do you want to reset for tomorrow or Monday?
That's tomorrow's fine, Judge.
Okay, reset for tomorrow. She didn't really give a reason, but I grant it. Stephen William Argo. All right, so you were picked up on a violation of probation or community control. Bond remains set at 0 bond. Thank you, sir.
Thank you.
Sabrina Talisa Bacchus. Ms. Bacchus, the court does find probable cause for the offense of battery, domestic violence, and will order bond in your case at $500. Order no contact with the victim, no return to the location where this incident occurred, with the exception of one.
Judge, she does.
I'm sorry, go ahead, counsel.
I'm sorry, Judge. I was gonna ask for a ROR, Judge. She does have no prior. She qualifies for PTR by nature of the charge. However, she resides in Philadelphia. She was here on vacation as to this charge.
No court, the court declines to order ROR and will instead order the $500 as the court has previously indicated. No contact, no return, with the exception of one-time visit with law enforcement to pick up any personal belongings if necessary. Thank you, ma'am. Edwin Maverick Brayton. And Mr. Brayton, the court does find probable cause for offenses as follows: carrying a concealed firearm and possession of a weapon or ammunition. The court will order bond as count one, $1,000, and as count two, $4,000. The court further informs you that you were picked up on a violation of probation, and bond on that case will stay set at no bond. Thank you, sir.
Thank you.
Raymond Oliver Brooks. All right, Mr. Brooks, you were picked up for a violation of probation or community control. Bond remains set at no bond in your case. Thank you, sir. Thank you. James Cannon Ferrero.
We're gonna waive the reading of the charges, Judge.
All right. The court has found probable cause for the charges, and the court bond will remain set at no bond. Both count one and
Is the
count
court
two.
finding?
Yes, ma'am.
Is the court finding proof evident presumption great as to the no bond status?
Yes, ma'am.
Okay.
Akeem Dion Holliman. Akeem Dion Holliman. The court, good morning. Yes, sir, you were picked up for a violation of probation or community control, and bond will stay set at no bond in your case. Thank you, sir. Casey Robert Jonas. The court does not find probable cause for the offense of battery on a law enforcement officer, firefighter, or security person. And does the state wish to try to provide some probable cause to the court?
Your Honor, Your Honor, again, state would just request a reset to try to obtain a supplemental report to see if there's any additional information to qualify the victim as a law enforcement officer as identified in the statute.
Would you like for me to reset it for tomorrow or for Monday?
For Monday, please, Your Honor, because I don't know if we'll be able to get it by tomorrow.
All right.
I'd ask for only 24 hours, Judge, so I'd ask for tomorrow.
Okay. Doesn't the statute allow additional time, Ms. Merced?
Yes, Your Honor, we have up to 48 hours.
All right, I'm going to go ahead and reset it for Monday, which is the 3rd.
Judge, Officer Dunkirk with PTR.
I can't hear you.
Officer Dunkirk with PTR.
Oh, yes, ma'am.
Mr. Jonas
I
is
still
currently
can't.
out on county. Mr. Jonas is currently out on county probation as of April 15th of this year. In case number 18MM4201.
All right, well, given that the court is not able to find probable cause at this time, I will take no action on any of the cases if that's what you're asking me to consider.
Yes, Judge.
Not at this time. You can bring that up again on tomorrow, on Monday, when the case is called.
Okay, thank you, Judge.
Thank you, too.
I appreciate it. Thank you.
Anthony Aurelio Leal. All right, sir, you were picked up for violation of probation or community control, and bond will remain set at no bond. Thank you, sir. Charmaine Ezeal Loman. Ma'am, the court does find probable cause for the offense of battery domestic violence. I will order a bond of $500, order no contact with the victim, no return to the location where this incident occurred, with the exception of a one-time visit with law enforcement if necessary for personal belongings. Thank you, ma'am.
Judge, she does qualify for pretrial release, and pretrial release was able to make contact with the victim, who's asking that she be allowed to return home, as well as asking for a no hostile contact provision. So we'd ask for PTR with those conditions.
And the court will grant that if there's no objection from the state.
State would object, Your Honor, would ask for no contact.
Okay. Well, she has been assessed, and the paperwork indicates that she qualifies for PTR. And it says the victim wants no hostile contact and to return home. So I'm assuming that they've done, some investigation on it. So I'm going to go ahead and grant that request. I'll allow PTR, no hostile contact, and you may return home to the location where this incident occurred. All right, thank you.
Thank you.
Henry Lugo. Henry Lugo, you were picked up on an out-of-county warrant for Brevard County. Bond is set at $2,000 and will remain set at $2,000. Thank you, sir. Jimmy Lamar Lynch.
And just to be clear, Judge,
Yes, ma'am.
because it's an out-of-county warrant, we won't be appointed, correct?
Well, I usually appoint the public defender on every single case. Do you not want to be appointed on that?
We can be appointed, Judge, that's fine.
All right. Jimmy Lamar Lynch. Jimmy
Can we
Lynch,
reset him, Judge?
to tomorrow?
Yes, Judge.
Or yes, ma'am. I guess you don't. Ruben Munet, or Munette, Ruben. The court finds probable cause for the offensive battery and will set bond at $500, order no return and no contact with the victim. You may return one time in the presence of law enforcement to retrieve any personal belongings if necessary. Thank you.
Judge, he qualifies for pretrial release. Can we have pretrial release with the no contact, no return, but the one-time assist?
Okay, let me see. Any objection to PTR with those conditions?
No objection to PTR with no contact and the bond.
All right, the court will grant that request and order PTR, no contact, no return, with the exception of one time in the presence of law enforcement to get personal belongings. Thank you. Luis Ramirez Lamort.
Can we reset him, Judge? He's in medical.
Yes, we set for medical tomorrow. Ruben Guillermo Rodriguez. Sir, you were picked up for violation of probation on 2 active warrants. Bond will remain set at 0, no bond on both cases. Thank you, sir. Anude Santiago. Anude Santiago.
bonded.
Previously bonded. Veronica Wynette Saunders.
Bonded as well.
Okay, previously bonded. Cynthia Louise Sipes.
She's approaching, Judge.
Okay. Ma'am, the court does find probable cause for the offense of trespass, and bond will stay set at $500 in your case.
The charge does qualify for pretrial release, Judge. We'd ask for PTR in this case.
Any objections?
No objection, Your Honor.
All right, the court will order pretrial release in this case.
State would just request no return, Your Honor.
Yes, and the court will order no return to the location where this incident occurred as a condition of PTR. Thank you. Justin Keith Smith. Sir, you were picked up for failure to appear. Court bond will remain set at no bond in your case. Thank you. Tatiana Solar. Ms. Solar, the court finds probable cause for offenses of possession of alcohol by an underage person, and bond is set at $250. The court finds probable cause for driving under the influence, and bond is set at $500. As a condition of your bond, ma'am, you are ordered to not drive a motor vehicle. The court has considered PTR in your case and decided against PTR and will not be ordering PTR in your case. Thank you.
Judge, she does have no priors. I'm not sure if the court was aware of that when the court decided they weren't willing to do pretrial release, but I did want to at least put it on the record.
Well, I was counting these two offenses. What says the state?
Your Honor, state would just leave it to the discretion of the court.
No PTR.
So she was given bond to both cases though, correct?
She's given bond on both her cases.
All right, thank you, Judge.
Julio Tejeda. The court finds probable cause for battery in this case. Will order a bond of $500, no contact, no return.
He does qualify for PTR. Can we have pretrial release with no contact, no return, but a one-time assist?
Any objection, Ms. Merced?
No objection, Your Honor.
All right, with those conditions, the court will allow PTR, no contact. The court will allow a one, I'm sorry, one
Judge,
time.
my apologies.
Okay, can you get
We
to the
spoke to
microphone? Microphone.
We spoke to the victim, Judge. We spoke to the victim, Judge, and she requests a no hostile contact.
All right, Ms. Merced.
State would object, Your Honor, and request no contact.
All right, well, given that the victim has requested no hostile contact, I'm going to adhere to the victim's request, allow no hostile contact, bond at PTR, no hostile contact. Thank you.
Is the no return provision still in place, Judge?
No, ma'am. No, ma'am.
Okay, so just PTR, no hostile contact, only two conditions.
Yes, ma'am. Lisa,
Thank you, Judge.
thank you. Lisa Gabriella Vanman. Ma'am, you were picked up on multiple warrants. The bond remains set as follows: $3,500, $1,000, $2,500, and $1,000. Your bond total is $8,000 on your various warrants. Thank you, ma'am. Jacole Leanne Whitfield.
Good afternoon.
Good afternoon. The court finds probable cause for petty theft. Bond remains set at $500.
She does qualify for pretrial release, Judge. Can we have pretrial release in this case?
I don't consider pretrial release in this case unless the state has no objection.
Your Honor, again, state would leave it to Your Honor's discretion.
All right, if you leave it to my discretion, then the court's not gonna allow it. $500 bond. Edgar Jr. Willis. Court does find probable cause for battery by strangulation and domestic violence. As to each count, let me see what, the court will allow a bond of $500. Order no contact with the victim, no return to the location where this incident occurred.
He does qualify for pretrial release, Judge. Can we have pretrial release with a no contact, no return?
The court is not inclined to do so unless the state agrees.
No, Your Honor.
No, denied. Each count.
So it's 500 per count?
Yes, ma'am. No contact, no return, with the exception of one-time return to retrieve personal belongings. The court also is entering an order of no weapons or firearms. Israeli Ferrer Albello. The court, ma'am, you were picked up on a violation of probation or community control. In your case, bond will remain set at no bond. Thank you, ma'am. Kennedy Step. Kennedy Step.
Okay. One moment, Judge. They have to bring them from the back. We're going to waive the reading of the charges, and I believe Mr. Estep is hiring a private attorney.
Okay, well, can you hear me? Because I need to inform the state that it was very difficult, and I'm not sure that I found probable cause in this case because there were so many pages of the PC affidavit that were blacked out, and I couldn't read them. So I don't know why they were blacked out. I mean, I'm the judge, I should be able to read them. But the whole entire pages were blacked out. So it's a stretch to find probable cause in this case. I need more information. Perhaps it was just an oversight that I received all these blacked out pages. What says the state?
Your Honor, state would request a reset so that we can obtain a clear affidavit.
All right, then, Mr. Estep, I'm gonna reschedule tomorrow, Ms. Merced, or the
If we
next
could
day?
request Monday, Your Honor, I don't know that we would get it in time for tomorrow.
All right, the court will reschedule the case until Monday, for the state to.
And can we make sure that,
Yes, ma'am.
I'm sorry, Judge, I didn't mean to cut you off. I was just going to ask, can we make sure that the public defender gets a copy as well for initial appearance of the, I guess, an unredacted copy?
Miss?
Yes, Your Honor.
I don't know how we do that. All interested parties should receive a copy. Mainly the judge needs a copy, because that the judge cannot find probable cause without an unredacted copy. Thank you. Well, the public defender until he gets his own attorney. The public defender is appointed. Edgar Willis. Edgar Willis.
No, we did that one, Judge.
Oh, so yeah, it's a redo. And I think we did Alvaro Lugo. I think I got some copies.
No, I'm asking to reset him, though, Judge.
Okay. Alvaro Lugo.
I'm asking to reset that one.
Oh, reset.
For tomorrow.
Yes, ma'am. Tomorrow. Okay. Scott Botti. All right, Mr. Botti, you were picked up for violation of probation or community control. Bond remains set at no bond in your case. Thank you, sir.
The last two we're asking to reset, Judge. Medina Diaz and Rivera.
The court will reset both Henry Medina Diaz and Alberto Rivera. Anything further, Ms. Smith?
No, Judge. What time are we going to start tomorrow? Do you know? Or should we have them in the room, I guess I should say?
Well, we start at 11 o'clock.
Okay.
All right, thank you.
All right, thank you, Judge. See you tomorrow.
You too, bye-bye. All right. I haven't read these things, so I just want one at a time, one defendant at a time, until we get to the part where I've read it. This is the stuff that I haven't read. I read the ones from the other young lady. I didn't read your stack. No, that sticky means, yeah, so I just need to know what I've read versus what I haven't read. No, and there was a stack from you that was not read. Where is that at? No. So my understanding is that your stack goes first.
No, the Spanish and move-ups.
Okay, but your stack goes before the stack that I read. I read everything she gave me,
Right, so did you read any lines at all? This is my.
only the move up from you.
Okay, so let me, the little sheet in here. Right here.
Okay, so those are the unread ones, and these are the red ones, because I read way more than that.
These are Spanish and move-ups.
Way more than that. She gave me more than.
Yeah, because you read the bottom half.
Yeah, the bottom half, right. So we're gonna do these? Okay. And these are the ones that I said I'll hold just to see. Okay. Jorge Rafael Lopez Fuentes. All right, is the interpreter online?
The interpreters online, we're trying to run testing with the equipment, making sure that all the parties can hear.
Okay. Mr. Lopez Fuentes, can you hear?
Yes.
All right. You cannot hear? All right, do you need to hear? Can you hear you can hear him? Okay, so are you running a test on that part now?
Yes, Your Honor.
All right, let's just get started, and if anything confidential needs to happen, we'll just figure that out. Otherwise, we'll be here all day.
Normally it works.
Okay, well, we'll figure it out. I mean, we won't require anything confidential to be said out loud.
Okay.
Okay? Mr. Lopez Fuentes, sir, the court finds probable cause for possession of cocaine and trespass on property after warning. Bond is set at 1,000 on count 1 and 100 on count 2. Public defenders appointed. Juan Ramos Torres.
Your Honor, State would just request no return on the Lopez Fuentes.
Yes, I'll grant that. Court will order no return to the property where the trespass occurred at.
Your Honor, I don't think the interpreter's coming through the headset. He's looking like he didn't hear anything.
Okay.
Joven, se prohíbe el regreso al lugar de los hechos.
So, Mr. Interpreter, can you ask him if he heard you? So maybe the defendant headset isn't working either, Mr. Interpreter.
If it pleases the court, we can just do these over the loudspeaker the same way we did Judy and Osceola.
Yes, well, why don't we, until we figure out what the glitch is, and we'll just make sure. Counsel, you just have to tell me if you need, I guess we won't have the ability for you to be able to say anything.
That's fine.
Okay. All right, Juan Ramos Torres. Juan Torres. All right. Sir, you were picked up for failure to appear, 3 counts. Bond remains at no bond. On those failure to appear offenses, the court takes no action on the case that you were previously out on bond. 18 CF 11707, court takes no action on that case.
Estás detenido bajo orden de arresto por 3 incomparecencias. Estás detenido sin fianza en esas 3 incomparecencias. La corte, perdón, no va a tomar acción en el caso por el cual estaba libre bajo fianza, que es el caso 18 CF 11707.
Yvette Rodriguez. ma'am, the court finds probable cause for count 1 aggravated assault with the weapon. Bond remains at $2,500 and battery bond is set at $100. The court orders no contact with the victim, no return to the location where this incident occurred, with the exception of you are allowed a one-time visit to pick up personal belongings. Further, no possession of no weapons or firearms as a condition of bond. And the court does appoint the public defender on your case. Thank you.
Se determina causa probable en tu caso. En el primer cargo de amenaza agravada con arma se fijan $2,500 de fianza. En el segundo cargo de agresión física se fijan $100 de fianza. Se prohíbe el contacto con la víctima, se prohíbe el regreso al lugar de los hechos, excepto una vez con escolta policial para recoger efectos personales. Se prohíbe la posesión de armas blancas, armas de fuego y se designa defensor público. Gracias.
Carl Dallas. All right. Are we done with the Spanish? Thank you, Mr. Interpreter.
Thank you, Your Honor, and have a great weekend.
You do the same. Sir, the court finds probable cause for offense of trespass after warning and a conveyance, and bond is set at $500 in that case. State you want me to order no return?
Yes, please, Your Honor.
Court orders no return to the location where this incident occurred and appoints the public defender to represent you in this matter. Thank you, sir.
So what I do?
Well, the charge is trespass. And you can ask your attorney for more details on what the allegations are regarding your charge.
When do I get out?
The bond is $500, and you can post that bond at your ability to post it.
Can my family come post my bond?
Absolutely.
Where at?
I can't tell you that because I don't know where.
At a
it
bail
is.
bonds?
I don't know where.
At a bail bonds?
I don't know where. I don't know the location. All right. When pay YN?
He refused, Your Honor.
Okay. Refused. So I'll reschedule him for tomorrow. How about that? Oh man, I don't want to have to read all this again in the morning. This is a lot. Let me see here. But you all get different paperwork every single day, don't you? So, I'm gonna keep this and put it right here. I'm gonna remind myself I already read it. James Jerry Williams.
Yes, ma'am.
Oh, I mean, you can take the top paperwork and all, but I want to keep it PC because I don't want to read this again in the morning if he shows up. Some kind of way, I gotta remember that I already read that. That took me a long time. Okay. Oh, yeah, maybe you can put a note on the judge already read. Just put it You gonna remember it? Okay. Sir, I'm sorry. As to your case, says, cases, the court does find probable cause for as follows: aggravated assault on a law enforcement official with a motor vehicle. Bond is set at $5,000. Battery on a law enforcement officer. The court is setting bond in that case at $2,500. Criminal mischief bond is set at $150, which is lower than what was recommended. Resisting an officer, the court reduces the bond to $150. Grand theft, third degree motor vehicle, and the court reduces that bond as well to $150. Further, sir, the court is revoking your ROR on your.
May I be heard on that?
You would like to be heard?
Yes, Your Honor.
All right, yes, ma'am.
On his out on bond case, 2019 MM3241, no information has been filed in that case, and it's been over 33 days. The arrest date is April 18, 2019.
Can
We
you,
ask you
can
to
you
take
provide the case number again? Because I don't know that I have. Is it, go ahead.
It's 19 MM 003241 AO.
No information's been filed?
No, that is correct.
All right.
April 18th is the arrest date. For the
And can that be confirmed by anyone other than the public defender? No. All right, the court will, the ROR status will remain in effect.
Thank you, Your Honor.
Thank you, ma'am.
Thomas Shands. Mr. Shan, sir, you were picked up on an out-of-county warrant for failure to appear. Bond is set at no bond and will remain as such. Thank you, sir. Oh, well, let me just see what I have. Well, it's, yes, the teletype indicates 3,500, so that's what I'm gonna go by, and the bond will stay at 3,500, sir. Ray Anthony Lamore. All right, sir, the court finds probable cause for the offense of trespass on property after a warning, and bond is set at $500. Court is appointing the public defender. I'm sorry if I didn't mention it in the last case, the court did appoint the public defender. All right, the court is appointing the public defender on all IA cases unless otherwise stated. Stephen Randall Wiggins.
Your Honor, State would request no return on the Lamar.
As to Mr. Lamar, the court orders no return to the location where this incident occurs. Condition of bond. Stephen Randall Wiggins.
Yes, ma'am.
The court finds probable cause for possession of an alcoholic beverage in an open container. Bond is set at $250.
Your Honor, we'd ask for him to be ROR. This is a nonviolent misdemeanor. It's the state's non-monetary bond policy to advocate for ROR in cases such as this.
I'm inclined to leave it at the bond of $250 unless the state agrees to an ROR.
State would agree, Your Honor.
You would?
Yes, Your
All
Honor.
right, the court will grant the request for ROR and will order ROR in this case. Renoir Amari Powell. The court finds probable cause for the charge of battery, dating violence, and orders bond of $500. Orders no contact with the victim, no return to the location where this happened, with the exception of a one-time visit to pick up any personal belongings. The court further finds probable cause for possession of cannabis, and bond is set at $250. Possession of methamphetamine, bond remains set at $1,000. And possession of fentanyl, the court will set the bond as the possession of fentanyl at $250. The court orders. That's it. Sorry.
For the, I didn't catch the bond amount for the battery.
500.
Thank you, Your Honor. Your Honor, we'll waive the reading of the charges on this one.
Timmy Morgan Warren.
Yes, we'll waive the reading of the charges.
All right. The court finds probable cause for the offenses as noted, and will appoint the public defender for representation in this case on all counts. Oh, bonds remain at no bond. Sorry. I'm sorry. Anything further?
No, Your Honor.
Okay. Cameo Bannister. Sir, the court finds probable cause for use of an anti-shoplifting device and petty theft. Bond is set at $1,000 on count 1 and $100 on count 2. The court is revoking the ROR status on the case number 2019 CF 7877. Oh, I'm sorry, 2019 MM 4115. The court is revoking the ROR status and ordering a bond of $500.
Your Honor, State would request no return.
The court grants that request and orders no return to the location where this incident occurred as a condition of bond. Thank you.
All right, so what's gonna happen? Okay. So, if I don't find out,
Unfortunately, no, sir, I'm not in a position to resolve the
If
case
if I
today.
don't bond out by my next court date, can you guys have a plea for me?
I am certain the public defender can make arrangements to have that happen.
All right. You
If
have a
you-
nice day, Your Honor.
You do the same. Thank you, sir. Roger Dale Christopher, or Christopher Roger Dale.
Yes, ma'am.
Sir, the court finds probable cause for possession of heroin, and bond is set at $1,000. The court finds probable cause for possession of methamphetamine, and bond is reduced to $150. And the court appoints the public defender in the case. Thank you. Any questions, sir? Sir, thank you.
Thank you, ma'am.
Corey Albert Osborne, the court, sir, you were picked up on a failure to appear, and bond is set at no bond on both counts of your failure to appear. Thank you, sir. Robert Gillum. All right, sir, the court finds probable cause for the offense of trespass after warning, and bond is set at $500. Thank you, sir.
Public defender's appointed.
Yes, ma'am.
State will request no return, Your Honor.
The court, yes, the court will order no return to the location of the incident as a condition of bond. Robert Forrest Lau. Thank you, sir. Look, you were picked up on an out-of-county warrant. Bond will remain set at $1,000 in your case.
I'm sorry, Your Honor. Are we on Mr. Gillum?
Law, Mr. Law, L-A-U-X.
Okay, thank you.
Mr., thank you, sir. Mr. Brian Daniel Larmore. Brian Larmore. The court finds probable cause for petty theft. Bond is set at $250 in your case, sir.
State would also
I
request
didn't
no
hear you.
return.
And the court will order a condition that you not return to the location where this incident occurred as a condition of your bond. Thank you, sir. Antonio DeKeith, or Antonio Morris DeKeith. All right, sir, the court finds probable cause for resisting an officer without violence. Bond is set at $500. Attempting to injure a police dog, bond is set at $500. Grand theft of a motor vehicle, bond is set at $150. Leaving the scene of a crash with injuries, bond remains set at $2,500. Possession of cannabis, bond is set at $150. And possession of cocaine, bond is set at $150.
Your Honor, what was the bond on the grand theft? Motor vehicle?
$150.
Okay. It's a little hard to hear.
Quentin Jackson. Is that who you are? All right, you were picked up for a violation of community control, and bond will remain set at no bond in your case. Court does appoint the public defender. Okay. This looks like you haven't read that. All right.
There might be. There usually are. But we're not to the best about yet. Yeah.
All right. Manuel Fernandez, you were picked up for violation of probation. The court will order the bond remain set at no bond in your case. Thomas Moore. Thank you, sir. Sir, you were picked up for violation of probation. Bond will remain set at $5,000 in your case. Thank you, sir. The court does appoint the public defender to represent you, sir. Oh, is that it?
You got some, but not for him.
Yeah, I know. There's no contact.
All right, Nicholas Gomez. All right, the court finds probable cause for false imprisonment and battery domestic violence. As to count 1, bond is set at $5,000. As to count 2, bond is set at $250. The court orders as a condition of bond that you have no contact with the victim and that you not return to the location where this incident occurred. Possess no firearms or weapons as a condition of bond, and that you are allowed a one-time visit in the presence of law enforcement if necessary to retrieve any personal belongings.
Your Honor, can I be heard on the issue of the do not return? He indicates to me that it's his house. We'd ask that you order and maintain separate residence, but the no contact be in place.
Well, the
Because
court is going to maintain the court's order at this time. Madam Prosecutor, the court is unable to find probable cause for violation of domestic injunction. Do you have, am I missing something?
Your Honor, we would request a reset in order to obtain additional information to support.
So, but the court is able to find probable cause for all of the other related offenses. Is Shaquille Irby, is that who you are?
Yes, ma'am.
So the court finds probable cause for burglary of a dwelling with an assault or a battery. Bond will remain set at no bond on that count. The court finds, probable cause for battery by strangulation, and bond is set at $500. And domestic violence, bond is set at $500. The court is unable to find probable cause at this time for violation of domestic injunction, but the state is asking for additional time. And how much time?
If it could be reset to Monday, Your Honor.
Your Honor, I would object to that because according to Florida Rules of Criminal Procedure 3.133A1, the state is only entitled to a 24-hour reset, and after that 24-hour reset, they can request an additional 24 hours if they're upon showing extraordinary circumstances, and we just haven't.
You know
had
what?
that.
I think she's actually right about. I think you're right about that,
Okay.
counsel. I think she's right about that. I mean, I don't think I need to relook at the rule. I'm so sorry because I gave her more time on 2 other cases. But I won't do that in the future. But I'm going to give you the 24 hours. Then you can ask tomorrow for additional time. Unfortunately, I already gave you some more time on the other 2 cases. But going forward, the court will only give 24 additional hours and then an additional amount of time, if necessary, at that time. So we'll bring him back tomorrow on the other 3 counts. the grand theft and the violation of domestic injunctions. All right? Okay. Alan McFadden.
Yes, ma'am.
All right. The court is unable to find probable cause on this, or was this a capias?
This is a warrant, Your Honor, yes.
Oh, okay, okay, then there are two of them. Let me see here. All right, so you were picked up on, a warrant for, battery domestic violence. Warrant was served in two different cases, actually. Bond will remain set at no bond.
Your Honor, he's entitled to a bond in these cases, then the IA judge is supposed to set them. It's just that since they're domestic violence cases.
Well, you know what, I don't usually mind setting a bond on, domestic violence cases, but I have no narratives.
It's not a punishable by life offense. It's no bond until you see the IA judge because.
I need more information. I have no narratives. Can I get more information on these two cases?
He's picked up for failures to appear on these cases, Your Honor. Your Honors, I can request the narratives on the underlying.
Well, wait a minute, if they're failure to appear.
These are failure to appear,
then
so
I'm-
he would not be entitled to bond based on that.
They're gonna stay at no bond.
I'm sorry.
If it's failure to appear, if it's a new law violation, I will be happy to set a bond for this gentleman. But, the paperwork's a little bit different looking than some of the other paperwork. If in fact it is if it's a failure to appear and that's what it looks like from all I have,
3 weeks, Your Honor.
the bond will remain set at no bond. Both cases.
Okay, I'm sorry, Your Honor.
If
I
you-
had it as a warrant arrest.
If you give me any more information that proves that it is not a failure to appear, then I will be happy to reevaluate.
Which case do you have on the failure to appear? Which charge?
Both of them.
Cases 19 CF 7855 and 19 CF 7857.
Mistake.
Your Honor, I've been in jail 3 weeks. What am I here for?
I beg your pardon,
I've been in jail 3 weeks.
Microphone.
What am I here for? I've been in jail 3 weeks. What am I here for?
Well, who are you? Are you Guadalape Puebla?
Alan Dwayne McFadden Jr.
Your Honor, the 2019 7855 it's an affidavit to issue it's a new offense. The information was filed on 5/30.
No, I'm not going to sit here and restate the same thing that I've already stated. Either I need a narrative so that I can determine probable cause and the appropriate bond or PTR or some release status, or it's a capias. The paperwork I have shows 2 KPI.
The issue, so a capias is it's a pickup order. It's not necessarily for a failure to appear. A capias was issued because the state filed charges and they issued a capias for a warrant for his arrest.
Then get me the narratives so that I can evaluate what bond should be set, and I'd be happy to do that.
I don't have the narratives, only the state would have that narrative.
Well, I'll be happy to do that with every single case, just like I'm doing with the cases that I'm going through right now. And until I get that information, bond stays set at no bond.
Are you resetting this for tomorrow?
I haven't been asked to reset it for tomorrow. Is that what you were?
If you don't have a narrative, then you don't have probable cause.
But I have a capias.
The capias is because they filed new charges. It's not because he failed to appear.
Your Honor, I will request a reset. I don't think PD is
Well, let me
requesting
just
at
see
this
what
time.
I
If
was
Your Honor
just
wants to
handed.
get more information.
18-112-133. Does he have one case or does he have 2? Oh, okay. So I'm looking at one case now. Can I see the paperwork on? So now the issue is I don't know if this paperwork goes with these files. So you know what? I'm not, someone's gonna have to organize this paperwork. It's just not really my forte. I'm kind of bad at putting the right paperwork with the right files. We'll call him back tomorrow. Okay?
Okay.
The court, Guadalupe Puebla, the court finds no probable cause for kidnapping or false imprisonment, will allow the state 24 hours to provide probable cause for that. The court finds no probable cause for robbery, will allow the state 24 hours to find probable cause for that. The court finds probable cause for battery, orders a bond of $500. The court finds probable cause for resisting an officer, bond is set at $500. The court does find probable cause for disorderly conduct, bond is set at $100. The court finds probable cause for petty theft, bond is set at $100. The court further orders no contact with the victim in this case and no return to the location where this incident occurred, which does not appear that it's hard for me to determine if it occurred at a residence since looks like a lot of the physical altercation occurred sort of in the street. State, you have to tell me if I should order no return to the residence.
Yeah, I would. No.
Your Honor, do you want me to make the probable cause argument at this time? Or just as
Well, I don't know, because there's some people standing there. I don't know if you've had an opportunity to discuss with
I have not had an
them.
opportunity to speak with them.
All right, well, however you feel like you need to do it, if you feel like I could benefit from witness testimony, by all means, I'll hear from witnesses. If you just want to make legal argument, that's fine too.
Your Honor, as to the Kidnap charge, state would concede that there was not a kidnap, but however, as to the false imprisonment, state would argue that there was false imprisonment based on the report indicating that the defendant did block in the vehicle and block that vehicle from leaving.
Defense?
Is the argument that the accused blocked a car with her body?
No.
I would say that's not sufficient for false imprisonment. A person can't possibly stop a car.
It says that Guadalupe
It was a
used
car.
her vehicle to
Yeah.
block the other vehicle. So it's a vehicle blocking a vehicle, not a body blocking a vehicle.
And then multiple bodies outside of the vehicle, as the vehicle was blocking the other vehicle.
I'll defer to the clerk.
I'll find probable cause and, I'll order the bond of $1,000. Is that it? As to probable cause?
For the count one, Your Honor, as to count two, just trying to go down to the narrative. It indicates that the defendant was fighting with the victims, and at that time, one of the victims dropped their wallet, and the defendant did pick it up during the time of the altercation, so state would argue that that does qualify as robbery with no firearm or weapon. There was force being used when property was taken from the victim.
The court declines to find probable cause for robbery. And if that is it, then the court at this time finds there is no probable cause for the robbery. And you're not asking for additional time to find more information, then I will
Yes, ma'am.
I will just find no probable cause as to that.
If Your Honor would allow, I would request additional time if we can perhaps obtain more information from the officer.
All right,
as to
you
that.
can get 24 hours on that.
The
Count
defense
two.
would object that it's not something that can be cured, just for the record.
She
There's a
can
witness
cure it
present.
if she can get more information. So 24 hours, ma'am. And while these folks have been standing there so patiently, neither side is asked to inquire of them, and I don't intend to inquire of them if you all don't need to inquire of them.
Generally, I guess, may I inquire?
Yes, either side. I mean, they
yeah.
I mean, I've invited the state to inquire, but the state, I don't know, do you wish to inquire?
I did want to inquire just as to the residents and if there would be no return.
Okay,
necessary.
go ahead.
Can you,
Yeah, no return.
they're indicating no return. I'm not.
I'm sorry, but that,
I don't know if they've been sworn or stated their name for the record.
I need testimony. I can't, whatever just happened is not enough for me.
No, I know, Your Honor. I was just wondering, I didn't know if they had introduced themselves or put their name on the record or been sworn.
If
I
you
don't
wish
know
to
if that
inquire
happened
of them,
beforehand.
then,
Madam
just,
Clerk?
Raise your right hand, please. Do you swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Please state your name for the record.
My name is Aurelia Marie Escobedo.
If you're going to speak to the court, you're going to have to speak into the microphone.
My name
Otherwise,
is-
I cannot hear you.
Sorry, my name is Aurelia Marie Escobedo.
Name is Pablo.
Stay at the microphone. Okay, then ask her any questions you'd like to ask.
You were indicating, well, I'm sorry, you indicated that your name is Aurelia, so you are one of the victims in this case, is that correct?
Yes, ma'am.
And did this incident happen at your residence?
It was not at the residence, but we did live with her, with the defendant.
So you do live together?
We did, but she just recently had tried to kick us out.
So I'm sorry, I'm unclear. Are you currently living in the same residence, the defendant and you?
Not at the moment, because prior to the altercation, she had been trying to kick us out, but it's not even really her home.
So where this incident occurred, is that where you live?
No, not where it occurred at.
Okay. So, Your Honor, based on that, state would just request that they maintain separate residence?
What about the other witness?
As to this victim, Your Honor.
Okay. Well, let me just hear from all witnesses
Yes,
before
Your
I
Honor.
make a final
If
decision.
you could you introduce yourself, please, and state your name?
Pablo Puebla.
And you're also a listed victim in this case, is that correct?
Yes, ma'am.
Do you reside at the same residence as the defendant?
I do.
And is that where this incident occurred?
No, it's not.
Okay. Again, Your Honor, state would request separate residence for the defendant. Do the two of you live together?
Yes.
Okay.
Well, I'm even more confused than I was, because the female witness said that she does not reside.
They say they
but
don't reside
The
together.
male witness said that they do reside together, and I'm just even more.
The same day she tried to kick us out, or she tried to kick us out, but it's not her home to kick us out, so we're still battling to try to
Well,
get our
maybe,
stuff.
maybe if you help me by answering this question. Do you have a place where you reside right now? That is
no,
a
I'm
different.
actually on the street right now,
You're
no.
not listening. You're not letting me finish. Do you have a place where you reside right now that is a different location than where the defendant would reside if the defendant is released?
Yeah,
You do?
we're homeless.
Okay. All right. So in other words, you'll take care of your residence and she can go back to her residence. Is that what you're saying?
Well, she does have mail that she's trying
I
to
can't hear
withhold
you
at
if
her
you're not
residence.
talking into the microphone.
Go ahead.
She does, I mean, it is our home. We're that's our address. I don't know how, I mean,
Well, I don't really know. I mean, you all are asking me to
Can I
enter
inquire
orders
one more
based
time, Your Honor?
on what
May I
you
inquire?
don't know. Do you have any questions for these people?
No, I don't have any questions for them. I was just, actually, no, I do have one question. This incident, did this occur at the residence that either she lives at or you live at?
no.
Where, okay, that's all I wanted to know.
All right, well, I can best make the right order based on the quality of the testimony I receive. And I'm not going to restrict someone from going to their own home if the other people don't have a greater right to be there. So it's either you figure that out so they can answer the questions
If
and,
I can inquire one more time, Your Honor, I'm just
Okay.
going to use the address to see if I can clarify the testimony.
go ahead, Ms. Merced.
The address that I have listed here is 419 South Central Avenue. Is that where either of you are currently living?
No. That's my job. That's my workplace.
Okay, so this happened at your workplace?
Yes, ma'am.
Okay, thank you. And just to confirm what was previously stated on the record, you are not currently, either of you, living with the defendant, is that correct?
No.
Okay.
All right, I think that's it. That's all I need. All right, the court orders no return to the location where this incident occurred. I think I've already addressed the bonds.
Yes, Your Honor.
The court further orders no contact with the victims in this case and maintain separate residences.
Can you put those names on the record so she knows who exactly not to have contact with?
Or Aurelia Escobedo. No contact with Aurelia Escobedo. No contact with Pablo Puebla. Pablo Puebla.
Thank you.
24 hours. Johnny Walters III.
Yes, Your Honor.
Sir, the court has reviewed your file and finds probable cause for aggravated battery on a pregnant individual, and bond will be set in that case at $2,500. The court finds probable cause for grand theft third degree, bond is set at $500, and grand theft third degree motor vehicle, bond is set at $500, and grand theft third degree bond is set at $150. The court is ordering you have no contact with the victim whatsoever, not return to the location where this incident occurred, with the exception of that you can return to the victim's residence one time to retrieve any personal belongings that may be present.
There's a witness present. May I inquire? After she's sworn in?
Does the state wish to inquire of the person who's present?
Not at this time, Your Honor.
All right, then yes, you may inquire.
Could you please state your name for the record?
Jamila Torbett.
And, Ms. DeVorley, what is your relationship to Mr. Walters?
My boyfriend for 7 years.
Are you the alleged victim in this case?
Are we together?
Are you the alleged victim in this case?
Supposedly, yeah.
Yes.
Ma'am, I need you to speak into the microphone
I'm
or I
sorry.
cannot hear you.
Yes,
Okay.
supposedly.
Would you like contact with Mr.
Yes,
Walters?
ma'am.
Are you afraid of Mr. Walters?
No, not at all.
Would you like Mr. Walters to return home?
Yes, ma'am. Because he helped, sorry.
No,
He-
go ahead.
I'm epileptic and we have a sick kid. He does majority of the help with the kids. So what's going on is a complete misunderstanding.
Okay.
So I do need him home because he's the caregiver and he helps me because of my medical condition and the kids. So,
I have nothing further. I'm ready for argument, but I'll let the state inquire if they need.
Ms. Merced?
Yes, Your Honor, I would like to inquire. Have there been any prior incidents between yourself and
No,
the
ma'am.
defendant? Has law enforcement ever been called out?
no, ma'am.
Were there any minors present when this took place?
My daughter, she was 2, but she was asleep.
Nothing further, Your Honor.
All right, any objection to no return as opposed to, no hostile contact as opposed to no contact whatsoever?
They would still object to no hostile contact and would request no contact based on the fact that a minor was present. And I'm currently looking at history, and I believe, I'm just trying to double check a date of birth because I do have another incident.
Another incident with this very
That's
same
what I'm trying to
individual?
confirm, whether it was the same victim.
Can that be confirmed by anyone?
And I'm sorry, you're Jamila George, is that correct?
Jamila, yeah.
Yes, Your Honor. I do have a prior incident that took place, according to the notes that I have here, back in 2015 with the same victim. I understand that this was eventually dropped, but when I inquired of the victim whether law enforcement has ever been called out, she did indicate no, so state would be concerned that there may be a fear factor present.
The court, it does seem to be confirmed from the record that there was prior contact with the, contact with the victim as a victim in a separate case, so consequently, the court is going to order no contact.
Defense is objecting, given the victim's testimony.
Your objections noted. No contact, with the exception of one time returning to retrieve personal belongings. Other than that, no return. No possession of firearms or weapons.
Thank you.
Wendy Barthelis. Wendy Barthelis.
Yes, Your Honor.
The court finds probable cause for violation of a domestic violence injunction. Orders bond at $1,000. The court orders no contact with the victim in this case whatsoever. Possession of no weapons or firearms as a condition of bond in this case. The court appoints a public defender to represent you. Thank you.
Thank you.
Brennan Edward Scott. The court finds probable cause for battery. Domestic violence, and orders bond at $500. No contact with the victim, no return to the location where this occurred, with the exception of a one-time return to retrieve any personal belongings if necessary. Public defender is appointed. Marcia Franchilon Drake.
I'm sorry, was the bond $1,000 on that?
Madam Clerk.
Thank you.
State.
Yes, Your Honor.
The court is,
Maricia Fronts to Leon Drake.
thank you.
You're
The
welcome.
court is, unable to find probable cause for battery. Oh, I'm sorry. It's assault,
assault,
sorry.
yes, Your Honor.
The court does find probable cause for assault and, orders a bond of $500. No order, as a condition of the bond, the court orders no contact with the victim and no return to the location where this incident occurred, with the exception of a one-time return to retrieve any personal belongings that may be present. Thank you.
Thank you so much.
Justin Harrington. The court finds probable cause for battery, domestic violence, orders bond at $500, no return to the location where this happened, no contact with the victim. You are allowed one time in the presence of law enforcement to retrieve any personal belongings.
Public defender appointed.
Yes, ma'am.
Thank you, Your Honor.
Rainey Alexandria Holly. All right, the court finds probable cause for battery, domestic violence, and orders bond of $500. And, sir, what's your name?
Joshua Walker.
Let's swear him in.
Do you swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes.
Do you want to talk to Mr. Walker, Ms. Merced?
Not at this time, Your Honor.
Would you like to speak with Mr. Walker?
Yes, Your Honor. Are you the alleged victim in this case?
I can't hear you.
Are you the alleged victim in this case?
Yes, ma'am.
Would you like to have contact with Miss Holly?
Yes, ma'am.
Are you afraid of Miss Holly?
No, ma'am.
Would you like Miss Holly to return home?
Yes, ma'am.
I have no further questions. Given the alleged victim's testimony, I'd ask for no hostile contact and that they be allowed to reside in the same residence.
All right, the court is inclined to grant that. Does the state have any objection?
Your Honor, if I just may ask one question.
Go ahead.
Were any minors present when this incident took place?
Not in the immediate room, no. It was in like a back room. They didn't see anything.
Have there ever been any prior incidents between yourself and the defendant?
No, ma'am.
Has law enforcement ever been called out?
No, ma'am.
Your Honor, at this time, state would still request no contact, but leave it to Your Honor's discretion.
The court will order no hostile contact. The parties may remain in the same home together, but no hostile contact, ma'am. Okay. Jeffrey Lewis,
I didn't hear what you said.
$500.
That was it. Yep.
Jeffrey Lewis. All right, Mr. Lewis, the court finds probable cause for battery, domestic violence, and orders a bond of $500, as well as no contact with the victim, no return to the location where this incident occurred, with the exception of a one-time visit in the presence of law enforcement to retrieve personal belongings if needed. Jeremy Ramirez. State. And the court is unable to find probable cause at this time. for violation of a domestic violence injunction. There is a reference made to an injunction. The court needs verification of the injunction.
It does say in the report, Your Honor, that the officer verified the injunction, but Your Honor is requesting a copy of it.
Well, I'm requesting verification. Is this an Orange County case number 2019 DR 2683?
I believe that's the number of the injunction, and it indicates that it was issued in Pasco County.
All right, well, I need verification.
I can pull it up on the Pasco County.
Oh, you can?
Clerk of court, I would imagine. Well, actually, no, I'm sorry, Your Honor, I wouldn't have access to their injunction files. I don't see how I could get a copy of the Pasco County injunction.
Well,
prior
how
to
did the
that.
officer get it?
The officer did indicate in his report that he verified the injunction via teletype, but you still want me to get a copy of
So
it
if he
from him?
verified it via teletype, then why can't I see it?
Okay, Your Honor, I will request that they provide us with a copy.
All right, yes, I just need to verify it. I guess if it's via teletype, it's fine. It needs to be attached.
Yes, Your Honor.
All right, you want 24 hours?
Oh, yes, please, Your Honor, maybe
All right.
reset.
The court will allow 24 hours for you to obtain that. Alexander Junior Santiago. The court finds probable cause in this case for battery domestic violence, and will order a bond of $500. Further, I will hear from the, ma'am, what is your name?
Dalianis Bonilla.
All right, from Ms. Bonilla. Let's swear her in.
Raise your right hand, please. Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes.
All right, Ms. Merced, would you like to inquire of Ms. Bonilla?
Not at this time, Your Honor.
All right, how about you, Ms. Daly?
Ms. Bonilla, are you the alleged victim in this case?
I can.
I'm sorry, are you the alleged victim in this case?
Yes.
Would you like contact with Mr. Santiago?
Yes.
Are you afraid of Mr. Santiago? Would you like Mr. Santiago to return home and reside with you?
Yeah.
Well, I need to hear what you're saying.
Yes.
Okay.
Is there any question you'd like
Ma'am,
me
are
to?
you afraid of Mr. Santiago?
I'm sorry, what?
Are you afraid of Mr. Santiago?
No.
Given the alleged victim's testimony, I'd request that there's no hostile contact and they'd be allowed to maintain the same residence. Additionally, Mr. Santiago has 0 criminal history and would qualify for PTR if they were able to live together.
Ms. Merced.
Isn't that what it
If
says?
I just- I'm sorry?
Okay, never mind. Go ahead.
I'm sorry, I didn't hear what the PTR officer said.
I was saying that he should qualify for
I didn't hear what-
PTR
I heard
if they
what you
could
said, I
live
didn't hear
together.
what she said. What did you say?
Interview, he provided conflicting information to the officer, came back and provided another information, called her on the phone, and then came back and provided for different information so that they sort of would connect. So for that reason, him providing conflicting information, she disqualifies him for it.
Well, he
She's
has no-
disqualified from,
He is disqualified from pretrial.
Even though he has
Okay.
no criminal history?
Correct.
Not even an arrest?
Correct.
Okay.
all right, well, we're just going to go ahead on and let Ms. Merced inquire.
I'm sorry, were there any minors present when this took place?
No.
Okay, and have there
Is that a yes or a no?
No.
have there been any prior incidents between yourself and the defendant?
No.
Has law enforcement ever been called out?
No.
If this type of incident were to happen again, would you call 911?
It was a misunderstanding.
Ma'am, are you over the age of 18?
Yes.
All right.
Your Honor, based on the victim's testimony, it doesn't appear that she would call 911, and based on the statements from PTR that there may have been conflicting information given initially, state would object to the no hostile contact and request no contact and separate residence.
The court will decline to do that at this time based on her testimony. Let me just confirm. You said you're not afraid of him.
No.
All right, and you do want him in
Yes.
the residence with you. The court will allow no hostile contact with her, sir. You know what that means? Yes? All right. The court will allow the bond of $500 declining to allow PTR at this time. All right, thank you, ma'am. Thank you, sir. All right, Jason Allen?
Yes, ma'am.
All right, sir. All right, the court does find probable cause for failure to report vacating a residence within 48 hours, which is a sex offender violation. You have a recommended bond on this, Ms. Prosecutor?
State would request no bond, Your Honor.
Your Honor, it's not a punishable by life or capital offense. He's entitled to a reasonable monetary bond.
All right, let me see. All right, the court is finding that he is entitled to a bond. The court will set a bond. Does the state have a recommendation as to the amount of the bond?
No, Your Honor, we leave it to Your Honor's discretion.
All right, the court will set the bond at $5,000.
Thank you.
Michael Bell. Sir, the court finds probable cause for count 1 burglary of a structure. Bond remains at $3,500, and count 2 burglary of a conveyance. Bond is $150. The court is also ordering that you not return to the location of this incident as a condition of bond and have no contact with the victim owners of the property. Thank you. Edward Black.
How are you, Your Honor?
Thank you, sir. Sir, the court finds probable cause for possession of cocaine. Bond remains set at $1,000. Thank you, sir.
Thank you, ma'am.
Johnny Bryant. I guess this is one of the ones where I guess I will need that driving record. Otherwise, I'm not able to find probable cause on count 3.
For
I'm
Johnny
thinking.
Bryant?
Yes.
Did you say count 3 or count 2, Your
Count
Honor?
2, I'm sorry.
Okay.
Count
Your
2.
Honor, you can only consider what's inside the 4 corners of the affidavit for probable cause.
Really?
Yes.
Wow. I'm gonna look at this driving record.
Okay.
All right, as to count one, fleeing and attempting to elude a police officer, the court finds probable cause. Bond is set at $7,500. As to count two, driving while your license suspended with 2 prior convictions, the court is unable to find probable cause of 2 prior convictions. As to, but the court can find probable cause for driving while license suspended if the state wishes for me to do that.
Your Honor, state would request a reset so we can try to obtain the
All
driving
right, the
record.
court will reschedule in 24 hours as to count 2. As to count 3, the court finds probable cause for possession of cannabis. Bond remains at $100. And resisting an officer without violence, the court finds probable cause. Bond also remains at $100. And the court does appoint the public defender. Denzel Butler. Mr. Butler, so you were picked up for failure to appear, and the court bond will remain at 0 bond. As to that, you will also have a charge of fleeing and attempting to elude, resisting an officer, and criminal mischief. Give me just one moment on those charges. All right, as to fleeing and attempting to elude, the court finds probable cause, and the court will order a bond of $7,500. The court finds probable cause for resisting an officer. Bond is set at $100. And criminal mischief, the court finds probable cause. Bond is set at ROR.
I don't know. You'll find out.
One moment. As to Mr. Butler, one moment. These are all failure to appear. All right. Mr. Butler? I already addressed one of them, and I see 2 left. Sir, you did have 2 additional failure to appear cases, and the court is ordering bond to remain at no bond on those 2 additional cases. Brady, Jerome Carroll, the court is unable to find probable cause for possession of cannabis with intent to sell or deliver. The court does find probable cause of possession of cannabis, and bond is set at remains at $100 for possession of cannabis. State you want 24 hours on the count 1?
Yes, please, Your Honor.
All right. And the court will, at this time, take no action in the case 2019 CF 2299. However, the court would like for this to be brought back for the court to reconsider upon finding of probable cause on count 1. Angel Corsino. All right, the court finds probable cause as to possession of methamphetamine, and bond is set at $1,000. The court finds no probable cause for possession of cannabis. Bond is set at ROR. And, sir, there's also a failure to appear, and bond will remain set at no bond on the failure to appear. Eric Nicholas Della Barbara.
He bonded, Your Honor.
Okay. Clifton Josiah Dixon. Sir, the court finds probable cause for possession of a concealed firearm. Bond remains at $2,500. And possession of cannabis, bond is $100. Resisting an officer without violence, bond is $100. As a condition of bond, you're ordered to possess no firearms or weapons. Rockland Ellis. Miss Prosecutor,
Yes, Your Honor.
what are nerd rope marijuana edibles?
My understanding is that like the nerd candies are little small dots, and so apparently they're on a strip that has the marijuana in them.
Oh, okay. So it's that what, and along with the gummies, what is being referred to as the controlled substance?
There was also the nerd rope was marijuana. The nerd refused gummy edibles were also marijuana, and then there were
Some cigars, pre-rolled cigars. I don't see anything other than marijuana.
I apologize, Your Honor. If I could just have a moment, I thought there was something else on this one. I maybe.
Well, wait. What is this THC vial?
Oh, that's it. Yeah, I believe that would be it then, Your Honor. But there are two. There's a Rhino 90% THC vial.
The court finds probable cause for possession of a controlled substance, and bond will remain set at $1,000. The court finds probable cause for possession of cannabis greater than 20 grams. Bond is set at $500. Armed possession of cannabis, bond is set at $7,500.
Your Honor, Mr. Ellis qualifies for pretrial release. We ask him to be released on pretrial release.
That's denied. All right, Stephen Etienne.
Yes, ma'am.
Sir, the court finds probable cause for driving on a License while suspended with 2 prior convictions. Bond remains set at $2,500. Further, the court will revoke the bond in case number 2019 CF 4367, letter AO, and bond is set at 0, none. Revoke ROR. Michael Gargano. Sir, you were picked up for failure to appear. Bond remains set at no bond. Sorry, Mr. Joseph Finn, Joseph Finn. Sir, you were picked up for failure to appear. 2 counts. Bond remains set at no bond on both counts.
Not guilty.
Thank you, sir. I will do so. Tanel Giles.
Are we done with Mr. Gargano?
Yes, we're done. I'm sorry. I shouldn't have called him
I'm sorry,
back.
Your Honor. Was that Mr. Finn?
That was Mr. Finn.
It was Mr. Gargano, then it was Mr. Finn.
Oh, okay, I apologize. I had him in reverse.
Mr.
order.
Tanel Giles.
Yes, ma'am.
Ms. Prosecutor, is this a charge of possession of, I'm sorry, there's a page 2. My mistake. All right, sir, the court does find probable cause for possession of MDMA, ecstasy, and the court further revokes the ROR. And actually, bond remains set at $1,000. The court revokes ROR in case number 2019 CF 6896 AO and 2019 CF 6880 AO. Revokes ROR, bond is set at no bond, both cases. Becky Goodwin.
She bonded, Your Honor.
Thank you. Christopher Harris.
Yes, ma'am.
Court finds probable cause for count 1, possession of methamphetamine, bond is set at $1,000, and count 2, resisting an officer without violence, bond is set at $100. Further, the court will revoke the ROR status on case number 2017 CF 3489 out of Osceola County. Bond is set at no bond. The court revokes the bond on 2016 CF 2769, and bond is set at no bond. Donnelly Harvey.
Yes, ma'am.
Sorry. Sir, ma'am, the court finds probable cause for petty theft, subsequent offense, and bond is, court will set bond at $1,000. The court will take no action as to the 2019 CF 6241 case. Thank you, ma'am. Santiago Jackson. Sir, the court finds probable cause as to count one introduction of contraband into a facility, and bond is set at 1,000, and possession of cocaine, bond is set at 150. Oh, sorry, one moment, hold on, I have a second case. Sir, you have a out-of-county warrant where bond was ordered at no bond. Bond will remain at no bond in that case. Lorenzo Jackson.
Lorenzo Johnson is behavior, Your Honor.
Oh, sorry, Johnson. All right, we call Mr. Johnson in the morning.
Is that, so Lorenzo Johnson we're resetting?
Lorenzo.
Okay.
Reginald Johnson.
He bonded, Your Honor.
Reginald bonded. Regina Jones. Ma'am, the court finds probable cause for trafficking meth MDMA. Bond remains set at $50,000. Trafficking cocaine, bond is set at $50,000. Possession of cannabis, bond is set at $100. And possession of paraphernalia, bond is set at $100.
Would Your Honor be inclined to reduce one of the $50,000 bonds,
Any objection?
since one's already set at $50,000?
Madam Prosecutor, to reduction of trafficking of cocaine?
No objection, Your Honor.
The court will reduce that bond to $5,000. Count two. Mark Jordan. Is that who you are?
Yes, ma'am.
Well, destruction of evidence. $1,000 bond for throwing a little bit of beer. State is what's going on with this case?
I mean, technically.
Why is it not just an open container case?
I'm unsure, Your Honor. Technically, it does qualify, however, if
Well, I don't really know what to do with this case. I don't have any experience with this particular charge. I'm kind of reluctant to order $1,000 bond on what it looks very closely resembling an open container case. But I'll go through my bond schedule if I must, or I could just order a $250 bond. Is this a felony?
Destruction of evidence is a felony, Your Honor.
State, do you have any objection to the court ordering a $250 bond in this case?
Your Honor, State would leave it at Your Honor's discretion.
I'll order a $250 bond.
And it's to do with the container.
No, I'm still sticking with the destruction of evidence.
Sorry.
I just reduced the bond. I guess technically that's what it is. Dante Lewis,
Your Honor, what was the bond on the alcohol, the open container?
there was no open container. No, ROR.
Thank you.
If there is a case, it's ROR.
Thank you.
And if there is no case, then it's probably subsumed in the destruction of evidence case. Madam Prosecutor, did you show another case?
I did not, Your Honor.
Oh, I had it as both.
I don't think there's another case. But if there is, if it's for open container, ROR.
Thank you.
Mr. Lewis,
Good afternoon, Your Honor.
good afternoon. Sir, the court finds probable cause as to trafficking in oxycodone. Bond is set at $50,000. Resisting an officer, bond is set at 100. No, I didn't see that. No, I did not. I just overlooked it. The court is noting that there was updated information as to the bond. For trafficking, bond is set at $100,000 rather than $50,000. The court will order bond of $100 on the resisting offense and $100 on the possession of cannabis offense.
Your Honor, my client wants me to ask you if you'd be inclined to reduce the $100,000 bond to $50,000 or
No,
less.
No, sir, not at this time, no. Michael Logan. Sir, the court finds probable cause for grand theft third degree. Bond remains set at $500 in that case. The court will take no action as to the 2019 MM 123 case. Junior Lewis.
Yes, good afternoon.
Good afternoon. You were picked up for failure to appear, and bond will remain at no bond on both counts of your failure to appear charge.
Yes, but I had called that day I was supposed to go to court. My car was giving me trouble, and I called at 9:10. I was supposed to be in court at 9 a.m., and they said they were sending the message to the courtroom, and I called.
Did you have a public defender on that charge, sir?
No, I didn't.
Unfortunately, there's nothing I can do at this time. You do now have the public defender, and the public defender is able to file a motion and bring it to the judge's attention that you had a legitimate excuse and that you were trying to get to court on time. So the lawyer will help you with that.
Okay.
Thank you. Marlene? Yes. Midle? Ma'am, the court finds probable cause for grand theft, motor vehicle. Bond is set at $1,000, and resisting an officer, bond is set at $100. The court will revoke the bond As to 2019 MM 209, bond is, that's an open case. There was no bond on that case?
May I be heard on that? She was found incompetent to proceed in both of those case numbers, so she's not out on bond. She's on conditional release.
Oh, okay. Well, the
No
court will
action.
take no action as to neither 2019 MM1, I'm not sure if that's a 6 or a 0, but 1618 or 1018, and 2019 MM209. Both of those are open cases that do not have a bond or a release status on them. Anthony Morton. The court finds probable cause for count 1, sale or delivery of cocaine. Bond is set at 150, and count 2, delivery of a controlled substance within 1,000 feet of a convenience. And bond is set at $10,000.
Excuse me, can I say something?
The defense has a probable cause challenge when you're ready.
I beg your pardon?
I said I have a probable cause challenge when you're ready.
As to Alicia Pryor?
Yes.
All right. All right, the court finds probable cause, Ms. Pryor, to resisting an officer without violence. Bond will be set at $500. The court finds probable cause for driving with a suspended license as a habitual offender. Bond is set at $2,500. What says the defense as to challenge to the probable
We
cause?
would be challenging count 1 to resisting an officer without violence. The affidavit merely just tracks the language of the statute. There's no factual basis for how she actually resisted and what legal duty the officer was executing.
Well, the court disagrees. The court finds probable cause based on the facts that the court reads in paragraph 2.
She qualifies for
Unless the state disagrees. Do you think that that is
No, Your Honor,
is
state, we agree with Your
insufficient?
Honor.
All right, so I think that's sufficient probable cause. Now, we're not trying to make a determination of if it's beyond a reasonable doubt, but it's probable cause.
Yes,
And
Your
you were asking,
She qualifies for straight pretrial release. We ask that she be released on pretrial release if the court's inclined.
how can she qualify for straight pretrial release with this driving while license suspended record? But I guess if she does, she does. What does the pretrial release people say? All right, well, any objection to granting her PTR?
State would leave it to Your Honor's
I'll
discretion.
grant PTR. Ma'am, you're going to be granted PTR on your cases rather than the bonds. You just need to well, you already qualify. They've already assessed you. All right. Another stack. Is this part of the stack already read? Okay, yeah. Yeah, I see mine. Okay. And then, once we get to that, is the, okay. And that's what I already read. Okay, good. Start going fast again. All right, Sammy Ramirez, sir, the court finds probable cause for attempted burglary of a conveyance. Bond is set at $1,000, and probable cause for resisting an officer without violence. Bond is set at $100. Further, the court will, the bond that was previously ordered in 2019 CF 6662, the court will revoke the bond, and bond is set at no bond.
May I be heard on that case?
The bond that was previously ordered in 2019 CF 5707, the court will revoke the bond, and bond is set at no bond on both counts. In the case 2019 CF 5771, the court will revoke the bond, and bond is set at 0 bond on both counts. And yes, ma'am, you may be heard.
Yes, on all of those case numbers that the court has just listed, no information has been filed as to the 19 CF 5707. The arrest date was 4/23, so it's been over 33 days. As to,
Wait a minute, which one? For?
the first one, 5707.
Okay, that's my second one.
I'm sorry, I have a.
So 5707 has been over 33 days?
Yes.
Okay, what about the 6662?
So that was a warrant case, and the warrant was issued on May 13th, but the offense date was April 22nd.
Well, the warrant was not issued until May 13th, though. So the court, as to the 5707, the court will take no action as to that case, but I'm still revoking the bond in the other case. There's a third case, 5711. What's the status on that one?
No information's been filed. The arrest date on that case was 4/23.
But the bondsman did come off that case, so she didn't know that jail on it.
The bondsman came off the one? Okay. So there's no bond on that one anyway, ma'am.
So would he be able to post bond then?
Current bonds are set at 1,100.
So we would stay at that then?
Well, I thought you said he came off the bond.
Came off of it, which means he's being held on that with the original bonds at 1,100.
Okay. Well, back to the 33 days. Has it been more than 33 days or not?
The arrest date was 4/23.
All right, then the court will take no action as to that one. So, all right. I think that covers every one of his cases. Irvin Richardson. The court finds probable cause, Mr. Richardson, for aggravated assault with the weapon. and bond remains set at $2,500. The court finds probable cause for grand theft. Bond is set at $150. The court is ordering that you have no contact with the victim whatsoever in this case, that you possess no firearms or weapon as a condition of the bond, and that you not I think that's it. No contact with the victim.
There's another case, Your Honor.
There's another case? No, this is, oh, it has two defendants, okay.
It's a warrant case.
Irvin Richardson is to, maybe it's a warrant case, but I still think I have to read it. All right, sir. Further, the court finds that you were picked up on a warrant for which the court does find probable cause for burglary of a dwelling, which bond will remain set at $7,500. Grand theft bond is set at $150, remains set at $150. Dealing in stolen property bond remains at $150. Receiving money from the pawnbroker with false ID bond remains set at $150, and violations of the Florida Pawnbroker Act bond remains set at $150.
Mr. Richardson would like me to ask you if you would reduce the bond on one of the higher counts, since there are so many.
The court is disinclined to reduce the bond at this time. But thank you. John Doe. John Doe.
No, every spirit.
It's an AKA, Your Honor. I saw it on the clerk's website when I looked up this case.
Well, I don't know the other name. All I have is the John Doe.
What's the booking number?
This one.
That's spirit, right? Well, that's spirit right now.
John Doe is the gentleman standing next to me.
Okay, well, let me just read through here, and
No,
maybe
every
I
spirit.
can get another name.
Why you call me John Doe?
All of a sudden I feel sick. Oh, Avery Spirit, AKA John Doe.
No.
Yeah, I'm gonna have to take a break. I'll do these two, and then I'm gonna take a break after. I'll do this section separately. I think I can make it. All right, the court finds probable cause for cruelty to animals, and bond will remain set at $2,000. And obstructing or opposing a police officer, the court will set bond at $150.
That's it?
Martelly St. Victor. Is that who you are? Marcellus St. Victor?
Jean Roberto Montelli St. Victor.
Okay, thank you. The court finds probable cause for sale or delivery of methamphetamine. Bond remains set at $15,000. Further, the court will revoke the bond that was previously set in 2019 CF 5276. Bond was set in that for a total of $1,450. Bond is revoked and set at no bond on
May
all
I-
4 counts.
Sorry. Your Honor, may I be heard?
Yes, ma'am.
First, I would like to challenge probable cause on the sale and delivery of meth. In the 4 corners of the arrest affidavit, there is no mention that it is actually meth because it was not tested positive for meth. It just says he confirmed it was meth. Doesn't say how. Generally, we're supposed to test it and to prove that it actually is methamphetamine.
Madam Prosecutor?
Your Honor, State would request a reset so that we may obtain a supplemental report.
Okay, the court will decline to find probable cause at this time and will allow 24 hours for the state to provide additional information.
And for the out on bond case, no.
Yeah, I will, the court reverses the order to revoke the bond pending the outcome of the state's investigation and providing the court with additional details. Brandon Walker.
He bonded, Your Honor.
Thank you. And the court's going to take a recess. Who are these 2 people?
Those are 2 of my traffic cases.
All right, Vern? Or one of
He
you-
bonded, Your Honor.
He bonded, okay, Vern. Mohammed Fayaz? But is that who that is?
No, this is South.
Okay, well then,
He must have bonded, Your Honor. I don't have that one either.
Golam Mohammed? Is that who you are?
1901-6665.
Well, who are you?
Jalen South.
Who?
Jalen South.
Okay, Jalen South. Mr. South? Jalen South.
Yes.
The court finds probable cause for attaching a tag that was not assigned to your vehicle and bond remains set at $250.
Your Honor, he has no criminal history and he qualifies for straight pretrial release. Would the court be inclined?
Yes, ma'am. PTR in lieu of bond. Don't bring anybody else in, please. Tobias Watts, is that who you are? The court, so you were picked up for failure to appear. Bond will remain set at $500 on your FTA. Thank you, sir. Court's going to take a recess. How do I turn this off? All mute. We're back on the record. Ready to proceed? I guess you can recycle that. I don't need it.
Are we starting with Gentry?
Ada Carrasquillo. Reset. Carolyn Gentry. Reset. She refused. Tomorrow. Reset tomorrow. All right, Ms. Gentry, the court finds probable cause for petty theft. Bond will remain set at $250.
Ms. Gentry has indicated to me that she would like to resolve her case.
What says the state?
There's no offer at this time, Your Honor.
No offer at this time.
They won't give you one if she.
Antonio Hopkins. Court finds probable cause for petty theft. Second offense, bond remains set at $500, and for resisting an officer, bond. Oh, actually, the court did not find probable cause for resisting. The court had a question about that probable cause. State, did I miss something?
Your Honor, state would request a reset so that we can obtain a supplemental report.
Right. The court does find probable cause for the petty theft, and based on that, the court will revoke the PTR and/or the bond in that case, 2019 CF 6576, letter AO, and bond will be set at no bond in that case. The court will reschedule for 24 hours for the state to provide probable cause as to count 2, resisting an officer without violence. Tyler McFarland.
What I mean?
Tyler McFarland. Is that who you are?
Yes, ma'am.
The court finds probable cause for possession of cannabis. Bond is set at $100. Possession of paraphernalia. Bond is set at $500.
I'm sorry, Your Honor, would you please repeat those again?
Possession of cannabis, count 1. Bond is $100. Count 2. Bond is $500.
Your Honor, he has no criminal history, and it's the state's non-monetary bond policy to advocate for ROR in cases such as this.
No criminal history.
So what my PTR state says. Are we talking about Tyler McFarland? Or
Yes.
Yes.
State.
Yes, Your Honor, state would have no objection to ROR.
ROR.
Yes, Your Honor, this is just a possession of cannabis under 20 grams and a possession of drug paraphernalia with no criminal history, so the defendant would qualify for ROR under the state attorney's policy.
All right, the court will allow ROR as to both count 1 and count 2.
Thank you.
Perry Vincent Martin.
Yes, ma'am.
The court finds probable cause for possession of a prescription drug without a script. Bond is set at $500. Sean Reedy. The court finds probable cause for trespassing in a structure or a conveyance. Bond is set at $500. Richard Rivera.
Mr. Reedy wanted to know if he could resolve his case.
State.
No offer at this time, Your Honor.
No offer at this time. Richard Rivera. The court finds probable cause for criminal mischief. Bond is set at $500, and for possession of paraphernalia, bond is set at $150. Cody Lance. Cody Lance. Is there a Cody Lance present?
Oh, I have Lance Cody, sorry. Yes, that's who you're talking about.
Is that who you are?
Yes, ma'am.
Okay. Court finds probable cause, possession of and/or use of drug equipment. Bond is set at $500, and resisting an officer, bond is set at $100. The court will revoke ROR as to 2019 CF 523, and bond is set at $2,000. The court will revoke ROR as to 2019 CF 524 AO, and bond is set at $500 on each count for a total of $2,000. Oh, wait a minute. No, I didn't add that right. $500 on each count for a total of $2,500.
Your Honor, may I be heard on those out-of-bond cases?
Yes, ma'am.
No information has been filed in either of those cases, and the offense date for both of those was January 11th, 2019.
Okay. Yeah, I know where you're going with that. So the court's going to, actually, court will